Mr. Cammack, please raise your right hand. Good morning, Your Honor. Good morning. I do solemnly swear that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth, so help me God. I do, Judge. Please take your seat. And before you begin, I've always been asked by both sides, I meant to do this earlier, the time clock, presentation of the evidence, the House, 9 hours, 19 minutes, and 12 seconds left. 9, 19, and 12 seconds. Respondent, 12 hours, 14 minutes, and 15 seconds left. 12 hours, 14 minutes, and 15 seconds. You may begin.
Good morning. Fine. Is your microphone on, please, sir?
Can you hear me? Is that better?
That's better.
Okay, good morning.
All right, Mr. Cammack, obviously, but state your name for the record, please.
My name is Brandon Raymond Cammack.
And Mr. Cammack, how old are you?
37, sir.
And as we've gone through this, you're doing really well about leaning forward. The microphone, I think that microphone and this one requires to be pretty close. If you sometimes may call it to your attention, but if you can just sort of try to keep it in mind, that would be good.
Okay.
Now, what's your profession?
I'm a lawyer.
And can you take about a minute and a half, if you don't mind, to sort of give us a little bit of your background and experience, whatever got you to where you are now?
Sure. It all started I went to school at University of Houston for my undergrad. I went to University of Houston law school as well. Graduated in 2015. During my time at U of H, I interned for the Public Defender's Office in Harris County. I clerked for the 208th District Court in Harris County for Judge Denise Collins. When I graduated, I went out. My dad, Sam Cammack, is also a criminal defense lawyer. I got out and started working for him. I worked for him for about 3 years, and then went off on my own, and I've been on my own, I guess, for the last 5 years now. And then about last year or so, I partnered with Ben Friedman, who's my business partner. We have a criminal and a personal injury docket. I think I've personally, at this point in my career, handled close to 600 cases, probably tried 15 to 20 cases, somewhere in there. Handled appeals up at the Court of Appeals in Houston. I've argued at the Court of Criminal Appeals, and that's what I do. That's how I got here.
All right, fine. When you say you graduated from law school in 2015, and I believe you said you're 37?
That's correct.
So did you do something in between undergraduate and law school?
No, I didn't, sir. I just went straight into law school.
Okay. So when you graduated from law school in 2015, you were what age?
It's 29.
All right. So I'm still trying to fit back. Ordinarily, you'd be 25 if you went straight for college. Did you do something before college or so?
I went to school for 2 years, and then I started working for my grandfather, Sam Cammack Sr., Sam Cammack II, for his business. And then I just took a few years off, just focused on working and making a living, and then decided to go back to school at my dad's advice.
Gotcha. So your grandfather was in what kind of business?
He was a business owner. He did a variety of things throughout his life, but he was a commercial real estate developer and also owned a mortgage business. And so I worked with him over there.
How long did you work for him?
I was there, I'd say 2 to 3 years or so, and then decided to go back to school.
All right, now, as you're aware, the time frame we generally hear about are events in the year 2020. At that time, how long had you been a lawyer?
About 5 years.
Okay. And by the way, I think congratulations are due. Did you just recently get married?
I got married to my beautiful wife, Terry, on September 2nd,
So you have been married now how long?
A week and a half. We didn't get to do a honeymoon.
And is your wedding one thing that sort of set the time frame as to when you might be available as a witness in this case?
Yes, sir. That's why we didn't. I'm here, so we didn't get the honeymoon. We'll do that next year.
All right. Now, at the time that, let's say in the period of time of August of 2020, you'd been a lawyer about 5 years, is that right?
Yes, sir. That's correct.
Had you had any federal practice at that time?
I believe at that time I was licensed in the Southern District, but my practice was primarily in the county and district court, state court cases.
And was it at that time exclusively criminal?
Yes, sir. Exclusively criminal.
And you've added sort of a personal injury component to it since 2020?
That's correct.
All right. And in your criminal practice, had you ever been a prosecutor?
No, sir.
So had your experience been literally, exclusively, as you have described, doing criminal defense work?
That's correct.
So if you hadn't been a prosecutor, is it fair to assume that maybe you had never dealt with issuing grand jury subpoenas or dealing with a grand jury in the role of a prosecutor?
I had never issued grand jury subpoenas as a defense lawyer.
Okay. Now, you probably had prepared packets representing people for a grand jury, urging them that whatever your client's position was, correct?
Yes, sir. We've presented grand jury packets to the grand jury through the DA's office when we turn those over.
All right. Now, at the time, can you tell us when you first got involved in this case now? When did you first hear from someone, and whom was it?
It would actually be on my birthday of 2020, August 22nd. That's when I first knew about Mr. Paxton reaching out to me. I got a call from an unknown number on that day. I think I was out to lunch with some friends or something. And then later that evening, I got a call from a gentleman named Michael Wynn, who I knew through the Rotary Club, and said that Mr. Paxton had reached out to me.
Excuse me, I didn't mean to interrupt on you. Mr. Wynn, was Mr. Wynn already a friend of yours or an acquaintance? Would you describe, as of August of 2020, how would you describe your relationship with Mr. Wynn?
Just an acquaintance. I knew Michael. I've been heavily involved in the Rotary Club, which is a charitable organization. We have a downtown Rotary Club of Houston. I've been involved with charities for like the last 6 years, I think, and he became a member of that year. And then I had worked with Michael. He was a chair of the Houston Bar Association. I was a member, and he had reached out to me, I think, earlier this summer to do a panel on how the courts would conduct business during COVID-19. And so I reached out to Judge Rosenthal, Judge Susan Brown, Kelly Johnson, Judge Jordan, Herb Ritchie, and there was a gentleman from Baker Botts. But we basically did a Zoom panel on how we would conduct business. So that was my only interaction with Mr. Wynn.
All right. Did you become, as you got to know him, did you become familiar with the fact that he was a former federal prosecutor?
Yes, sir, I did.
And what was your knowledge as to his background at the time of this call that you just described that you got from him?
Well, at that time, I didn't really know much about his background other than just, it was more just like when I would see him in passing, or at a Rotary meeting, how you doing? I didn't really, it wasn't like a friendship or anything like that. I just knew him from those two settings.
Now, you mentioned your father a while ago was and is a lawyer, but at the time that Mr. Wynn and ultimately the Attorney General reached out to you, were you in a solo practice or were you with your father?
I was in a solo practice at the time.
And did you have a secretary or anybody, or paralegal or anybody helping you?
I had a legal assistant, and I think at that time I maybe had one other lawyer working for me, and my older brother was in law school as well, and I sponsored his bar card as a temporary bar card or something like that.
All right, so that if you got involved into a case that involved potentially a great number of documents, witnesses, etc., the support you would have had would have been what?
I don't understand the question.
The support groups, I mean, what kind of legal support would you have had in order to be able to conduct an investigation or something?
Well, the documents that I received just personally to my email.
Okay. Now, tell me the nature of your call from Mr. Wynn.
Mr. Wynn had reached out to me and told me that Mr. Paxton was trying to get in touch with me. Didn't really say anything more than that. The call that I had gotten on my birthday from Mr. Paxton was from an unknown number, so there was really no way to call back. And then it wasn't until the next day that I spoke with him.
And so as a date for the jury to have, the date that you spoke with Mr. Paxton was what date?
That would have been August 23rd of 2020.
And by the way, up there, did you have with you, not that you did you have the invoice you ultimately sent to the Attorney General's office?
No, sir.
Did you bring it to the stand with you?
No, sir. I don't have anything in front of me.
do you want or need that as a point of reference for dates? Or if you don't, that's fine. Or would you like to have available a copy in order to periodically check things? It's totally up to you.
I'll take it, sure.
Pardon me?
I'll take it, yes,
okay.
sir.
Mr. Hardin, this is his bill.
This is Exhibit 227, which I move to introduce if it is not in evidence.
No objection.
Admit Exhibit 227 into evidence.
Now, I'm not going to really regularly be talking to you about this necessarily, but I'm offering it to you as periodically if it helps you plug in some dates.
Okay.
Have you, in our conversations previously, have you sometimes referred to this to make sure you were comfortable with certain dates?
Yes, sir. With respect to the dates, this would be helpful for me to remember.
Right. Now, let's go to the first. By the way, did you learn as you went along, thank you, Stella, that Mr. Wynn was the one who recommended you to the Attorney General?
Yes, sir. Mr. Paxton told me that when I met him.
All right. So now let's go to that conversation, your first conversation with the then Attorney General, Mr. Paxton. Did you return his call or did he call you?
I believe I returned his call. I returned his call the next day and we spoke, and he asked me to, he said he would, he had gotten my name from Michael Wynn. I think the words were, my name was dropped in the hat by Michael Wynn, and I'm looking to hire someone to work on a criminal investigation, and we scheduled a time for me to come out to Austin here to his office.
So, 5-year lawyer, solo practice, what was your reaction?
I mean, I was excited because it was the Attorney General's office, and so I was excited for the opportunity to go out and meet him.
All right. And did you do so?
I did.
And when did you do it?
I believe that was August 26th. Our meeting was on August 26th.
All right. And in the August 26th meeting, hold on just a second. All right. So tell me about that. Did you drive up to Austin or up to here?
Yes, sir. I drove out to Austin.
Did you go anywhere else first?
No, sir. Just came straight to meet.
Straight to the Attorney General's office?
That's correct.
All right. Describe for us that meeting.
So I went in, I signed in the front desk, and then I went up to the floor where his office is, and I think I waited around maybe 15 or 20 minutes, and then Mr. Paxton came to the floor, and we went into his office, and then...
All right. Who was in the initial meeting between you and Mr. Paxton?
It was just me and Mr. Paxton in his office.
Do you recall about what time of day you talked to him?
I think that would have been... I don't recall the exact time, but maybe around lunchtime, somewhere in there.
Okay. Now, what did Mr. Paxton say?
So before I got there, he had actually reached out to me through text messages and said, "Can you bring a resume with you?" And I was like, "Well, I haven't prepared a resume in a long time," but I went ahead and prepared one, and I brought my resume in, and then it was kind of like, our conversation that we're having now. Where are you from? What do you do? Your background. I gave him my resume and just kind of pleasantries. And then he said that he was looking to hire a special prosecutor to investigate a criminal case where potentially there were potential violations of the Texas Penal Code.
And you mentioned special prosecutor. Was that his word?
Yes, sir.
And so, of course, you hadn't been hired at that time, but later when you were, whenever you represented yourself as a special prosecutor, where did that term come from?
Mr. Paxton.
All right. And did he tell you what the role of this special prosecutor he was interviewing you for would be?
No, sir. Not really.
Initially, when he talked about this job, what did you think it was going to entail?
My understanding, this was just an assumption. I was like, well, if I'm going to be hired as a special prosecutor, I would potentially be presenting a case to a jury maybe at some point, or presenting the case to be charged. That was my initial impression.
And he didn't tell you otherwise at that time?
That was, like I said, sir, that was just my assumption of what the job would entail.
All right. And then how long would you estimate you talked to him in this initial meeting in his office?
Roughly 15 or 20 minutes.
Did he express anything, any views about his own staff or why he was hiring somebody from outside?
Yes, sir. He said that he was interviewing multiple people, considering multiple people for the position, and that he couldn't get his own staff would not work on what he wanted them to work on.
All right. They said they would not work on it?
That's correct. And he mentioned that, he just wanted to find out the truth and about what happened.
Okay. Do you recall anything else from the conversation in that initial meeting?
No, sir. I mean, that's...
And then what happened after you had this original meeting with him in his office by himself?
He said, I want to introduce you to someone. I obviously knew who Mr. Paxton was. And he said, I want to introduce you to this first assistant, Jeff Mateer, whose office was down the hall. So he walked me over there, and I met with Mr. Mateer in his office, just Mr. Mateer and I.
And now how would you characterize or describe Mr. Mateer's reaction when he came in and introduced you?
It was the same type of conversation, pleasantries, how are you? I gave him my resume. I told him, the conversation kind of didn't really get off the ground much. Just like, I'm here for the special prosecutor, interviewed for the special prosecutor position. And his attitude was kind of like disengaged about it. Knew about it, but didn't really seem interested in it. I'd say, kind of just like it was Mr. Paxton's own deal that he was focused on. It wasn't obviously wasn't an area of focus or concern for Mr. Mateer.
Did it strike you in any way as if his attitude was, so this is Mr. Paxton's deal, he's not that interested in it?
Sustained.
Thank you.
Then you tell me how it did strike you.
I'm sorry, sir.
How did it strike you as to Mr. Mateer's involvement in it?
Just, he was very disengaged did not seem interested in it at all. Seemed like it was just kind of a side deal that Mr. Paxton was working on. It was his own focus. Mr. Mateer was not focused on it at all.
How long would you think you were in Mr. Mateer's office?
Say roughly 20 minutes.
Had Mr. Paxton left you there by yourself with Mr. Mateer?
Yes, sir.
And then what happened after you finished meeting Mr. Mateer?
I went back over to Mr. Paxton's office, and he was in there, just him and I. And I said goodbye. Thank you for the opportunity. Thanks for calling me up. And he said, okay, we might be in touch with you. So I drove back to Houston. All right.
So how was it left when this was all over in that first meeting?
I'm sorry, how was it left?
How was it left? What was supposed to happen next?
Well, I really didn't know. I mean, I looked at it like, okay, I just interviewed with Mr. Paxton and the first assistant. And so if they want to talk to me, they know how to get in touch with me. All
right. So you left, obviously. What's the next thing that happened in connection with this case?
I got a text message from a gentleman named Mr. Vassar a couple days later, asking me to set up a time to meet with him.
Do you recall the date or so that you got the text message?
That would have been August 26th or 7th, I believe. It was August 28th, maybe 27th, 28th.
I'm looking down at Exhibit 227, and I notice it looks like the first time you charged was 9/3. So did you choose not to build the state for that first meeting or two when you went up there?
That's correct. And also I'd like to say that's a typo, that 9/3/20 date. The date that I actually went out there for the meeting was 9/4/20. So I made a typo there.
Okay, all right. Now, at the end, once you got back, you got the text from Mr. Vassar, what happened next?
So we scheduled a time to speak on the phone that day. That's what the text message was about. And we got on a call together.
All right. And did you ultimately send receive a contract or proposed contract from Mr. Vassar?
Yes, sir. He asked me for my email address on that phone call. And, I told him, this is about the special prosecutor position. He agreed. And then he said, well, I need your email address. I'm going to be working on a contract for you.
Okay. Did you receive that contract?
So, yes, sir, I did.
When?
Well, I got the contract on 9/3, September 3rd, but I didn't, it must have got lost. I get hundreds of emails. It just got lost in the shuffle somewhere. So Mr. Paxton actually reached out to me on 9/3 and said, did you get the contract by text message? And I said no, because I was supposed to go out there on 9/4 to meet with the complainant, Mr. Paul, and also Mr. Paxton. So short answer is I got the contract, I just didn't see it that day. It got lost in the shuffle somewhere.
All right, so tell me about how this appointment or arrangement set up for 9/4. Whose idea was that?
So I got a call from Mr. Paxton, and it was kind of like, hey, we want you to do this job. And
excuse me if I interrupted. Did you consider that the notice to you that you've now been hired?
yes, because he said I would be getting a contract, you got the job, and then he asked me, what's the hourly rate that you would charge to do this? And I said, well, I'll do it for $300 an hour. And he said, I think we can get that for you. And,
now, I'm just guessing, you correct me if I'm wrong. In your criminal practice, customarily your billing, were you charging people hourly ordinarily, or was it usually some type of flat fee arrangement?
On criminal cases, flat fee. On personal injury cases, contingency fee.
So did you have experience in charging that fee of $300 an hour, or were you just sort of guessing?
It wasn't guessing. I just was trying to consider, what was going to need to be done in the case. I mean,
Okay.
And so I landed on 300. I thought that was fair.
All right. Now, when you had that, how long did that phone call that you're describing, was that your second call with Mr. Paxton?
Yes, sir.
All right. And then how long did that call last?
I don't recall. It wasn't very long. A few minutes, maybe.
You gave him your hourly rate, and then was there an appointment made for when?
So there was an appointment made for 9/4, September 4th, 2020.
Who picked that date?
We agreed to that date because I was going to meet the complainant, or Mr. Paul, that morning. And so after, I'm in Houston, so I'm driving back and forth. I try to meet them both the same day. So
when did you receive Mr. Paul's name as the person that you were going to be, you say complainant. In other words, describe what you meant by that when you said he was a complainant.
Well, he was the one who had made the complaint or the allegations, and so I viewed him as the complainant.
All right. Had you seen any document as yet connected with the case?
No, sir.
And so do you recall when you first received Mr. Paul's name?
That would have been from Michael Wynn, when I set the meeting up to go out there and visit with him, with Mr. Wynn for the first time, Mr. Paul for the first time.
All right. Who set up the meeting with Mr. Paul?
Mr. Wynn.
And did you inform the Attorney General that you were going to also meet Mr. Paul before you met him on the 4th?
I did.
When did you do that?
I don't recall. It was within one of those days.
Would it have been the day that you talked to him about coming up on the 4th?
Yes, sir.
Okay. So did you inform him you were going first to Mr. Paul and then coming to the Attorney General?
That's correct.
So tell us about your first meeting with Mr. Paul. How did that happen and where?
So I met Mr. Paul at his office with Michael Wynn, and I drove out here early in the morning. I met with him for, I'd say, hour and a half, 2 hours. And that was the initial time that I, had heard the allegations about their complaint.
Had you done any research on Mr. Paul, his background, who he was, et cetera, before you had this first meeting with him?
I think I may have Googled his name and read a headline or something like that.
But did you limit your looking into him to Google him? Is that about the only thing you remember doing at that stage?
Yes, I didn't look at any court records or anything. I mean, that's all that I did.
And what was your level of knowledge about him when you first went to meet him on the
That he's
4th?
A commercial real estate developer here in Austin.
Okay. Did you see that he had had a search warrant executed on his house and business back in August?
No, sir.
So what was your level of knowledge of Mr. Paul at the time you met him that first time, whether you got it from the Attorney General or anyone else?
I mean, I didn't know him, didn't know anything about him.
Okay. And where did you meet him?
At his office.
Who was present during the meeting?
It was Mr. Paul and Mr. Wynn.
All right. So what happened at the meeting, without going in necessarily at this time with what he said to you, what was the nature of the bill? Who did most of the talking in the meeting?
Nate Paul did most of the talking, and it was just a lot of information given to me in a short time period.
Well, how was he doing that? I mean, how were you given information?
He was talking, he was just talking, trying to tell me, the circumstances surrounding the search of his home.
Did he make any presentation to you?
Towards the end, he showed me a copy of a search warrant and an order, and that was kind of the gist of his complaint. He showed me this presentation on a PDF document.
And so if you had to estimate the time that you visited with Mr. Paul at that time to get his, whatever he wanted to impart to you, how much of that hour and a half or hour and 45 meeting was Mr. Paul talking to you?
I don't understand, like a percentage type thing.
Yes.
Let's just say he was talking the majority of the time. Mr. Wynn was not.
And what was your first impression of Mr. Paul? How would you describe what you saw or listened to in this meeting?
Energetic, passionate, and had a lot of conviction, kind of an aggressive attitude, just a very, energetic person.
And what was your reaction when you left? Let me ask you this. Did he basically give you his side of the matter that you had been retained to investigate?
That's correct.
And what was your reaction to it?
I mean, I was convinced by what I was shown in the search warrant presentation and all that.
So when you left, to go talk to the Attorney General, had you already formed a personal belief as to what you thought was going on here?
No, not a personal belief. I was just like, hey, if what he's showing me on how the search warrant was altered is true, this is a big deal.
Okay. And did you, at that time, say to anybody or think that it looks like they did some bad stuff?
I had not developed an opinion about one way or the other. I mean, that was my first time, it was kind of like drinking through a fire hose, just a ton of information coming in a short time. And when I went to Mr. Paxton's office after that, I told him it was convincing, and he agreed.
Okay. So let's move now to General Paxton, meeting with General Paxton on the 4th of September, was it?
That's correct.
How long was that meeting? Where'd you meet him?
So we arranged to meet at his office again, and the meeting was, I think, roughly 20 minutes or so.
And then what did Mr. Paxton say in that meeting?
So I told him I was convinced, it was a convincing presentation of what he agreed with that. He also said that the people in his office who were not, they weren't investigating the case. They weren't working on it. At that point, I had learned that there were some federal agents and people, I guess, in positions of power who were kind of involved in that. And, he made a comment that you need to have some guts to work on a case like this. And I was fired up about the opportunity to do it.
Yeah. So how would you describe to the jury and the court your level now of excitement? Now that you've got a little bit of idea of what Mr. Paul says, you and the Attorney General have agreed is convincing, and you think this is going to be a big deal. What was your state of mind about that?
I was excited to be working on a project with the Attorney General's office.
You were already there, right?
I mean, it's the chief law enforcement officer of our state, and it wasn't about money or anything like that. It was just an opportunity to do something new in my career and try to help out.
All right. And when he said that you as people weren't working on you, did he express anything about how he felt about that to you, or tell you whether they were not working on it or they wouldn't work on it? In your own words, what did he say?
I don't recall specifically, but he said that he couldn't get the people in his office to work on this case.
Okay. And did you leave that meeting with the impression or feeling that his people were refusing to work on it?
Yes.
Did you wonder, what if they're not going to work on it, why don't you fire them?
I mean,
You didn't think about that?
no, sir.
All right. Okay. Now, after that, did that meeting get terminated a little early, or tell me? You said it was about 20 minutes.
So he said
Excuse me just a sec. You've driven all the way up for Houston for it. What happened to shorten it a little bit?
He had to go to a press conference, and I was going to take off, and he said, well, why don't you just come over there with me to the press conference? And so I went over there with him and with one of his staff, came over to the press conference, and then after that, we went back to the office. I just kind of watched the press conference.
All right, so now, not only have you been hired by the Attorney General, but you're going to a press conference with him. How'd that make you feel?
Well, I mean, I've been with my dad in press conferences before in some of his high-profile cases, but it was cool.
Yeah, okay. All right, now, did you think anything about, well, let me back up. So you had 20 minutes or so to talk to him about the case. Did y'all talk about any of the facts in the meeting before the press conference?
No, I did not really have a full grasp on all of the people that were involved and all the facts of the case at that point. Just...
Now, what was your impression or belief at that time as to the occupations or nature of the people you were supposed to investigate?
I knew that they were both local law enforcement, and some of them were federal law enforcement officers at the time.
Did you know that one of his allegations was about a federal magistrate?
Yes, sir.
What was your reaction to hear he wanted you to investigate a federal judge?
My reaction to it was just hearing out their side of the story. I didn't really have an opinion one way or the other. However, if the allegations that they were making were true, then that'd be serious.
Okay. Now, did he talk about any in that conversation, any of either Mr. Paul or him, of any people other than federal and local law enforcement being the people he wanted investigated?
No, sir.
After the press conference, how much longer were you in the company of the Attorney General?
I think probably 15 or 20 minutes. We went back to his office and finished up the conversation there.
Well, what happened in that conversation?
When we got back to the office, I was a little bit concerned because at the time, I think I'm in private practice. I think I had roughly 75 cases on my own docket. And I told him, I'm like, well, if I'm coming back and forth between Houston and Austin, how am I going to be able to do this? And he said, well, look, his words were, if you can just get a wet ink copy of the original search warrant, this will be over pretty quickly. And I'm sorry.
No, go ahead.
Well, just if what had been produced to Nate Paul and his lawyers matched up with the original copy, it would be over quickly. But obviously, if there were discrepancies between the original wet ink copy and his words, then this thing could drag out a little bit more.
So what did you think you were going to do originally then? And by the way, had you ever heard the phrase, and maybe it's very common, I had a wet copy. What is that what he said, a wet copy?
A wet ink copy.
What does that mean? What did you take it to mean?
Just the original search warrants that was signed off by the judge had, a wet ink signature on it.
Okay.
Not the scanned PDF version.
All right. So what did you walk out of that meeting heading back in the car to Houston? Did you think your mission was?
So we really didn't go into the scope of the work. At that point, it wasn't until I actually got so the copy of the contract had been sitting in my inbox. So when I get back home and I read my contract and see that the scope is limited to like more of an investigative role, then I'm like, okay, well, I'm a lawyer. I'm just going to collect evidence, review evidence that's presented to me, and draw some type of conclusion to either corroborate what the allegation is or contradict that, and put it in a brief and submit it. So I knew at that point, once I read my contract, that I wouldn't be trying a case or anything like that. It was limited in scope.
Can you put the original the contract up and go to the addendum A, please? I believe the contract is in evidence in several ways.
Is this in, Mr. Hardin? Do you know?
Pardon me?
Is it in?
I think it is.
I'm not contradicting.
I'll check. Hold on just a sec.
Could we get an exhibit number, Rusty? Eric, can you get us an exhibit?
It is in.
It's House 160 and it's in evidence.
Thank you.
Now, do you recognize this particular excerpt from the contract?
Yes, sir.
All right. And if you could scroll up just, yeah, that's going to be good. Can you explain to the jury what you realized your scope was more limited when you saw this, I take it you're saying, than you originally imagined your role would be?
Just in an investigative role, and then my ultimate goal or job at the end of this would be to prepare a report of my findings and give that to the Attorney General's office, and whatever they do with it is.
And was this scope different than what you understood it to be when you originally talked to the Attorney General?
This was different than what I had, I guess, come up with in my mind, what I would be doing.
Can you tell us what lines or sentences there, Mr. Cammack, so she can highlight exactly what you noticed when you saw that it was a little bit change in the scope of what you could do?
Can I have a second or just look at this and read it?
So, for instance, do you see the sentence, if you would, and shall prepare a report documenting any potential criminal charges that may be discovered in the course of the investigation? Do you see that? And before.
So that's yes, sir. That's the report I was referring to.
Okay. And that is a more restricted role. Is it your testimony? That's really a more restricted role than you understood from the Attorney General you were originally going to have.
I'm sorry, could you repeat the question?
Is that a more restricted role than you originally thought you were going to have when you talked to the Attorney General?
Yes, sir.
Okay. Now, you notice it says, notwithstanding anything to the contrary contained in this outside counsel contract, outside counsel shall conduct this investigation only as consistent with the complaint referred to the OAG and is only as directed by the OAG. Correct? So who did you believe you were being hired by?
The Office of the Attorney General.
Had you had any contact with the District Attorney's Office?
No, sir.
Did you at any time during this representation think you were working for the District Attorney's Office?
No, sir.
Throughout your representation in this matter, whom did you think, or who hired you, and whom did you think you were working for?
The Office of the Attorney General.
All right. And in turn, throughout all of this, who in the Attorney General's office in a position of responsibility did you consistently have your contact with?
The only person I reported to was Mr. Paxton at his direction.
Okay. Now, do you see, except for outside counsel's duty to provide a post-investigation report, this outside counsel contract expressly excludes legal services relating to any other post-investigation activities, including, but not limited to, indictment and prosecution. Had you yourself looked into the law that talked about the respective jurisdictions of a district attorney's office and the Attorney General's office?
No, sir.
Did you ever?
No, sir.
Okay. In this particular matter, what event did you think you were going to be investigating?
The referral from Travis County DA's office with respect to this allegedly unlawful search.
All right. And then later, did you receive another referral, what's been called referral number 2?
Yes, sir.
Now, that's dated September the 23rd. Do you happen to recall when you received it?
I think I got that on 9/24.
Okay.
On an email from the Travis County DA's office.
And was that a totally different matter than you were originally hired to investigate?
Yes, sir.
When you got that, what was your response?
Well, I read through it, and I don't remember when I spoke with Mr. Paul and Mr. Wynn at the meeting, if it was before or after that, but when I got it, it was related to some type of alleged mortgage fraud where these lenders were wrongfully foreclosing on his properties and then trying to sell it at the auction. I don't recall any more detail than that.
All right. And when you looked at that one, of course, who was the complainant, the person who was complaining about the criminal conduct and wanted it investigated?
It was also Nate Paul.
Now, when you looked at it, did you see that it was essentially a complaint about civil litigation matters?
I'm sorry, could you?
Yeah, and I'm really only asking about your mindset.
Yes, sir.
Not one way the other.
Okay.
Did you notice whether it actually was a complaint about civil litigation matters in bankruptcy court?
Well, I wasn't looking at it through that lens at all. And to be frank with you, I didn't have any experience in handling any type of mortgage fraud or prosecuting any type of potential white-collar crime in that way.
All right. So did you just sort of put it aside and not ultimately do anything with it?
No, sir. That's not true.
Okay. Well, tell me in your words.
Well, I spoke with Mr. Paxton about the referral because I wasn't sure if my scope of my contract covered that.
Certainly.
And so, he said that it did. And so I was like, well, I'm going to rise to the occasion. I'm going to figure this out.
All right. So let me see if we can go through the mindset or experience for you here. You see a referral on a separate matter, which is not the one you were originally hired for, correct?
Yes, sir.
And you receive it on September 24th, and you notice it's an allegation of mortgage fraud occurred in bankruptcy court. You see that?
Yes, sir.
So how did you find out what the Attorney General felt about it? Did you call him?
Yes, sir. I mean, I'm sorry, but I don't remember the exact date.
That's okay.
But I asked him, I know for sure that I asked him if that was covered within the scope of my contract, and he said yes.
Do you remember when that conversation was and what the rest of the conversation was?
I would just have to give you an approximation. It was roughly around the time that I received the contract on 9/24, either a day before or a day after, or the day of, just somewhere in that 23 to 25th range.
And do you recall what the occasion of that conversation with him was, somewhere around the 24th of September? Did you call him explicitly for that, about whether this referral number 2 was in your contract, or were there other things that y'all talked about as well?
I don't recall the entire nature of that specific call.
Okay. Did you notice when you looked at referral 2 that one of the people he was asking to be criminally investigated was a federal bankruptcy judge named Tony Davis?
No, sir.
You didn't notice at that time?
No, sir.
Okay. Did that referral, just like the first referral, have a list of people that Mr. Paul claimed were people of interest?
It did, yes, sir.
All right. And did it list these people? Do you recall whether when it listed them, whether it listed actually personal data like their address and their phone numbers?
I don't recall if that was in the referral or not.
All right. Don't remember whether it was in referral number 2. Is that what you're saying?
Yes, sir.
All right. Was that the case in referral number 1?
Yes, sir.
Okay.
There were names and I believe some demographic information.
All right.
The first one. I don't recall.
Now, in referral number, let's go back now to the period a little before September 24th, when we were talking about the original referral. After you returned, did you receive any type of documents and materials to review when you left the meeting with both Mr. Paul and back on the 4th of September?
Yes, sir.
Can you tell us what kind of materials he gave you that you took back to Houston to review?
So I had taken my handwritten notes from the meeting back with me. And then I also received like a little 5 or 6 page document that appeared to be some type of timeline of events giving Mr. Nate Paul's version about what happened.
All right. Now, did you take that just as his version?
Yes, sir.
All right. But when you left there, what did you have when you left there, and then on the 4th, and after your meeting with the Attorney General, had you developed sort of a game plan in your own mind as to how you were going to do the investigation?
So I did. I was trying to consider, how to get information to either corroborate or contradict what was being said.
All right. And did you tell us how you viewed the role of Mr. Paul and his lawyer, Mr. Wynn, in this, in terms of what role were they to play in the upcoming investigation?
Well, I viewed Mr. Paul as the complainant. He's the one who was complaining of these allegations, and then, Mr. Wynn was his attorney in some other separate matter.
How did you view your role as the Attorney General? Did you look at them almost as a client in terms of them sharing information with you and all? How would you describe that in your own words? With who? Mr. Paul.
Okay.
And of course, Mr. Wynn's his lawyer. But in your view did you consider yourself as like a prosecutor and a citizen had come in and made a complaint?
I viewed him as a complainant in the case, and just in the same way that if a client hires me for a case and they bring in a banker's box full of documents and information, I'm going to go through it. And so I didn't think that it was unusual that I would be getting information from the complainant and his attorney. And as I got that information, I thought this was the same information that Mr. Penley had.
Yes. Had you met Mr. Penley?
No, sir.
Did you ever meet him?
No, sir.
All right. So when you originally were hired by the Attorney General, did you make a certain assumption as to what your role and Mr. Penley's would be?
Well, I thought I would meet Mr. Penley at some point. I remember I asked Mr. Paxton in that that second meeting if I'd be meeting, am I going to talk to him? Does he have a file that I can start working with? And his response was, I think he was out of town, and he had a file on his desk. So I did assume at some point that I would meet Mr. Penley and take a look at his file.
Well, did you assume originally that you would be working with the Attorney General's staff as you gathered information, and that would mean that you'd be working with the division head?
I did. I mean, obviously, as a solo practitioner, I don't have access to a lot of the resources that government offices has. And so I thought at some point I would be dealing with or meeting with some of these individuals.
Right. And so did you just assume that Mr. Penley was being kept informed as what was going on here?
I didn't really think about that at the time.
Okay, fair enough. But at any time, how many times did you ask Mr. Paxton about either meeting Mr. Penley or getting some information or getting some support from the Attorney General's office?
I'm sorry, I didn't understand the question. Mr. Harden. Can you repeat your question, Rusty? I didn't hear it. I'm sorry.
Sure. How many times did you ask Mr. Paxton about either meeting Mr. Penley or getting some information or getting some support from the Attorney General's office?
Thank you.
I asked, it's kind of two parts. So with respect to Mr. Penley, I'd only talked to him about Mr. Penley maybe twice, and then that was early on, and then that's when I was asking about, was there a file, how do I get in touch with him on this deal? And then as far as getting support from the office, I think I asked probably 4 or 5 times over the course of this 3.5 week period when this all happened, can I get badge? Can I get credentials? Which I never got, but I repeatedly asked for those things.
And what was the Attorney General's response each time?
I think initially his response is, okay, we have to get somebody to work on that, or we'll get it to you. It's just I never got a firm answer on when I would be getting those things. I knew I would need it, when it came to issuing subpoenas and things like that.
Yeah, so what things were you asking him for? Let's start with Mr. Penley. Each time that you asked him or mentioned Mr. Penley, did he have some reason not to put you in touch with Mr. Penley?
The only thing that I asked about Mr. Penley was, did he have a file and will I be meeting with him? To which his response was, he's out of town and his file is on the desk. I just thought in my mind that I would eventually meet with him to discuss this case. I mean, I don't know anything about any of these people in that office. And so I'm like, I didn't know anything going on. So
How did you know Mr. Penley just looking at a flow chart? How'd you know about him?
I knew the name from Mr. Wynn and Mr. Paul in that first meeting.
Did Mr. Wynn and Mr. Paul, were they critical of Mr. Penley in that first meeting?
Yes.
What'd they say?
Well, they said that Mr. Penley said that there was no information that could be presented to him that would make him believe that a federal official broke the law in the way that they claimed.
All right. And this conversation with them was that was the one September 4th?
Yes, sir.
Okay. Now, do you think that's a little strange that they didn't want to deal with the head of the division in the Attorney General's office?
My understanding was that they had met with him one time.
That's all, just one time?
Yes, sir. That's what I was told.
Is that what they told you?
Yes, sir. And he refused to look into it. And then that was kind of reinforced by the fact that Mr. Paxton said that he couldn't get anyone in his office to work on the case.
All right. So in your conversations with them and as your investigation, were you ever told or informed that they actually met with Mr. Paul 3 times?
Excuse me, Your Honor, that them, objection hearsay, that includes other people other than Mr. Paxton.
Sustained.
Let me ask you this. Did you ever learn from Mr. Paul, Mr. Wynn, or Attorney General Paxton that Mr. Penley...
Excuse me, same exact objection.
Let me just finish, please.
I'm sorry.
That Mr. Penley or Mr. David Maxwell met with Mr. Paul and Mr. Wynn 3 times.
Okay, that's both multifarious and hearsay.
Sustained.
Did you ever learn that Mr. Penley, did you learn anything from any source about how often Mr. Penley was trying to get Mr. Wynn to provide further documents?
Objection.
Objection is only was he aware of anything like that?
Objection hearsay. The question was, did you learn from any source? Objection hearsay.
I'm only...
Overruled.
Thank you. Were you?
I'm sorry, could you please repeat the question?
Sure. Were you ever aware from any source that Mr. Penley, after 3 meetings, was continuing to try to get documents from Mr. Wynn? Did you ever hear that from anybody?
Objection. I'm sorry. Objection hearsay. I apologize. Sorry, Mr. Cammack. Sorry, Rusty. Objection hearsay.
Sustained.
In your mind, what was your understanding from any source of the level of involvement of Mr. Penley and Mr. Maxwell in this investigation?
I'm sorry, Rusty, the level of?
I'm not asking for any statements or anything. I'm asking what his understanding of mindset was.
I understand. I just didn't. You said the level of, and then the word trailed off. I'm sorry if I'm being difficult.
How sorry are you?
Pretty sorry. Sorry enough.
All right. My question, I think, stands, Your Honor. I simply want to know what his state of mind and level of knowledge was, because it has a lot to do with what he does later.
Yeah, I didn't hear an objection, actually. I just heard him say...
I didn't either, so...
He just said he couldn't hear you. So.
I just didn't understand the question. That question, as asked, I'm fine. Go ahead.
Is your microphone on?
Well, he's reading it. I can't read that far. Go ahead. I'm sorry.
Thank you. Now, at the end of the day, what was your level of knowledge about this?
So I was told early on by Mr. Paxton that the people in his office weren't doing what he asked them to do. That's why he was considering hiring outside counsel.
Right.
And then towards the end of September, in this 3.5 week period, I was told by Michael Wynn that Mr. Penley had reached out to him kind of out of the clear blue for documents. And then I asked Mr. Paxton about that when I spoke with him, and he said, well, I told him to stand down. He's not working on this case, you are.
And who should stand down?
Mr. Penley.
Yeah, General Paxton told you that Mr. Penley should stand down. He wasn't involved in the case anymore?
That's correct, and that was my only other time that I knew about any of his involvement.
All right, do you recall when that conversation was and where you were?
It would have been a phone call towards the end of September.
All right, thank you. Now, let's go back after the 4th. I assume you started reviewing the materials you had received?
Yes, sir.
Tell us about how you proceeded in your investigation then.
All right, so I was still trying to get my arms around what was alleged and all of the folks that were involved in it, and trying to figure out, since I didn't really have any information, what information I would be able to obtain. And just started kind of thinking of the way to do this would be to do grand jury subpoenas to get information regarding like phone calls and things between the individuals involved in that first referral.
All right. Now, by the way, did you during this period of time, Mr. Cammack, consult with any other people you thought might have had these types of investigations before to sort of get an idea how to proceed?
No, sir. No,
this
sir.
is not something you had done before, correct?
I had not ever done this before.
Okay. Now, by the way, in your communications with the Attorney General, how were you communicating with him? By phone, by text, by email? Can you describe the forms of communication y'all used?
So we spoke by phone and through text message, and then throughout this process, I continually forwarded emails to him as something would come up or I would get some information.
Well, did you use any kind of encrypted communications?
Yeah, I think about the middle of the month, he asked me to use the Signal app, which I wasn't really familiar with at the time. I just thought it was like a WhatsApp or just a messaging
You were unfamiliar with Signal app at that time?
I'd never used it before.
All right. And how did that come about that he wanted you to communicate with him using Signal app?
He asked me on a phone call to download the app and use that.
Did you go on the internet to look and see what a Signal app was?
No, sir, I just downloaded the app.
Okay. And do you recall what the nature of the conversation was in which he asked you to start using Signal app?
It would have been a call where we were talking just generally about the case, kind of the status of it and what was going on. It wasn't I do remember it was not a phone call specifically about using that app.
And what type of email address did you use with him?
But what do you mean?
Well, do you recall what the email address was?
No, sir.
Was it an official Attorney General's office email address?
Oh, I see what you mean. No, sir.
All right. What was it?
His email address was a Proton mail address.
All right.
That I was given.
Had you used Proton before?
No, sir.
Had you ever heard of Proton?
I had heard of it. I've never used it.
Okay. Now, in addition, what about the phones? What type of phone number did you have that you would communicate with him?
I had the original number that he had first called me on, and then I think later he gave me another number. Around that time, I was getting calls from unknown numbers, or it'd say potential spam. You get those types of calls, and I was like, well, I don't want to miss the Attorney General's number, so I got myself a separate number and gave it to him. That way I knew when that phone rang, that was Mr. Paxton calling.
So are you saying that you ultimately got a phone that was totally dedicated to phone conversations with the Attorney General of the state of Texas, and that's the only number that you communicated with on that phone?
Yes, sir.
And you did that, why?
Because I didn't want to miss a call from an unknown number or a spam likely call, or when you get those spam calls, I didn't want to have that come up and miss an important call. So
did he use multiple phone numbers with you?
Yes, sir.
How many?
2 numbers.
Okay. And were either of those official Attorney General lines?
I believe they were cell phone numbers. I don't believe they were office numbers.
All right. In fact, when was the first time that you ever learned what the official email address or the Attorney General office email address was of the Attorney General that you were dealing with all this time?
The first time that I ever saw his governmental email address
Yes.
was when I got a cease and desist letter from Jeff Mateer.
And when was that?
That would have been, I believe, August 1st or 2nd.
And how was it that you saw what the Attorney General's official email address was?
They were all copied on the email. All the gentlemen, Mr. Vassar, I think, was one of them. And
was that first time when you got your cease and desist letter, the first time you ever knew of any official communication form of communicating with the Attorney General, whether it was through text or email or phone?
I thought all of my communications with him were official, but that was the first time that I saw his governmental email address.
All right.
Yes, sir.
Now, did you trust the Attorney General?
Yes, sir.
Were you flattered about him reaching out to you?
Yes, sir.
Did you trust Michael Wynn?
Yes, sir.
Did you appreciate him referring you to the Attorney General?
I did. Yes, sir.
Okay. And did you always trust Michael Wynn to have your best interest at heart and try to help you?
Yes, sir. I didn't have any reason not to trust him. I knew that he was Nate Paul's lawyer.
Okay. Did you trust Nate Paul?
Didn't really know Nate Paul. I just was trying to do my job.
All right. Now let's move to the period of the middle of September. After you came back, you had all your material from the 4th that you'd gotten from Nate Paul. What did you do after that?
So around this time, I had a conversation with Mr. Paxton because I wanted to try to get the individuals named in that first referral, like call logs and email logs showing whether or not these people had been talking around the time that the search had taken place. And so, being that it's sensitive, since they are federal agents and there's some people in power there, I thought that the grand jury subpoena would be a discreet way to get that information. And so I brought that up to Mr. Paxton.
And do you recall when this conversation was?
I believe it was around, we had talked about it from early on in the month, like within that first week of September, but the conversations kind of continued going on until about the middle of the month, about September 14th.
Okay. Now, at that time, what did you say to Mr. Paxton, and what did he say to you?
I told him I think we should try to do a grand jury subpoenas, being that this is a discreet way to get information. Grand jury proceedings are private and secret proceedings, and so we'd be able to get information that way without raising any kind of alarms or causing some type of, panic about the situation. And he said it was a smart idea.
So he endorsed it?
Yes, sir.
Did either of you talk about the fact that if you issued grand jury subpoenas for a claimed offense that Mr. Paul was presenting to you, that the recipients of those grand jury subpoenas would know what was going on or have questions or be maybe even alarmed? Did y'all discuss that at all?
Excuse me, objection leading.
I think I gave him several
Sustained.
choices. Did y'all talk about the possible reaction of people that got these subpoenas?
No, sir.
Later you issued subpoenas, did you not, for credit unions and banks and stuff like that, correct?
Yes, sir.
Was there any conversation between you and the Attorney General about how those people might feel when they got those grand juries?
No, sir.
Did you become later aware, we'll get to who all that were on there, of that some of these subpoenas were going to lawyers or people that were opposing Mr. Paul in litigation? Were you aware that that's who some of the people were?
No, sir.
Okay, well then let's get to what you know. When you talk to the Attorney General back about downloading the app and everything, were you also talking to him at that time about trying to seek credentials and other types of things that you needed for what you were doing?
Yes, sir. I needed
When did you first start asking for those types of things?
in my first meeting with him on September 4th, and then I asked about it again, like as I'm approaching the time where I need to be, as the time I'm doing the applications for these subpoenas.
What did you ask him for?
Email address, am I going to get some type of badge or some credentials, like, because I'm going to be approaching people with legal documents and I need something to show that I have the authority to do that.
But what did he say?
We're working on it.
Now, you assumed, did you not, that of course it'd be perfectly fine to give you those things because it would be a public record and there was nothing wrong with it, correct?
I expected to get that.
Yes. And you expected and believed you were going to need that, did you not, in your investigation?
Yes, and I ended up, I did need it.
How many times do you think you asked the Attorney General for these official documents?
It would have had him in 4 or 5 times over the course of a month.
And each time you asked him for him, what was his response?
We're working on it. We'll get it to you.
At some time, did you begin to wonder why they would not give you any kind of official documents to show your status?
No. I don't know how the office operates within the Attorney General's office. I wasn't sure if there was a bunch of red tape to go through. I didn't know any of that. I just knew that I would need it to do what he was asking me to do.
Right. We always hear about the slowness of bureaucracy and government agencies. Is that the kind of thing you just thought was going on?
Yes, sir.
Okay. So it never occurred to you that maybe he didn't want them to be public?
Objection, leading and assuming facts not in evidence.
Sustained.
Did it ever occur to you? Did you ever have the thought, a wonder, don't they want this public or what? Did you have that kind of thought process?
I wasn't thinking about anything like that.
Fair enough. Now, when you mentioned the grand jury possibility to the Attorney General, in that conversation, and you think that conversation was when, roughly?
That would have been around I know I spoke with him about it on September 6th, so I have a note here on this invoice, but the middle of the month around September 14th.
Okay.
There were a couple conversations where I was just kind of trying to figure my way through this.
Now, you, of course, as you mentioned before, had never done a grand jury investigation, correct?
That is correct.
So did you ask him some questions, to the Attorney General, some questions to try to help you in that respect? First of all, did you assume that maybe he would know that kind of answers?
Yes, sir. I am so sorry. Judge, is there any way I can use a restroom break?
We'll stand at ease for 10 minutes.
Sorry about that.
We'll give you 10 minutes. The witness may step down.
Thank you, Judge.
Okay.
Thank you very much.
I would just stand at your desk, George. I would not leave. He's just stepping out and coming right back.
Okay, so they've taken a 10-minute break here, so Mr. Cammack can go to the restroom. Todd, testimony.
Just shocking. Shocking. I just am blown away at why this seemingly inexperienced and inappropriate, I don't want to call him inappropriate.
He has no experience for this.
Nothing. It's not even in his realm of. I mean, he's a criminal defense lawyer that really hadn't done too much of any criminal defense work. Worked for his dad, and gets recruited by Nate Paul and Ken Paxton to. I mean, he said it. Investigate law enforcement and potentially a federal magistrate. I mean, that's nothing. That's nowhere even close to what he knew how to do. He went to the University of Houston undergrad in law school, and how they ever found him as a mark or a target, I guess Mr. Wynn, his Nate Paul's lawyer, was a buddy of his in Rotary, and they weren't even friends. I mean, according to Mr. Cammack, they were barely associates. They barely knew each other. This is just, I don't understand what's going on here.
Well, and then he's asked, did you consult with anybody that's done these kind of investigations? Nope.
He didn't have any staff. He had one paralegal and a third-year bar card lawyer that worked for him in his office, and was just given this task to go investigate law enforcement. I mean, we were speaking while this was going on. Okay, on Monday, go, start. Well, how does he even know what he's supposed to do? How does he even begin?
Go ahead,
Attorney
Bernadine.
General didn't want an experienced attorney.
That's right.
That was the whole point of it.
Oh, I'm with you.
To
You know,
go
he didn't
and
want
get-
Joe Brown because he's a former U.S.
That's
attorney.
right.
Yes,
He wanted somebody that he could, a puppet.
he recruited what he wanted, and he got what he wanted. So, and then, and if you're looking at someone with such inexperience, then you could almost understand why he's not asking all these questions, because he's working for the Attorney General.
That's right.
You would just,
We got to fix.
What am I off on here?
We're going to fix Todd's mic. Hey,
God, again.
apparently it's rubbing up against your jacket, and people are commenting in the live stream. So we're going to fix it.
Where did it go?
Let's put it. Hey, Jay, can you come help
Sorry
Todd?
about that.
And we'll get this. We'll get this. So yeah, no. And then I think just this whole issue of, we there's been prior reporting about how Brandon Cammack gets identified, but we now hear from Brandon Cammack's own mouth that the first person he talks to about being hired about being brought in to do this is Michael Wynn. Michael Wynn, who is Nate Paul's attorney. And once we get Todd's mic situation figured out here, we can talk about how crazy and unusual it would be to have to just have something like that. I mean, that would be a really rare situation to have. To have that happen, and then we haven't heard. They haven't gotten to this part yet. But when they go to deliver the subpoenas to some of these banks. Okay, they're coming back.
Hold on one.
Okay,
Hold on, Mr. Harden,
they're
for all
coming
the
back.
Jurors to be seated again.
Mr. Cammack.
Hold on 1 second. They're not all in their seats. Court will come to order, and hold on one moment, Mr. Harden, for all the jurors to be seated again.
Mr. Cammack.
Hold on 1 second. They're not all in their seats. Looks like we're short 2 members. Mr. Hughes and Mr. Miles. Senator Miles, Senator Hughes, please come forward. Okay. Okay, thank you. We're 1 juror short, so we're going to wait. We're texting him now. Mr. Hardin, you may resume.
Thank you, Your Honor. All right, Mr. Cammack, I want to go to, if I may, when you were asking him and talking to him about the grand jury subpoenas. During that conversation, and you mentioned that you asked him about credentials. How did you go about trying to find out how to do a grand jury issuing and using grand jury subpoenas? What did you do? Your microphone.
Yes, sir. So I asked Mr. Paxton, it's, at this point, he's like, this is a smart idea. This is the way that we should proceed. So the next question is, okay, well, how do we do this? Because I wasn't sure whether the Attorney General's office had their own special grand jury in session for cases, or if we would do it through county, like Travis County grand jury. And so I didn't know the answer to that. He said he didn't know the answer to that. He would need to find out. And, I think he had indicated to me at that time, he wasn't a criminal lawyer. Most of his experience was in business law. So he would find out which grand jury that we would.
And did you find out?
He reached back out to me around the middle of the month, maybe a day or so after, and told me that we would be going through the Travis County grand jury.
But the AG himself called you back and told you that?
Yes, sir.
And then what did you do?
So my next step was to reach out to Travis County District Attorney's Office, and it was kind of weird because before I even have an opportunity to do that, I get a message or a voicemail that Michael Wynn had sent me saying, this is the person that you need to contact over there.
How soon after you had the conversation with the Attorney General that concerning the fact that it would be a Travis County grand jury, how soon after that conversation with the Attorney General did Mr. Wynn reach out and give you a contact in the Travis County DA's office?
I don't recall exactly, probably within 24 to 48 hours.
Do you have any idea how Mr. Wynn would have known that you were seeking that information?
Well, I'm sorry.
Had you told Mr. Wynn you were trying to find out, or did it just come in unsolicited?
No, I spoke with Mr. Wynn about the grand jury process.
All right.
So he was aware, him and Nate Paul were both aware that that's how I was proceeding with their investigation.
When you got that information, did you reach out to the Travis County grand jury?
I reached out to the Travis County District Attorney's office and spoke.
Excuse me, I said grand jury, you're right. The office, excuse me, go ahead.
I spoke with, I forget, it was a nice woman, I forget her name. She put me in touch with a gentleman named Don Clemmer. And then Don Clemmer put me in touch with, I guess, this real sweet lady. I think her name was Bailey. She might have been the grand jury coordinator over there.
Let me ask you this. Was it last name Mulder? Does that sound?
That sounds like correct.
Right. Did you tell these folks that you were a special prosecutor working with the Attorney General's office?
Yes, sir.
Okay. And as such, you were asking assistance to get some grand jury subpoenas?
Yes, sir.
And did they help you get the grand jury subpoenas?
Yes, sir, they did.
And let me ask you, at this time, Your Honor, I want to move to introduce en masse, I believe we informed counsel on the other side, Exhibit 257, which I'll represent as all of Mr. Cammack's production in this matter to both sides. These are the documents that he has produced to lawyers on both sides, and I move to introduce them in toto.
Any objection? Speak on the microphone, please. Still can't hear you.
Object to 649, 691.
Dan, can I stop you for just a second to explain to the court? We have given them excerpts. So that it was too voluminous to be carrying around the hard document here. But what we did do, about 2,000 pages, I think it was a lot. What we've then I've gone through and taken out excerpts and put an exhibit number on them. But they are excerpts from what I was seeking to do was introducing the whole group and then taking out and putting an exhibit number on those that we specifically were going to talk about. Go ahead.
I appreciate all that, Mr. President, but to be clear, we got an amended exhibit at 4:50 this morning, which includes these, several of which I will be objecting to, several of which I won't.
Excuse me, are we going to start getting into when we get stuff for them and what time of the morning? I would just ask for
Just stop right now.
Yeah.
You would, like I started to say, object to 649, 691, 687, 688, 689, 690, 686, and 650.
Reason for the objection?
Sir?
You objected to those documents, okay?
I am. Now,
Okay.
I do not have objections to 677, 678, 679, 680, 681, 682, 683, 684, 685, and 693. The last sequence, Mr. President, I do not have an objection to.
So let's go back to the objection.
Yes, sir.
I'd asked you for a reason for the objection to the
Yes, sir.
other documents.
Yes, sir. The basis is hearsay on each. And just so, let me try to get them in order so Mr. Hardin and I can literally be on the same page.
May I ask one more time real quickly the ones you object to, Dan?
Sure.
Make sure I got all of them.
Yes, sir. The ones I'm objecting to are in order, Rusty, are 649. That's the work product. If you're with me, you want me to come over there? I'm happy to do that if that's easier for you.
No, go ahead.
649, 650, 686, 687, 689, 690, and 691.
And the type of objection, Your Honor, the basis?
Hearsay. And I don't know if you, Judge, Mr. President, do you have them in front of you?
We don't have them.
May I do this? Let me go right now to discuss the ones that has no objection to and ask that they be admitted.
Sure.
Okay, we'll admit the items that you have no objection to, and to be certain we have those right numbers, would you repeat those numbers that you do not object to?
The numbers that and I'm not sure these are in order, but 677, no
Yes.
objection.
Okay,
678, no
Yes.
objection. 680, 681, 682,
yes,
683,
yes,
684,
yes,
685,
yes.
and 693.
What about 679?
All right.
Hold on one second, just checking this.
You inquired on
What I-
679. I don't have that one in front of me.
Okay, you originally said you had no objection to 679, but you may have misspoken.
Certainly capable of doing that. No, 670. You're correct, Mr. President. 679. We do object to 679.
Okay, so 679. So to the court reporter, and forgive my for a moment there, something I said the witnesses shouldn't do. So to be clear to the court reporter, no objection to 677, 678, 680, 681, 682, 683, 684, 685, 693. And it's my understanding, Mr. Hardin, to begin, you will just focus on those. And if you want to refer to the others, you'll have to give us an answer on why it's not hearsay at that time.
That's correct. Your time, could I?
I'm admitting So we are admitting into evidence 677, 678, 679, 680. I'm sorry, 677, 678, not 679 at this time. 680, 681, 682, 683, 684, 685, and 693.
Your Honor, can I have 10 minutes credit back because of the housekeeping we did here?
Did you say you needed 10 minutes?
Could I have 10 minutes credit back for the conversation we've had?
I'll give you 5.
Thanks.
All right.
All right. One has to take what they can get. All right. Mr. Cammack,
yes, sir.
Did you start receiving assistance to get these grand jury subpoenas done as to who they would be from Mr. Wynn?
Yes, sir.
And is it still on? I didn't hear. Yeah.
Can you hear me?
Yes.
Okay.
Yeah. All right. And what form of assistance were you getting from him?
Well, I started to get a lot of information from Mr. Paul and Mr. Wynn through emails. That included the list of individuals who were, I guess, suspects or somehow witnesses or somehow related to that first initial referral.
And were these people that were to be put on the list of subpoenas?
Some of them were, yes, sir.
All right. And were you receiving from Mr. Wynn regularly information of people to include on the grand jury subpoenas?
Yes, sir.
Now, what was your thought process in terms of your investigation as to why you would automatically put those people on if they're asking? In your mind, you were doing what?
Well, I didn't independently source any of these individuals' name. I walk into this referral and I'm given a lot of information about different people who were involved and how they may be related to that first referral. And so I trusted that was the information that they were giving me was the same information that the Attorney General's office, Mr. Penley, would have already had to conduct his investigation.
All right, so you assumed that you were just getting information that already existed?
Yes, sir.
In the hands of the the AG?
Yes, sir.
But you hadn't talked to anyone in the AG, correct?
Other than Mr. Paxton, that's correct.
All right. And each time that you had a course of action in this case and thought you were going to do something, did you have a practice of contacting the Attorney General to update him?
Yes, sir.
And so as you went along and gathered all this information from Mr. Wynn and Mr. Paul, were you keeping the Attorney General informed of all this?
Yes, sir. I would discuss it on the phone, or anytime I got like a document emailed to me from Mr. Wynn, I would forward that on to the Attorney General's email address. And then when we spoke again, if we did, I would say, hey, I sent you this or sent you that.
So let me see if I understand. Whenever you received information from Mr. Wynn and or Mr. Paul by email, you would then forward that information to the Attorney General?
The majority of the time, yes, sir.
All right. So when they were sending you a list of people that should be subpoenaed by the grand jury, were you making sure you kept Mr. Paxton informed of that?
I'm sorry, do you mean if I sent that information to him, or just letting him know that I received that information, or?
Just letting him know that you received that information.
Yes, sir.
All right. So would it be an accurate statement that as you proceeded in this, well, let me put it another way. As you proceeded in your investigation, and as you determined what to do with the grand jury and what to do about grand jury subpoenas, were you at each stage keeping the Attorney General informed?
Yes, sir.
At any time, did the Attorney General contact you and say, no, don't do that?
No, sir.
So from your own state of mind, in every single thing you did in this investigation, what is your testimony to the jury as to whether you believed you had the full support and agreement of the Attorney General of the state of Texas?
That's true. I did everything at his supervision, kept him informed on everything. When I reached out to Travis County District Attorney's Office and introduced myself regarding the grand jury subpoenas, I mean, I got affirmation the entire time that everything was good, and no one said anything different until I, got a cease and desist letter at the end of.
And so it was one of your frustrations that you didn't have anything official to tell people that's what you were doing. Is that correct?
That's right.
Excuse me. Objection leading.
I'm sorry.
Well,
Sustained.
were you frustrated about the not having any identification and documents and means to tell others in the outside world?
Yes, because yes, sir.
All right. And what was the reason? What was the reason for being so frustrated?
For example, when I had some subpoenas issued for Microsoft, and I got an email back saying, without a governmental email address, we can't execute these subpoenas. So I knew that as I'm continuing to work in the course of this deal, that I would need to have some type of identification, whether it's a governmental email address, some number. I don't know what their processes are, but I knew that I would need some type of credential to be able to do what I was asked to do.
What were you subpoenaing Microsoft for?
Email records, I believe, for certain individuals that were involved in that first referral.
All right. So in the first referral, you were seeking email information, everything from Microsoft about all of these individuals?
Whoever had like an Outlook email address.
And in addition to the people involved in the execution of the search warrant, were you receiving from Mr. Wynn other names that should be added in?
I don't recall all of the names that were on the list.
Oh, yeah. I'm not asking you what the names were, but were you receiving during this time that you were conducting an investigation, continued list and suggestions of people to investigate and to list a grand jury subpoena for?
Yes, sir.
And at this stage, did you reach a stage of discomfort that you were getting all this information from the lawyer of a man that you knew was already under investigation by law enforcement?
I didn't know that Mr. Paul was under investigation at the time. I knew about the search, obviously, but I didn't know that he was under any kind of, at the time, it would have been a current investigation. And then just with respect to Michael Wynn, I had no reason not to trust that Michael was giving me information that he had already collected and that I thought that the Attorney General's office already had. So I thought that whatever he gave me was for the purposes of investigating that referral.
Okay. I want you to look. I'll put some hard copies up there for you. It's in evidence now. Exhibit 678.
678.
And it's going to be Bates stamp. Or do you need a Bates stamp? No. Okay. Thank you. Can you tell us what that is, please?
So this is an email that I sent to Ryan Vassar with this is the same day that I met with Mr. Paxton on 9/4. And when I got back home, I signed the draft contract that they sent me and sent it back, and I asked for an executed copy back. Mr. Vassar had asked me to see if there were any kind of conflicts, so I reached out. I didn't have any clients that had any cases pending where the AG's office was opposing counsel, and I reached out to the State Bar Ethics Hotline and said, hey, is this okay? I don't have any cases pending against them, and they said, it's fine, congratulations on the job.
All right. I'm trying to look at these subpoenas in terms of what's admitted, and I want you, if you would, to turn to 681. I'm only going to ask you to not put it up because I believe that's one that is one that's in evidence. Can you help me out? Look at 681. And identify this for the jury, please.
So this was an email from me to Michael Wynn, and it says sample form grand jury, Google grand jury subpoena.
And then look over to why did you send it to Michael Wynn?
Michael Wynn had initially, so I had never issued a grand jury subpoena before.
Pardon me?
I had never issued a grand jury subpoena before.
Right.
And so I asked Michael, once I put this draft together, if you take a look at it, it's the same information that they had already given me, and make sure that the form here is correct.
And so Mr. Wynn respond to you and tell you it was okay?
He said, form is fine.
And then at the end of the day, what did that help you do?
What did it help me do?
Yes. Did that help you decide how you were going to do the subpoenas and what language you were going to use and everything?
I sent this to him. I mean, I knew he was a federal prosecutor at this point in the past, Harvard educated. I just sent it to him does the form look okay here? So it helped me to know that this was the right way to do it.
All right. Your Honor, I'm looking here. I was having to order up the ones they've objected to. And there are some of these that I very much want to get into evidence. And I don't believe there is a legitimate objection. I'm trying to figure out how to handle this without taking any undue time now. But for instance, if I could, do we have hard copies for the court, Stella? Of these exhibits, do we have any more stacks? Do you have before you 691 without saying anything about what is in context? I want you to identify it for the record and tell us what it is.
Mr. Hardin, you said 691?
Yes. I wrote that down as one you objected to.
I don't have a six. Oh, I do too. I stand corrected. Thank you.
We have that on the list you objected to, correct?
Yes, sir. I'm sorry.
Well, we're waiting for us to see it. We don't have a copy before we can rule.
Yes, sir.
All right. You see 691, would you, without talking about the internal contents yet, would you describe what that document is?
This was an email from Michael Wynn on September 21st, 2020, with an attached Excel spreadsheet that appears to have individuals' names listed there with various demographic information.
Does it list names, addresses, and identifying data that have been blacked out for purposes of this exhibit? But does it list names, addresses, and personal data of people to be investigated and included on the grand jury subpoena?
Yes, sir.
All right. I don't understand what the objection was to that, Your Honor.
Go ahead. I'm sorry.
The objection is hearsay. It's not a list created by Mr. Cammack, but by Mr. Wynn, and it is being offered for the truth of the matter asserted because they're going to...
Your Honor, go ahead. I'm excused if you were talking. No, I thought you were through. Go ahead.
That's okay. It is going to be offered for the truth of the matter asserted because they're going to be arguing that these were the names ultimately where subpoenas were being used on. So objection, hearsay.
There are a series of these, Your Honor, that first of all, not offered for the truth of the matter, only that was provided to them. We are not suggesting that these people should be and were witnesses for the grand jury, should have been a grand jury subpoena. But more important part is, Article 16 is a conspiracy article that says that General Paxton engaged in conspiracy with others. We are not alleging that they engaged in this conspiracy with Mr. Cammack. We are alleging that he engaged in a conspiracy with Mr. Paul and Mr. Wynn. And any statements that are made in pursuant of that conspiracy would be admissible, whether or not it is hearsay. It's an exception to the hearsay rule. I know I am springing that on the court. You might want a moment to think about it or so, but that's why, A, it's not hearsay, but B, even it it is an act in furtherance of the conspiracy.
they are admissible through the testimony of a co-conspirator, not through Mr. Cammack, who Mr. Hardin admits is not a co-conspirator.
Give us a moment.
Pardon me? Okay.
And just, Judge, Mr. President, while you're considering this, I would, based upon Mr. Hardin's argument for the admissibility of it, there is no suggestion that General Paxton created or participated in the creation or the assimilation of this exhibit.
Okay, give us a moment.
Your Honor, if I may, there's a business records affidavit, Exhibit 547, a business record affidavit for all of Mr. Cammack's files. So the idea of this hearsay goes out the window. It would have to be kept out for some other reason. These are all have been certified. Can we bring, if you'd like, I'll bring up the affidavit for you to look at. 547.
Can't put a business record on something that is, you can't make a co-conspirator statement admissible or whatever through a business records affidavit. You okay on water, Brandon? You all right on water?
As you said, Mr. Hardin, you didn't mean to spring this on the court at the last second, but it is to us at the last second. I think this is a good time for a lunch break.
Sure.
And give us a chance to review all of this.
And just for your edification, Mr. President, I think the majority of these, I think, Rusty, correct me if I'm wrong, but I think the ones we're objecting to are very similar to, our objection to these is going to be consistent with the majority of the other ones that you want in, right?
That was going to be my next question, is the objection on all of these
I don't know all of them, but most of them.
Most of them.
Yeah, his objection would cover those, and our response covers all those that were kept out in his records.
Okay.
Thank you.
We may reach out to you during the lunch break. We may not, but we'll come back at 1 p.m. The witness can be excused till 1 p.m. You want to be back at 1? And counsel, can you both come up before you all leave for the lunch break?
Okay. Wow. This testimony is stunning because what you're hearing for the first time is just how intertwined Mr. Cammack's efforts are with Nate Paul's attorney. I mean, he's sending him lists of who you should subpoena. And I'm sure that on that list is going to be our magistrate, our clerk, all these people, all these federal agents that he needs to be subpoenaing. Todd, you were a prosecutor. Is this normal?
No, it's not normal at all. The other thing that is very striking to me that we also haven't quite touched on yet, and I know we only talked for a few minutes when there was a break a moment ago, is this idea that in the beginning of the relationship with the Attorney General in the first few weeks, they set up burner phone accounts that Mr.
Cammack got himself
a phone. The Attorney General suggested they start communicating through an app, and that the emails were not official state emails. He wouldn't give him credentials. The whole operation was in secret, clandestine. Like, we can't let anybody know that you even exist or that I'm in communication with you. Is that the way we want our elected officials to conduct official state business? Absolutely not. Anybody that's listening to this testimony, if you believe what this guy's saying, and why do we not believe it, right? I mean, once again, another witness, another individual coming forward. Why would he want to ruin his career? He's telling the truth. There's no reason to believe he's not. Why would he do all these things and say all these things unless they actually happened?
Yeah, Yeah, I mean, to some extent, I'm almost speechless because his testimony is just so problematic on so many levels.
And then he's just honest. Initially, he said, "Hey, I'd never done anything like this," and to have someone to go through the steps with was Nate Paul's attorney.
He gets contacted.
Yeah.
So his first conversation with somebody about being involved in this is Nate Paul's attorney. Okay.
Yeah.
Todd, you were a prosecutor. If you had a situation like this, let's say, would you consider it odd that the first person you're hearing from is the attorney to asking you to somehow be involved in investigating criminally? The first person you hear from is one of the party's attorneys?
So that's like saying, let's just put it in a state court kind of context. And John Creusot's been a friend for 25 years. He's a elected DA in Dallas County just because we're here in Dallas. That would be like there being a murder case out of Dallas, and the family of the victim has hired myself, someone like me, a private lawyer, to then go out and find another lawyer to do the investigation for John Creusot.
Doesn't that happen all the time?
Never. I mean, absolutely
never.
never.
I mean,
in other words, I'm
speaking
speaking for the family, but I'm also kind of speaking for Creusot because Creusot doesn't want his own office doing the investigation. So I go out and find this other attorney, and by the way, this other attorney has absolutely no experience with a murder investigation at all, and he's been licensed for 5 years, and he has done nothing upon nothing. And I'm going to trust the entire investigation to that private world lawyer that really doesn't know anything from anything. It makes absolutely no sense, and I've never heard of that happening ever anywhere, period.
Other than Paxton and Nate Paul's attorney wanted to control what was happening. And to me, and I know that the phrase "I feel sorry for him" might not work, but he's just a wide-eyed attorney who was just excited to work for the Attorney General, and he trusted everything that was going down, and he didn't think to say, okay, maybe I need to ask questions or get outside of who I'm talking to.
I don't blame him necessarily. I don't place a lot of blame on. I think you're right. I think he thought it was a great opportunity to advance his career. The Attorney General's taking a liking to me. Now, maybe did he go to bed at night going, why did they pick me?
I know.
If he was
honest with himself.
He should have.
One of the questions I would be asking is, you talked about your father quite a bit, being this experienced criminal lawyer from Houston. He even said, I had been in press conferences with my dad on some of his high-profile cases. Clearly, his father's got some credential to him. Did he ever go to his dad and say, listen to what I've been asked to do, and here's the things that what do you think about this? What should I be doing? What should I be looking for? Did he ever lean on someone that's got some more experience that would be honest with him and say, something doesn't smell right here?
Yeah, and it strikes me that, when he's asked, if he's ever done a public corruption investigation, he says that I had not ever done this before. And then he's asked, well, did you consult with anybody about how to do it? Well, no. I mean, he's talking to Ken Paxton throughout this, and he's talking to Michael Wynn. But Ken Paxton was a real estate attorney.
Yeah.
He was not, this would not be Ken Paxton's area of knowledge. Now, it would be Mark Penley's. Mark Penley, David Maxwell, well, they would be your experts on conducting a criminal investigation.
That's correct.
That's who you would turn to. It just, and again, we haven't gotten to it yet, but I'm almost positive the prosecution's going to introduce into evidence these recordings of Michael Wynn going out with Brandon Cammack to deliver grand jury subpoenas to banks.
That is crazy.
To banks. Now, these were banks that were connected to the Mitty Foundation situation. The Mitty Foundation was this foundation that had invested in Nate Paul's companies, and Nate Paul wasn't paying up, wasn't paying what he was supposed to do, and so there was this huge, long-running lawsuit. And again, I have never heard of a situation like that.
No.
That is stunning.
It's bizarre.
You can't even wrap your mind around how unbelievable this is. And, just the whole description about he keeps trying to get credentials, trying to get an email.
The thing with Microsoft, he says, I've never done a grand jury subpoena. The first time I did one, I subpoenaed Microsoft's records. And Mr. Harden says, you did what?
Yeah.
I said, you subpoenaed Microsoft for what? He goes, well, I don't really know. I'm not really sure what I was subpoenaing them for, but I just felt like I was.
Doesn't run.
They said they sent him
emails,
a response back. We're not going to give you our records. You don't even have. It's like he was used a Hotmail account of some sort to try to.
I mean,
You know what? Again,
but he still seems kind of wide-eyed a little bit.
Well, I think now he just wants it over with.
I'm
he
sure
wants to
he
go on
does.
his
He wants to go on his honeymoon.
But you know what? You still have to. The more we hear the evidence, the less you wonder or either suspect why the House impeached Ken Paxton. I mean, they didn't have anything else to do but impeach him, or they would not have. I mean, it's just not to have impeached him. And I'm not saying that how it will end, but only that they had the responsibility to do something.
Sure. And the impeachment by the House is akin to a grand jury indictment.
Right.
That means there's enough evidence, enough probable cause for this to proceed forward to trial. And that's exactly what we're seeing. This is how it's supposed to work.
Yeah.
Here's the evidence. Here's the testimony. This is what the public deserves to see. These are our elected officials, a statewide, high-ranking elected official. This is what we deserve to be able to see.
And it's mind-boggling. I can't wait for the movie. I mean,
you're going to write the book,
because you just don't. Oh, I wish I could, but you just don't see this. You just don't see it. And those people who are not watching or listening or whatever, I think they were paid to go to a movie theater to see this. It's amazing.
Well, it is amazing. And one of the things that I'm going back in my notes that Paxton's team has made a big deal out of this idea. Well, he wasn't really a special prosecutor. Yet he talks about in his August 26th meeting with Paxton that Paxton said he was looking to hire, quote unquote, a special prosecutor.
What did the contract call him?
Well, the contract. Well, the initial contract drawn up by Vassar, I think, it was very limited in scope.
Right.
He was not supposed to be, quote unquote, carrying out an investigation. But that's not the contract I believe that's the one he ultimately signed, because that was the one where Penley refused to approve it, and that became kind of the hill that Penley decided to die on, because he was not going to approve this contract. They have not. I don't think they've introduced into evidence the contract he ultimately signed. I mean, that's the whole issue. And if everything was on the up and up with the hiring of Brandon Cammack, why was he never paid? Right? I mean, if everything's kosher, why is he not paid?
Right.
Yeah. Remember, Missy Carey said that the way that he went about doing it, there was no funding. So the question, how was he going to pay him?
Yeah, and again, to this day, he's never gotten paid. I mean, that's what that's what they testified to yesterday, or that's what, actually, I think it was Busby that said that. Busby's the one that said, when it's obviously going to be Dan Cogdell who's going to end up crossing Cammack. What does he got to do? Is there much he can do with Mr. Cammack?
You know what? If he does, then he's going to discredit his client, because you have, in order to discredit him, then he has to come out and say, okay, did he not do this? Well, yeah, he did. Okay, did he do this? If it were me, but you know what, they haven't done a lot, and I'm not an attorney, I'd pass him.
Hey, folks, the link that was posted, I think they just posted it. You need to look at Exhibits 2 and 3. If you look at Exhibits 2 and 3, click on that link. It will take you to that video recording. But don't leave the live stream to go do it. Do it later. But okay, Todd, you're the attorney. If you were going to be the cross, what would you do?
I'm trying to see where the weaknesses are and where he can come after him. I mean, I haven't seen it yet. I mean, I don't think he can pass over him. I think he's got to ask some questions
But do you spend much time with him?
I don't know. I mean, I'm not really sure what he can get out of him that will help the Attorney General. It's something I'd have to give a little bit more thought to before I could decide what exactly. He's got to have something, and it could be something that he has. You know, they anticipated, I'm sure, that this witness was going to testify, and they could have had something prepared well in advance of, you know, that stuff that he hasn't even said yet. So I'm not real sure yet what I would do strategy-wise to come after him, to attack him.
Yeah, I'm going to be real interested. And then, of course, Rusty Hardin's not done. We still have not gotten a ruling on this email that Michael Wynn sent, which is the list of, these are all the people, well, one of the emails he sent saying, an Excel spreadsheet of, these are all the people you need to go investigate. Wow.
It's crazy.
There may, in fact, be a movie on this one, for sure.
Yeah.
All right, folks, so we're going to take a break for lunch, and we're going to come back. We're going to come back at 12:45, and we're going to chat over lunch, and we'll be back, and we'll see where this heads when they restart at 1 o'clock. Thanks for joining us. Well, folks, we're back. We just had lunch. I'm Tanya Iser. We're here, investigative reporter here at Channel 8, joined with Todd Shapiro, an defense attorney up in Collin County, and the son of former state senator Florence Shapiro. If I'd planned it, I couldn't plan it better, but I didn't plan it because I don't think I realized the connection. And of course, Bernadine Steptoe, who is our WFAA's political producer, who knows all things political. Maybe as much as Bud Kennedy or more. What do you think? I already did this. I'm sorry. I just can't resist. Because I know Bud is watching.
County.
That's why I'm.
Depending on the county, Bud.
So we've been listening to this testimony from Brandon Cammack. He is the young attorney who was hired by Ken Paxton to carry out this really complicated public corruption investigation. Todd, would you generally hire a young, inexperienced attorney who's never done a public corruption investigation to do something like this?
Well, I mean, number one, I wouldn't hire an outside attorney if you're the Attorney General's office, a district attorney's office, unless there was an inherent conflict within your office, a conflict of interest, or somebody that's connected, a victim or a party that's connected to your office to where you cannot be objective and you can't carry out your official duties that your office has an inherent conflict with, and you need to go out and hire outside counsel. A lot of times what will happen is, again, I keep referring back kind of to state court, whether it's a district attorney's office, they'll bring in another DA's office. Let's say Dallas, John Creuzot has a conflict with one of his cases. He'll get Rockwall County, Collin County,
right,
Denton County to step in and prosecute the case. They won't go hire a lawyer with one paralegal or somebody that's got 5 years of experience.
You think John Creuzot
would have found this guy?
Yeah.
I don't believe so.
Well, I know John Creuzot, and I
not.
think that's really
and
unlikely.
again, John Creuzot represents one county in the state
Right.
of Texas, doesn't represent the entire state of
Right.
Texas the way Ken Paxton does. Let alone, would John Creuzot be making all the phone calls to this individual? Would he be emailing and texting?
Let's go download download Signal.
And not only would he not be doing that, would he be doing it in a secret fashion? So there's all these separate questions that you can continue to ask that have the same answer. Not only no, but heck no. Absolutely heck no. And those questions that have no answers to them just continue to add up in this case. This witness, we mentioned it at the break, we talked about it, is extremely damaging to Ken Paxton.
And he doesn't strike me as a guy who's trying to hurt Ken Paxton. He seems like he is pretty just honestly recounting how he became involved in this case. And we have to say it again, the first person he talks to about becoming involved in this situation is Michael Wynn, Nate Paul's attorney. Yep. I cannot imagine a circumstance where John Creuzot or let's talk about the Kaufman County District Attorney. I can't imagine Early Wiley doing something like that. No way. It doesn't pass the smell test as to why you would do that. And then Cammack is so inexperienced that he doesn't think he needs to go out and consult with anybody about how to do this, and he doesn't know how to do a grand jury subpoena, so he consults with Michael Wynn about how to do it. The person that is representing the party, and Wynn is sending him lists of people that he needs to subpoena. Mm-hmm. I don't know. I think before they went on break, they were trying to get this email in that Wynn had sent with this Excel spreadsheet, and this Excel spreadsheet, based on what I understand, is going to have a list of the people that they wanted subpoenaed, I think, from the first referral. Is there any reason not to let that in, Todd?
Well, I think the issue is whether or not it passes the evidence smell test, so to speak, whether it is admissible evidence, because it could be inherent hearsay. Has the proper predicate or foundation been laid to show that it's authentic, number one, and number two, if this is a hard phrase to understand, and it took years of law school to get it, and even in practice, if a document or a statement is being offered for what's called the truth of the matter asserted, meaning we're trying to get it for what is being purported in the document, and it is hearsay, then there has to be some form of exception to the hearsay rule for it to be admitted into evidence. And that's what Patrick and Judge Myers are probably trying to figure out. What is the proper ruling with regard to the objections that are being made from the defense team?
Okay, Judge Shapiro, what is the proper ruling?
I haven't seen the document, so it's kind of hard for me to say whether it should come in or not, but I can see the problems of it coming into evidence, and I can see the objections that are being made, and they're legitimate. They're the right ones. The question is, I'm not real sure with the document itself what it shows and what they're looking at, because they're not showing it to us on the TV as they're, he's talking about these documents they're looking at in the Senate chamber, and we're not able to see them on the stream.
Yeah, and that's one of the things they're doing is with the exhibits, they're not showing. So in this particular case, this document would not be shown on the senator's screen yet, but whenever they have a document, they're showing them on the iPads of the senators, but they're not. Our cameras are not allowed to show those documents. That's part of which is kind of unusual for a trial. I mean, and normally in a televised, well, this is not normal. Nothing about this is normal. But normally in a live stream trial, you would train your camera on whatever that document is, but that's not the way. The rules don't allow that. Bernadine?
I'm just listening because you all are talking about, that's out of my league in terms of what they're doing on a legal basis. But this last witness, and I'm going to just say the last witness, I totally agree that he is damaging to Ken Paxton. And he just appears to be this wide-eyed new attorney.
Even now.
Yes. And he's just up there trying to tell his side and just get through the process so he can get ready to go on his honeymoon.
I feel kind of bad for the guy. He can't even take his honeymoon.
I do. I really do. Because he just, according to what I'm hearing, he just saw this as an opportunity to work with the AG. And then, you know what, his ego actually got in the way in the sense that he was hearing from the AG himself. I'm so important that the AG is actually calling me and talking to me. So if anything, if he should put that in check next time. But
I don't think there's going to be a next time.
Well, next time he's approached. Well, you're right.
I don't think there'll be a next time.
You're
for Mr. Cammack.
You're absolutely right.
Have you ever been a special prosecutor?
No, I have not. So I spent 3 years in the DA's office in Dallas, got exceptional training. The Dallas DA's office is great today. They've got a lot of good prosecutors down there, but it was exceptional when I was there. Over 20 years ago, some of the best lawyers in Dallas were trained under some of the people that I was there with. The first assistant in Dallas, or in Collin County now, Bill Worski, who you know well, trained me, and I still use a lot of the stuff that he taught me way back when in trials today. So it's stuck with me for that long. There were so many great lawyers that came out of that office from that era, the late 90s into the early 2000s that have now gone on.
Like
Toby,
that?
exactly.
Yeah.
And so once I was done there and I went into private practice and went into defense work, I never kind of looked back, and that's what I've been doing ever since.
But this description of how to get a grand jury subpoena, I mean, he's never gotten a grand jury subpoena before.
It's just
he consults with Michael Wynn.
It's bizarre. And the other thing I was wondering is what makes him think that Michael Wynn knows how to deal with a grand jury subpoena? I mean, I guess he said, he was a former federal prosecutor.
Yeah,
how did he know that? Did he do enough research on Michael Wynn to know what his background was?
He didn't say exactly how he knew Michael Wynn was. I guess he just knew. No, I think because they had done some stuff together. They had been a Rotary together, and they had done. Didn't he say they had done some kind of continuing ed thing together or something?
Well, he had been on a panel for Wynn.
Okay.
So he knew Wynn before then. He just didn't know him as a friend or whatever. But I think professionally he knew him. But it's just interesting. But you know what? Wynn saw something in him that made him think that the guy would be gullible?
I mean,
controllable, maybe. That he would be open.
I mean, that appears to be the case.
Yeah, that he'd be open to being controlled. That we could steer him in the direction we want. So let's go grab this guy. He's young, he's hungry, he's smart enough but not too smart. He's got a nice small little practice that he can be taken away from it. He doesn't have too many cases. I mean, it seems like maybe he checked all the boxes that they were looking for somebody to serve in that capacity. And, it looks like they were right for a time being.
They were right. He did it.
Was it unfair to put Brandon Cammack in this position?
By who? Unfair to who?
By Ken Paxton and Michael
No,
Wynn. I mean, because
no.
now he's been castigated. I mean, he's kind of painted as a,
Well, he could have said no.
He could have said no.
Well,
Or
it
as he
did
got
not-
going, he could have gone, wait a minute, this is not what I thought it was going to be. I'm out.
I also
Yeah,
come from the school of belief that if something is too good to be true,
It is.
It is.
probably is.
Yeah, it
I
is.
mean,
And
whenever
I think we mentioned, how about asking some people you lean on in the legal community, including your own father, who is a very experienced trial lawyer and been in the Houston, legal community for a number of decades, according to his own son, and according to Brandon. Hey, Dad, let me tell you about this opportunity I just got. The Attorney General of Texas just called me, wants me to come down for a meeting and serve as a special prosecutor. How about that? And Dad goes, I'm sorry, what?
Well, and then
yeah.
special prosecutor
For
with
what?
the AG doesn't have.
I mean, just how about ask some questions?
Yeah, I would be interested to know why he didn't seek other kind of influence or whatever. That's a question.
I guess he thought he had what he needed by talking to Wynn and Paxton.
Well, I don't know about Wynn, but definitely the AG. Why would you think the AG would not be someone you could trust? So.
Yeah, I don't know. Well, and the AG does not have experience. His background, even though he's an attorney, but his background is as a real estate attorney. Ken Paxton's background was not as a criminal attorney. It's not like Todd or some of because all the guests we've had on here, all the legal guests are people who practice trial law.
Right.
I mean, which is why they're the kind of people I pick, because I want people, and they come from, different backgrounds. Some of them been federal prosecutors. And like one of the guys we had last week was actually a former public defender. I mean, people, different backgrounds, but who all have practiced in courtrooms. That is not Ken Paxton's background at all. He primarily did real estate, and so it just, I don't know.
But isn't it Wynn's background?
It is. Wynn
So
was
I
a
guess
former
he was-
federal
yeah, he was-
prosecutor.
I know this is just speculating, but apparently, number one, Paxton got what he wanted, and he was depending upon Wynn.
Where do you think Rusty Hardin's going next?
I don't know. I wonder how much more he has with him. I guess I'm also wondering, how did the relationship between this special prosecutor and the AG and Nate Paul and Mr. Wynn, how did it end? When did it sever? When did it become no longer a working relationship? Because I'm not sure I know that.
Well, I mean, obviously he gets the cease and desist letter on October 1st, 2020 from Jeff Mateer. Does he talk to Ken Paxton after that letter comes?
How does it all finally stop? And why? He obviously put some time and some work and some effort into what he was doing. Why did he never press forward and say, "Okay, if I'm done, where's my money"?
Well, I think
I
he
mean, I signed
probably
a contract.
did do that.
He sent bills, invoices.
Just never got paid?
He never got paid.
Okay, so why wouldn't he have sued the AG's office for? I mean, look, you signed a contract, pay me.
Yeah,
or something.
There's a lot of questions here and maybe they'll get to that.
Maybe, yeah. What about all the time? I mean, I guess you're probably gonna ask him. You signed a contract for $300 an hour. You work for X number of hours, right? So how much money are you owed by the Attorney General's office?
That you didn't get paid.
You didn't
And
get
why
paid.
didn't they
Why
pay
didn't
you?
they pay you? Did I ever give you an answer?
Right, and what was the explanation for why you didn't get paid? And of course, and if it wasn't Ken Paxton that said that answer, they'll say hearsay.
Right. I mean, well, did you ever ask the Attorney General why you haven't gotten paid, or did he just stop talking to you?
Well, these are all very
question.
interesting questions.
Very good questions.
I think they've Rusty Hardin has largely built this out chronologically.
Right.
Right.
Which is the way to go.
It is the way to go.
It's the
because
logical way.
It's the logical way. I mean, I know a lot of times whenever I'm telling a story, I typically will go chronologically.
Absolutely, because otherwise you get lost in going back and forth.
In fact, I've had a couple of occasions whenever I tried to deviate from that, my boss said, no. Go back and be chronological. It helps people follow.
Sure.
But you know what? Now he has less time and he's still using up the time. Okay, so what, does he not intend to cross? Or the defense is never going to present witnesses?
Because he's going to run out of time?
Yeah, so what happens? Now according to the time this morning, the defense had more time.
Right.
And they haven't used up a lot of it.
I wrote down
So
the
what happens if, I mean, it's going to be interesting if the prosecutors need to cross and they don't have any time.
I agree. Maybe they're just anticipating that this defense isn't going to call anybody.
Or either what they've laid out, maybe they don't need to cross him. I don't know, but that has sort of, I've wondered.
Well, they'll have time to cross him because as of this morning, the House had 9 hours, 19 minutes, and 12 seconds, and Paxton's side had 12 hours, 14 minutes, and 15 seconds.
Well, certainly the defense has time. What I think that what Bern is saying is, if the state continues to use a lot of their time in direct, because this is certainly not the last witness that they're going to present. The more time they use, the less time they're saving to start crossing some of the
defense witnesses.
That's true.
If they're already.
That's true, but Cammack is a very, very critical
I agree with
witness.
that.
I mean, he
Got to
is.
be thorough with it. Yep.
I mean, he is because all the testimony and the evidence and the documentary evidence that's been presented here indicates that it is this situation, these subpoenas, that is the straw that breaks the camel's back. It's not all the other stuff. The other stuff is made people nervous. They don't like it, but this.
Yep.
Because once you jump off into using the grand jury process, in their view, to go after enemies of Nate Paul, then that is where Penley and Mateer and Vassar and Banger and all these people basically draw the line in the sand. That's the line in the sand. In fact, I don't know that if that hadn't happened, in other words, if Ken Paxton stops with the other stuff, I don't think we're here today. I don't think we ever get to this particular point.
Who knows? But Ken Paxton did a lot to alarm people.
Yeah.
To alarm people, because you even had Margaret Moore talking about, she was alarmed in a sense. So I don't know, but it's just going to be interesting to see how it continues and plays out.
Well, I'm looking here at the live feed on the Senate. I see Cogdill back in the room. I see some of the attorneys. There's Rusty Hardin. He's back up at the podium, but we don't.
So looks like the senators are.
Oh, okay, there it is. There's a live look. Okay, so we can see some of the senators.
No Patrick.
No Patrick.
This is
not
now
yet.
the second time he's been tardy. Everybody says he's so punctual.
Well, it's just, today has been an unusual day, and we never got an explanation for why it took us so long to start. And we're still, of course, when he comes back, waiting this ruling.
Yeah, some pre-trial issues.
Some rulings, yeah.
Well, he might be working on the ruling, trying to, talking to Lana Myers to decide how they're going to rule. Because I suspect this is not the only email that Hardin is going to try to bring in that they've already objected to, and I mean that would be my guess. So,
well, if I'm not incorrect, I think that most of those documents that he was not letting in, or he was not approving, I think they dealt with this hearsay stuff. So maybe that's what.
Well, it's communications. I suspect. Well, it's going to be because it wouldn't if it was communications from Paxton, then hearsay wouldn't apply, right?
Sorry.
If it was communications from Paxton.
Anything Paxton says is not hearsay.
Right.
So it's called admissions of a party opponent. If it's the defendant, the person on trial, whatever you want to call it, anything that's said or done by the defendant is not hearsay by definition.
Right, but so these other emails or these other exhibits that they were
Any
fighting.
lines of communication from Paxton himself, not hearsay.
Then
Email is like a spoken word.
Then it's probably like this one is an email from Wynn.
That's
I'm
different.
guessing there's other emails from Wynn, and because he mentioned that Nate Paul had also emailed him, so I'm
different.
guessing there's some other emails from Nate Paul that we would very much.
So those emails, if they're trying to get those in, they got to come up with some sort of creative exception to the hearsay rule, because otherwise those are very clearly hearsay. Those are
I don't like
out of
this.
court statements being offered for the truth of the matter asserted. That's the definition of hearsay.
I kind of don't like this rule right now. I mean, this rule feels
Take
limiting.
it up with the rules of evidence.
It's just right now I'm like, I would like to see this. I want to hear this. I mean, why? Let me ask you this: why adhere to those rules of evidence in this?
Well, I mean, that's why adhere to the rules of evidence is your question.
Yeah, why? Why adhere to that? I mean, you're allowing the jury to vote on motions, which is not something done in a normal court. So why even do that? Why adhere to that?
Why?
I mean, because it's like you're picking and choosing what parts of a criminal trial you're going to adhere
Well, I mean,
to.
and the rules of evidence apply to a civil trial as well. I mean,
I'm just throwing it out there.
if it's that's a good question.
I like to stump
That's a
the
good question
lawyers.
because there are some judicial proceedings that the rules of evidence do not apply to. There are some hearings and some administrative hearings that we have where rules of evidence are not in play, that really anything comes in. So I don't know the answer to that. I guess that would be a question for the, I'm assuming they probably took a vote on that when they were passing the rules, when they decided what the rules for the trial were going to be, and they voted that the rules of evidence would apply.
Yeah.
I guess that was probably something that was in front of them that they debated and discussed, and they thought that that was appropriate for this type of trial.
Do you think it was a mistake for the prosecution to agree to such a short timeline to present their case?
Now, I don't know if they agreed to that or if that was
Yeah, did they have a
decided
choice?
by the presiding.
Yeah.
They didn't make a lot of public objections to it.
I think the operating word is public,
Yeah.
because they could have, yeah.
Maybe they think that's plenty of time to present their case. I mean, I don't, it doesn't look like they're trying to speed through it, like, oh, we're going to run out of time. I mean, who knows how many witnesses they have left?
I mean, they have yet to get into the renovation stuff. I mean, I
Right.
keep going back to that. The reason I go back to that is just because that's one of the impeachment articles.
I mean, they have, and they've really barely touched on the affair, and I keep bringing that up too because that's a pretty big player in this, even though the affair itself is not at issue necessarily, except for his fitness to hold office. It's the cover-up of the affair. It's the office resources. It's the security. It's all the things that were going on.
And it's Nate Paul employing her.
It's all the bribery.
And we haven't even talked about the Uber account.
Yeah, that's right.
Creates an
So
Uber
again,
account.
and all those things, amazingly go hand in hand with, you had a burner phone and he wanted you to text on an app that, a secretive app and an email that wasn't a real email, which all falls in line with all the allegations with regard to the extramarital affair. And, so it's like a common theme starts to emerge here.
Well, and then perhaps they'll get to it. But I think that they do recognize that how you deal with it and how you talk about it could be risky. And that they're taking their time. Because it could definitely be risky.
Well, one of the things that they're talking about, we were talking about open records. You're mentioning the burner phone and or using alternative methods of communication, whether it's Signal or Proton. The Attorney General's office is duty-bound to uphold open records law.
Sure, I would say so.
And so
if they're not, who is?
And so it's really problematic for the AG to be conducting official business outside of his official AG
All rise.
account.
The Court of Impeachment of the
Here we go.
Texas
Let's
Senate
take a
is
listen.
now in session. All rise. The Court of Impeachment of the Texas Senate is now in session.
Right.
To both parties, you gave us a lot of homework during lunch, I'll assure you.
We're just trying to assure you keep your day job and don't ever wander, Your Honor.
Yes, sir. Can I have both parties come up? Mr. Harden, both
Yes, sir.
parties.
Okay, so we can see that Dan Patrick has the attorneys up there at the bench. He's been on the break, as he commented, said that they were given a lot of homework. I guess him and Lana Myers, and they're clearly discussing these exhibits. These are the exhibits that the prosecution objected to. What do you think that discussion is up there at the bench, Todd?
I don't know if it's necessarily about that still. It's really hard to tell what it is that they're discussing. Maybe it is about the exhibits. I don't know. It's really, to guess or speculate as to what these sidebar conversations between the attorneys about is kind of a dangerous game to play, because you really just don't know what it is that they're talking about. If they wanted everybody to know what it was, it'd be on the record and be out loud. So it's just kind of a difficult speculation as to what they're discussing. It's probably not about what they had for lunch. That's probably...
No, I seriously doubt it's what they had for lunch.
But it's got something to do with something that's, admissibility, maybe about what they're anticipating may be coming, but it's certainly animated. You're probably correct in regards to the emails. That's probably what they're discussing, but I don't know the answer.
Well, I mean, the emails are a guess.
Yeah.
I mean, that's the guess, because
Since that seems to be the issue in front of them right now.
Well, because the defense wants to keep out these email. Well, we know one of the communications is an email from Wynn, which has an Excel spreadsheet of the people that Nate Paul that they wanted investigated. But while they didn't say what the other exhibits were they were objecting to, based on the context, it seems like it was most likely other communications from Wynn and other communications from Nate Paul. That seems like the most likely, logical explanation for what's happening. But it looks like they might be about to wrap this up. Let me go look at the other feed. Yeah, no, they're still up there. You still got Rusty Hardin and Dan Cogdill right up there leading the charge, trying to. These guys are these are legal lions. I mean, Dan Cogdill, Rusty Hardin. They're legal lions in Harris County, not Dallas County. Because I know on day one I kept getting their names mixed up, because they're just not people that I have dealt with much up here. They're not part of our. And Todd, does it seem like that the Houston attorneys are a little different than what we have up here in Dallas County?
I don't know about different. I think Tony Busby's a little different. Rusty Hardin's a legend. I mean, he is as good of a criminal defense lawyer. I know he's a prosecutor. They just broke. They're all great lawyers. I mean, there's no question. They're here for a reason.
Okay, let's take a listen.
Just clarify what you did. Just let me focus on that. You do that.
These are the 5 that are showing intention.
Court's back in session. Mr. Hardin, Mr. Cogdale,
Yes,
we're sustaining the objection on 686 and 691. And then the other ones we'll bring up one by one as we walk through.
Yes, sir.
So 686 and 691 will not be admitted. Bailiff, call the witness. Mr. Hardin, your witness, and now we'll start the clock.
Thank you, Your Honor.
Mr. Harden, that saved you some time on the clock by resolving some of those issues. So you got your extra 5 minutes. Okay.
Thank you, Your Honor. Something just came up at the well, how do we pronounce your name by your preference? We've said Cammack, we've said Cammack. Cammack. All right. Thank you. Mr. Cammack, I have several documents I want to go over with you. I first want to show you and ask you to look on that hard copy you have there. Do you have a hard copy of 649 with you up there?
Let me take a look. Yes, sir.
All right. And I want you to look at that 649 and without testifying as to the contents yet, tell me if that is a document that was prepared by you.
No, sir.
All right. Who was it prepared by?
This document was prepared by Michael Wynn.
By Michael Wynn?
Yes, sir.
And would you tell us the circumstances real quickly as to how you got that document from Michael Wynn?
This was emailed to me.
Emailed to you? Did you ask for it?
No, sir. This was unprompted.
All right. And then in this particular document, it's still not in evidence. I have a couple more questions for you.
Yes, sir.
When you received that from Michael Wynn.
Mr. Harden, excuse me. So there was an objection on 649?
Yes, sir. I haven't asked him questions about the content yet for that reason.
Because I'm going to sustain the objection on 649.
But I understood at the bench you wanted us to extend a predicate if we were going to try to overcome it. That's all I'm trying to do. But it's not in, you understand as a lawyer, it's not in evidence. Objection's been made, preliminary sustained. I'm being allowed to ask you a few more questions about it without describing the contents.
Yes, sir.
Okay? Now, when this particular document, and notice here, you forwarded that document to whom?
I sent this document to Mr. Paxton.
All right. And in the case of Mr. Paxton, when you sent it to him, is this an example of how you kept him informed of things that were being done?
Yes, sir. This was one of the ways.
All right. And this particular document, then, did you, as you then that you got from Mr. Wynn, did you use it as a basis to prepare any documents yourself?
No, sir.
All right. Did you do anything with this document?
No, sir.
So, is it your testimony you received this document from Mr. Wynn, you passed it on to the Attorney General. Did you and the Attorney General ever discuss this document?
No, sir.
Did you ever have any personal or over-the-phone contact with the Attorney General about this document?
Yes, sir.
All right, when was that?
It would have been around the time that I received this on this 9/16 date, but I don't recall the exact date that I spoke with him.
Can you discuss that conversation without referring to the contents internally of this document?
Yes. Just like in other things that I forwarded to Mr. Paxton, if I had a conversation about it, I would have said, yes, sir, I sent you over something that I got from Michael Wynn or Nate Paul, or Michael Wynn, actually.
Did you represent Mr. Paxton personally, individually?
I'm sorry, could you?
Did you ever consider yourself Mr. Ken Paxton's personal lawyer?
No, sir.
All right. And at that time, had you been retained by, I believe you testified, the Attorney General's office, is that correct? Or who did you think you had been hired by?
The Office of the Attorney General.
Okay, all right. So now, was anything with this document done in your preparation for any of the things you did?
No, I believe I skim-read this document and just sent it on to Mr. Paxton.
Without ever discussing it with him or anything?
Just discussing that I'd sent him over what this document is, but not going into any detail about what was in this document.
And is this a fairly typical process you had through this whole representation during the investigation?
The process of forwarding him emails and maybe discussing things with him?
Yeah.
Yes, sir.
All right. And were you regularly getting emails from Mr. Wynn that you would just pass on to the Attorney General?
I don't know about regularly. I would just have to look at the emails that.
Let me change the word regularly. Then would you frequently pass on to the Attorney General documents or emails you were getting from Mr. Wynn?
I had sent him some things. I just don't recall what those specific documents were. So I don't know if I can say that I frequently did it, but I did send him things and this is one example of it.
All right, and then let me ask it another way. Finally, that's all I have on this. Did you attempt throughout your representation or throughout your retention as investigator, try to keep the Attorney General updated on all of your activities?
Yes, sir.
All right. Your Honor, I'll ask the court to reconsider the exclusion of 649. There's a basis here. There's no privilege from anyone. There is on this document. Their business record had been filed with this. It's covered by a business record. There is no statement here by anyone other than Michael Wynn. It is not hearsay, though, because he's not making a statement that's being forwarded somebody else's statement. And so for all kinds of reasons, I respectfully request that this be admitted.
May I speak with Mr. Cammack, sorry, Brandon Cammack, on the predicate question, Your Honor?
Yes, you may.
Mr. Cammack, if you could look at the top of House Manager's Exhibit 649, and I think the fourth line down regarding the subject, it says, does it not, discovery plan dash work product?
Yes, sir.
I'm assuming based upon your designating the document with that description that you considered this to be part of the work product that you were performing in your role as an outside lawyer for the Attorney General's office. Correct?
Yes, sir.
You acted like that was a trick question. It wasn't meant to be.
Okay.
So would you agree with me, Mr. Cammack, that the act of reviewing it and then forwarding it was consistent with your description at the top of being work product? Agreed?
Yes, sir.
So it would be covered by the work product privilege, Mr. President.
So your objection is work product?
Yes, sir.
Your Honor, the work product privilege on this document belongs to this witness and witness alone. And the question would become, if he considers it his work product, he's produced it to us, which waives his work product. And I suspect he would concur again that he's not claiming the work product, and he's the only one in this equation that has the right to, and he's provided it to us voluntarily through this production. So it's waived, even if he did. But
with respect, I don't agree with the last.
I've never heard of a third party waiving somebody else's work product privilege.
I'm simply directing the witness to answer the question, which is it was sent pursuant to. I'm sorry. Brandon, are you okay on water? You good?
Yes, sir.
We will sustain the objection on hearsay.
Yes, sir.
Mr. Cammack, did Michael Wynn, what is your testimony as to whether or not he regularly or frequently throughout this kept providing you information to assist you in your investigation? Did he?
He did send me information throughout the course of this investigation.
Many times was it unsolicited?
Towards the end, it was.
All right.
Yes, sir.
And would he send you things that were to be, that gave you names that he was trying to get you to issue grand jury subpoenas for?
Objection leading.
That's not leading. That question was, would he do so-and-so? He can answer yes or no. It doesn't tell him which answer to give.
Overruled.
Thank you.
I'm sorry, could you?
Yeah. Would he? Did he send you things did he give you names that he was trying to get you to issue grand jury subpoenas for?
No, sir. Not in. he gave me names in an Excel spreadsheet that I think we discussed, but it was never, these are the people that you need to.
But Mr. Cammack, did he also?
Excuse me, may the witness be allowed to finish answering the question?
Certainly. I thought you were through. Were you through?
Are you through, Mr. Cammack?
Pardon me?
Yes, Judge. Yes, sir.
Thank you. Now, what all the kind of information was Mr. Wynn regularly providing you, if he was?
I'm so sorry.
Was he regularly providing you information?
Yes.
And what type of information was he providing you?
There were a couple Excel spreadsheets that he had forwarded to me that had the names and demographic information of individuals as they related to the referral that I got. There was a timeline that I was given early on. There was a memo that was provided to me, like a prosecution memo. There was, and as I sit here right now, I can't think of anything else.
Would you look at 650 up there, please?
Yes, sir.
All right. You've got 649 already. We talked about that, correct? The contents are not in evidence. You looked at, we talked about that, did we not?
Exhibit 649, yes, sir. We talked about it.
And now you've got 650 in front of you?
Yes, sir.
You just mentioned a prosecution memo that he provided you?
Yes, sir.
And what was the purpose of him giving you a prosecution memo?
Objection, conjecture, and speculation.
Sustained. Just rephrase it.
Excuse me, I'm sorry. What was the stated purpose of him giving you a prosecution memo?
That was also an unprompted email to me with this prosecution memo.
Were all of these things he were provided designed to help your investigation of the allegations of Mr. Paul?
The information that he gave me was helpful to my understanding of what the investigation was about and what was to be done.
Yes. And of course, you were conducting an investigation. Your view, you've mentioned before, was that Mr. Paul was your sort of complaining witness as a prosecutor in your mind, correct?
Yes, sir.
Okay. And were these different things that Mr. Wynn was providing you, were they intended to help you in your investigation of the complaint that was filed by Mr. Paul?
They were helpful to the investigation. Yes,
all
sir.
Right. Okay.
I don't know what, I'm sorry, I don't want to speak for Mr. Wynn about what the intention was, but they were helpful.
Well, Mr. Wynn was representing Mr. Paul, wasn't he?
Yes, sir.
We can kind of agree, can't we, that he's not going to be providing things to you that are harmful to Mr. Paul? Can't we agree on that?
Yes, sir.
Okay. So would you agree with me as you think about it, that Mr. Wynn was frequently providing you with information that was potentially helpful to Mr. Paul's complaint that you were investigating?
Objection, leading.
Sustained.
Were you getting information regularly from Mr. Wynn? Number one, were you?
Yes, sir.
And was that information designed to help you in investigating Mr. Paul's complaint?
It was helpful.
All right. You know it was helpful then, right?
Yes, sir.
All right. Did Mr. Wynn provide you a prosecution memo for you to adapt into one of your own?
He's provided the prosecution memo to me, unprompted, but that was kind of my jump off point for the investigative report that I was going to ultimately put together and turn back into the Attorney General's office.
Yes, sir. He actually, did he not, provided you a prosecution memo that is 650 that was designed for you to help write your report at the end of the investigation. Is that a fair statement?
Objection, leading.
Sustained.
What was the purpose of this prosecution memo?
I viewed it as giving me information about everything that had happened. More detailed information than just the timeline that I got initially at the first meeting.
Yes, sir. It was all information from the perspective of Mr. Paul, was it not?
Objection, leading.
I'll ask you another way. Was this information, excuse me, was this information offered to you for help, Mr. Paul?
Conjecture and speculation. He can't know what the purpose of it was.
I'll overrule.
I'm sorry, could you repeat it?
You can answer the question. Was this information provided to you to help Mr. Paul or to harm Mr. Paul?
It was helpful. It was helpful from my perspective to be able to wrap my mind around all of the different moving parts within that investigation.
All right, sir. I'm going to refer you to Exhibit 650 in front of you. 650. You have it?
Yes, sir.
It's not in evidence yet. But is this a email sent that you got from Mr. Wynn, or is this an email you created yourself?
This is an email that I created myself, and an email that I sent to Mr. Paxton.
All right, was this email, is this the prosecution memo we've been talking about?
Yes, sir.
And was the prosecution memo prepared by you?
This document was, yes.
All right. And did you use as a basis for this a prosecution memo proposed by Mr. Wynn that he sent you?
Yes, sir.
And then did you forward it on to the Attorney General?
I didn't forward Mr. Wynn's memo. I created my own. All right. And then forwarded it on.
So did you forward 650 to the Attorney General?
Yes, sir.
As far back as the date of 9/13, is that correct?
Yes, sir, 9/13.
Now, you're not here today claiming any type of privilege on this document, are you? Did you produce it to us?
Excuse me, those are two different questions.
Down at the bottom, I'd ask you to look and see if you see your name.
Could you repeat
the third question?
Yes, did you produce this document to us?
I believe my counsel did.
Yes, your counsel did. I know. In total openness, you provided us about 2,000 documents, didn't you?
Yes, sir.
It was a bunch, right? And 650 is one of those documents you provided us, correct?
Yes, sir.
And you weren't claiming work product privilege at that time or anything, were you?
My lawyers are the ones who produced all of it. I didn't make any claim one way or the other with respect to privilege.
Right, to both sides, correct?
Correct.
All right. So my question to you is this a document you prepared and just forwarded to the Attorney General for his information?
Yes.
Did you ever discuss this document with him?
I did.
When?
I believe it was around the time either just before or just after I had prepared this. I spoke with him about it to let him know that I had sent it.
That you intended what? To prepare a prosecution memo?
Yes, that I had sent this. Mm-hmm.
To him?
To him.
Did you discuss the contents with him at that time?
I did briefly, just to let him know that I had sent this over here and then it had some ideas about the case.
All right. And so was this designed to let him know that you were working on the case and this is where you were in the middle of September?
Yes, sir.
Okay. Now, again, Your Honor, I move to introduce Exhibit 650.
Objection, hearsay.
Your Honor, there are about 3 different reasons it's not.
Overruled.
All right. Now,
the exhibit is admitted to evidence 650.
I'm sorry, Mr. President, I couldn't hear you.
I'm sorry, I said overruled. 650 has been admitted to evidence.
Now, if we go over to the Bait Stamp 1986 of Cammack, Stacy. All right. Up at the top, number 6 says establishing a predicate to issue legal process. Do you see that?
Yes, sir.
And it has a list of names there. Where did you get those names?
I got these names from Michael Wynn.
All right. And if we go over to the first page of it, Stacy, can you tell us where you got this heading and the dates, what it is, the factual summary? where it says a more detailed chronology is attached to this memorandum. Did you get the information that you used as a basis of that from Mr. Wynn?
Yes, sir, from that original prosecution memo.
All right. So would it be a fair statement that everything you prepared in this document, that the research and writing of it was information provided by Mr. Paul or Mr. Wynn?
So, yes.
All right, I'll let you explain. You said so I want to give you an opportunity if you want to explain that.
Sure. Well, the prosecution memo that I got initially from Mr. Wynn, I'd reached out to him about it after I'd spoken with Mr. Paxton about sending it to him, and as lawyers, I checked with him. I said, I'm going to prepare this and send it over. Would it be okay if I use some of the things that you put in here, statutes, and reviewed some of the case law that was in there? So, he said, no problem, have at it. So I used that as the basis of what was going to ultimately be an investigative report to turn in at the end.
All right, I'm going to show you what is a new exhibit marked 696.
696.
I don't think you have it up there. I want to ask you just to look at this document, first of all, and see if you recognize it. Don't testify about the contents or anything. Okay?
Mr. Hardin, I don't have 696.
No, sir, it's a proposed new exhibit.
Okay.
I don't either.
And my question is simply, do you recognize it?
Yes, sir.
Can you identify what it is without talking about the internal contents?
This is an email from Michael Wynn, dated 9/25/2020, with what appears to be like a Word document attached to it.
Thank you.
Thank you.
And what did you do with that document? If anything.
What I did with it is I read it and I kind of just one ear out the other with it.
All right. Now, is that additional information Mr. Wynn prepared for you?
Yes, sir.
And without going into the contents of the documents, what was the purpose of that particular document?
This document appears to be a list of individuals to approach about an interview.
All right. So let me ask you this. May I have it back?
Sure.
I move to introduce 696.
Objection, hearsay.
Hearsay, we already have a record, a business records affidavit, which addresses whether the reliability of it. It is not a statement. It is a suggestion to this man by a co-conspirator in this case, not a co-conspirator with him, but a co-conspirator with the Attorney General and Mr. Paul, as they keep feeding this information in pursuit of their conspiracy. That's the reason we offer it.
And therein lies the problem, Mr. Hardin suggests, as they keep feeding the information. There is zero evidence that Ken Paxton saw this document, participated in this document, created this document before it was sent by Mr. Wynn to Mr. Cammack. And for Mr. Hardin to suggest there's not a statement is belied on the face of the document. Look at the very first page.
The objection is sustained.
All right, may I just for the record add one thing. Mr. Paxton doesn't have to have seen this if there's an actual conspiracy going on. It only needs to be somebody that is a member of that conspiracy. Any overt act or making any statement like that. I just want that in the record, Your Honor. I certainly don't want to quarrel with you.
Yeah, we sustained it to hearsay.
All right, thank you, Judge. Now, let's move forward. You are going to issue grand jury subpoenas, were you not? I
Yes,
said
sir.
are, but you were. Is that correct?
Yes, sir.
And in preparing those grand jury subpoenas, I think we've testified you used the assistance of the AG's office or the district attorney's office to get the forms prepared, correct?
That's correct.
Did anybody in the district attorney's office work with you or anything as to the content or the people they would be sent to or the wording or anything like that?
I believe I received a form from them in an email, like a sample form. That's the only thing that I received back from them as far as assistance goes.
So is what you said, what you received from them, what I'm really asking is, did any lawyer or anyone working on behalf of the content, did anybody try to talk to you about the content or the people to subpoena or anything like that?
No, sir.
All right. Was their duty simply aiding you to get the grand jury subpoena before a judge to sign?
Yes, sir. They facilitated.
Did you discuss with anybody in the district attorney's office anything about who you wanted to subpoena or anything like that? Or did you simply provide them the information, they helped you with format and presented it to a judge for you?
Yes, sir. So I just emailed the application for the subpoenas. They did not offer any assistance or make any comments or anything about the contents.
Was there anyone in the Attorney General's office aiding you at all in terms of investigating this complaint of Mr. Fall?
Objection, conjecture, and speculation.
Sustained.
All right. Now, at the end of the time, when you issue these subpoenas, let's go to the dates and times you did it.
Yes, sir.
Did you issue some subpoenas originally by email? You got your billing record up there?
Yes, sir. I'm looking at the
And your records or your memories show you when you did it? When did you first start serving these subpoenas?
would have been September 25th. 2020.
Pardon me?
It would have been September 25th, 2020.
All right. And then after you sent, do you remember how many of those you sent out by email?
It was roughly 35 to 40, somewhere in there.
All right. And then after you sent out some by email, then did you reserve some that you were going to serve and serve personally?
I think there were a few that I was going to serve personally for the second referral.
For the second one?
Yes, sir.
So why did you decide to send email for the emails on Mr. Paul's complaint, but decide to serve personally those in the second referral?
Because can I explain myself?
Sure.
So I have this list that I'm given of individuals that are subject to either the first or second referral. I get that from Michael Wynn. And the grand jury subpoenas were going to go out for email address, like to and from, the email log, to, from, what time, around the time that this search had taken place. And then there were also phone numbers to see if any contacts had been made around that time between cell phone numbers. So I say all that to say this: most of the people who were on this list either had a Gmail account or a Hotmail or a Microsoft account. So rather than piecemeal, let me get a couple subpoenas here, there was no intention of it to be this big shock value of sending out so many subpoenas. It was like, let me get all this information together. I will go through it and then go from there. And with respect to those that I emailed out, that's the way I looked it up. I went and looked that up. Like, okay, how does Microsoft receive a subpoena? Well, you can fax or email it. With respect to the banks that I've served those subpoenas on, I just did it in person.
Well, and then you notice you sent out, did you not, on the emails you did so that you were subpoenaing personal cell phones records? Did you send that out by email?
Those were by email,
yeah.
The cell phone records.
So were you sending out subpoenas for personal phone records of law enforcement officers, state and federal?
I'd have to look back, but I believe some of them were.
And were you did you even send out subpoena for the cell phone records of somebody who worked as a deputy for a federal magistrate? A courtroom deputy?
I would have to look, I believe so.
Okay. And then you don't happen to recall on the top of your mind right now who all you did, correct?
I do not, sir.
Okay, that's all right. So then, when you send out these different subpoenas, did you have any knowledge one way or the other that some of the people that you were sending subpoenas to were opposing counsel to Mr. Paul in civil litigation. Did you know that?
No, sir.
All right. If you had known that, would you have done it?
No.
All right. Who did you get the list from as to who subpoenaed?
I got the list from Michael Wynn and Nate Paul.
So is it an accurate statement to say that you issued grand jury subpoenas on behalf of the person that was under a state charges? You issued subpoenas to his agency, the Securities Board.
Objection, assuming facts not in evidence.
Did you realize that? That's really my question. Let me rephrase.
Sustained.
Thank you, Judge. Let me put it this way. First person out of the box in that prosecution memo we went over is Mr. Ronnie Saban, right? Did you know that?
Yes, sir.
All right. And you knew him as one of the agents involved in the search, correct?
That's correct.
Were you aware that he was an employee of the Securities Board and was involved in the criminal case where charges were filed and pending at this moment still against the Attorney General?
Objection, assume facts not in evidence.
Did you know that? That's all I'm asking.
Sustained.
Were you aware of what his role was?
Of the gentleman, I think you said Ronnie Saban?
Yes.
No, sir.
All right.
I just only knew him as one of the individuals who had searched Mr. Paul's residence.
Fine. All right. And then different other people. Did you know that Mr. Ray Chester, who was on your list, was opposing counsel in a lawsuit with the Mitty Foundation? Just did you know?
No.
All right. So did Mr. Wynn provide you these names without informing you that part of what they were seeking was information with people that were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul,
Okay,
namely the Mitty Foundation? Were you aware of any of that?
Multifarious, assuming facts not in evidence.
It's all in evidence.
No, it's not, and it's multifarious.
We have heard, well, excuse me, let me let the court rule.
Overruled.
Thank you very much. Were you aware of that?
I'm sorry, could you please rephrase that question?
So did Mr. Wynn provide you these names without informing you that part of whatever they were seeking was information with people who were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul in the Mitty Foundation litigation? Did he inform you of that?
No, sir.
Okay. Now, then you move on to the subpoenas that you were going to serve personally. And is it your testifying that those subpoenas were based on the second referral that Mr. Paul had filed originally with the DA's office on September the 23rd?
Those were for the second referral.
All
Yes,
right.
sir. Yes, sir.
And that's the referral that you had said you got on the 24th, right?
Yes, sir.
Okay. Now, at the time you sent out these subpoenas the previous week, after you sent them out and the judge signed them and they were ready to be sent out and you sent them out into the world of the internet, did you inform the Attorney General?
I did.
How did you inform him?
I believe I sent him an email.
All right. Did you send him an email at any time letting him know which people you were subpoenaing?
No.
All right.
I don't think I individually named.
If you need to stay with the microphone, please.
I don't believe I individually named each person, but
All right.
I just don't recall that.
Now, when you went out to serve the subpoenas in person, what dates did you do it and how did you do it?
That would have been on September the 29th of 2020.
September the 29th?
Yes, sir.
All right. And had you made arrangements with Mr. Wynn for him to go on these services of subpoenas with you?
So he was insistent on going.
What did he, I mean, how long had he been insistent talking to you about wanting to go with you?
Just maybe a day or so. I told them, I was informing them of what I was going to do to serve. I was going to go drop off the subpoenas, and he was insistent on going, and I was like, no, you don't really need to do that. I didn't really think it was appropriate. But he said, I'm Nate Paul's lawyer, and I'm it's important for me to be there in case they ask you any questions about his case or anything that's going on. And so, I felt a little pressure to say, okay. And he rode along with me.
Share with us why you felt pressure to accede to that.
I think just kind of pressure to perform. I wanted to do a good job, and I frankly trusted Michael.
Right. Did he inform you there was a statute prohibiting an interested party from serving subpoenas?
I was not aware of that.
Okay. And then, so when you made arrangements to go with him, where did you first meet up?
I forgot the hotel I was staying at down here, and he was at a hotel, and I just picked him up and we went.
What day of the week was it? 28th was a Monday, was it not?
I don't know. It was September 29th.
September 29th. I don't think anybody's going to argue if I can say it was a Tuesday.
Okay.
By the way, by this time, Tuesday the 29th, how much contact did you had with the Attorney General about this investigation? How many times? Just first of all, how many times did you talk to him by phone?
Between phone calls and text messages, it had to be somewhere 15 to 20 times range over that 3.5-4 week period.
Yeah. So that'd be 15 or 20 times that you were in contact with the Attorney General about the case, correct? And leading up to the 29th. And would you agree that you really actively get involved on the 3rd of September?
Oh, I'm sorry, one more time?
Roughly the 3rd.
The 3rd?
Yes. Remember the billing records, the first thing you billed is September 3rd.
Yes, sir, that was a typo. The date that I actually went out there was on 9/4.
All right. So can we say that those 15 to 20 times that you're in personal contact about this case with the Attorney General was 15 to 20 times in the days between the 3rd and the 29th of September?
I think that's accurate.
All right. And how many of those do you think they were personal phone calls?
I'm sorry, what?
How many of those 15 to 20 times were phone calls?
I would have to...
Roughly, just approximately.
Say maybe 7 to 10 times.
All right. How many of them were personal visits?
I didn't have any personal visits during that time.
During that time, you had the first meeting that you described when you were hired. Is that correct?
Yes, sir. I had the 8/26, the 9/4 day, and then throughout the month of September, I didn't meet any more in person.
Okay. And by the middle of it, he is communicating with you by a particular type of encrypted app. Is that right?
Mostly through cell phone, text, and then I was asked to download the Signal app, and I don't even think we had a conversation on the Signal app, maybe. I had that and then my cell phone.
Now, did the Attorney General, did you give the Attorney General advance notice that you were going to going out on the 29th and serving subpoenas?
Yes, sir.
Had you sent him any preliminary list of who you were serving them on?
No, sir.
Had you told him approximately how many you were going to serve?
No, sir.
How many were you planning to serve?
I believe there were 4 in person. There were the banks who were kind of the ones that were being accused in that second referral of this bank fraud deal.
All right. And so the email subpoenas that you sent out had to do with Nate Paul's referral number 1? Is that correct?
The emails that I sent out?
Yes.
Yes, sir.
Those subpoenas?
Yes, sir.
And then the subpoenas you served in person had to do with referral number 2. Is that what you're saying?
Yes, sir. That's correct.
All right. And when you would you just tell us in your own words, recite to us how you served those subpoenas?
We went to 2 banks.
Yeah, let me stop you there just a second. In each of these banks that you went to, did you identify yourself as a special prosecutor for the Attorney General's office?
Yes, sir, I did.
All right. And Mr. Wynn was with you at each one, correct?
Yes, sir.
Did you attempt at each of these banks to do some interviews of the people you served them on?
Just talking to them, yes, sir.
Yeah.
And giving the subpoena.
And did you talk to each of these people during it, in some cases, a little bit about why you were there in terms of the case?
Yes, sir.
All right. And you were there about a case Mr. Paul contended was a mortgage fraud case, correct?
Yes, sir.
And that was a case in which he wanted you to subpoena also or investigate a federal bankruptcy judge, correct?
Yes, sir.
Okay. And then did you conduct an interview of the husband of a court deputy during one of these services of subpoena?
There was I wasn't serving a subpoena. I don't believe it was, I was trying to talk to him.
All right, that was an interview without serving a subpoena. Without giving the person's name, unless counsel asked for it, and I think it's in the records, without giving the person's name, who did you go interview? Was it the husband of a deceased deputy?
Yes, I think she was a clerk of the court.
And where had the deceased clerk of the court been a clerk?
She was I forget which court it was. It was the court basically where this first initial referral came out of, the search warrant that came out of that made the basis of the first complaint.
So she was a previous clerk for the federal magistrate?
Yes.
And who were you talking to, her husband?
Her husband.
And did you have some suspicions or so that made you inquire as to how she died or anything?
I think there was I can't think of the right word, but there was like an indication that maybe there was some kind of foul play or something there with this clerk.
Now Mr. Cammack, that had been a suggestion to you by Mr. Wynn, had it not?
And Mr. Paul.
And Mr. Paul.
Yes.
So Mr. Paul tells you a deputy at the court that issued the warrant that I'm complaining about died under suspicious circumstances. That's what Mr. Paul tells you, right?
I don't remember those exact words, but it was something like that.
And maybe not that tone of voice, right?
Yes, sir.
But my point is, he actually led you to somebody that you in good faith interviewed, making you think that this husband might tell you suspicious circumstances of his deceased wife's death, correct?
Objection, leading, and argumentative.
Is that correct?
Sustained.
Thank you. Now, my only point was you issued those two. You served those two, were they on the 29th to these two financial institutions?
Yes, sir.
And do you remember what the names of the two financial institutions were?
I don't recall. I don't recall.
All right. After you issued those subpoenas on the 29th, what happened?
I get back to Houston the following day, and I've received an email from, I think, Microsoft at that point, and then also an email from counsel for one of the banks saying, we need some credentials to...
And, of course, you had been saying all along to the Attorney General you wanted credentials, right?
Yes, sir.
In order to take care of this particular problem. Is that right?
Excuse me. Third time. Objection, leading. Both questions.
Sustained.
Well, when you how many conversations did you say you'd had with the Attorney General trying to get credentials for this kind of work?
I think 4 or 5.
All right. And then once you got those emails, were those emails, if you served them on the 29th, were you receiving those the day after you served them, or would you receive them all the same day that you served them? If you remember.
It would have been after, and you can't quote me on that exact day if it was the 30th, but I do remember receiving emails to the effect of units.
And then what was the next thing that happened in your relationship, in your conduct with this?
I got a cease and desist letter.
From whom?
From a gentleman named Mark Penley.
What did you do?
I responded to his cease and desist and said, okay.
And then did you do anything else besides respond to it? Did you reach out to anyone?
I reached out to Mr. Paxton once I got the cease and desist.
Were you successful in reaching him? How'd you reach out?
I believe I called him.
All right. Were you able to talk to him?
I don't remember if it was that, if I spoke with him that day.
Did you also get a visit from federal law enforcement?
I did get, the U.S. Marshals showed up at my office down in Houston.
Yeah. Do you remember what day that was?
Maybe October 1st.
Who was the first? Federal marshals were at your office?
They came by my office.
Who was the first person you contacted?
I called Mr. Paxton, blowing his phone up. Like, why are there U.S. Marshals at my office?
How many times you called him?
Probably 5, 6 times, text messaging, and he answered his phone.
On the 5th time?
One of the times.
All right. And how often were you calling him until you got him?
Well, my secretary comes back and says, there's U.S. Marshals here at the office, and I'm like, what? What's going on? And then I just start blowing his phone up until he answers it.
In your mind, certainly, had you done anything wrong that would merit anybody in law enforcement coming to see you, in your mind?
No, sir.
All right. So the first person you called was the Attorney General?
Yes, sir.
And when you got him, what did he say?
He told me don't talk to him without counsel.
So he told you to get a lawyer before you talk to them?
That's correct.
Okay. Did you talk about the merits or anything of why they were there? Do this. What did you say to him, and what did he say to you?
Yeah, I said there's U.S. Marshals at my office. What is this all about? And he told me, well, don't talk to him without a lawyer. I don't know what it's about either.
Okay.
And then hung up the phone.
He hung up the phone, or you hung up?
I don't remember. We both hung up the phone and went out there and greeted those gentlemen and went to my conference room, and I said, hey, with all due respect, I can't talk to you without having a lawyer present, but can I have a business card? And I got the business card from those 2 gentlemen, took a picture of it, and I sent it to Mr. Paxton. I said, these are the guys who showed up at my office, and that was that.
All right. What's the next thing that happened to you in connection with this?
I had sent my invoice back to I got a cease and desist letter, and I send my invoice back over, and then I get an email the following day from Jeff Mateer.
And what did Mr. Mateer tell you?
They sent me another cease and desist letter, accusing me of crimes and all this other stuff. I'm like, whoa, what is going on here?
All right. And then at some time, did you go back to Mr. Vassar with the request to be paid, and that he responded to you?
They said there was no valid contract, and so I sent him the contract that I had for Mr. Paxton.
And all along, had you believed you had a valid contract?
Yes, sir.
And when you sent him the valid contract, was it signed? Who was it signed by?
It was signed by Mr. Paxton.
The one you sent back to him?
The one that they said that I didn't have a valid contract. I sent him the contract that I had for Mr. Paxton, with Mr. Paxton's signature on it.
Was Mr. Paxton's signature on the one you sent them?
The one that I sent them. I'm sorry.
When did you get a contract that had Mr. Paxton's signature?
I believe I got that on September 28th.
How had that happened?
So this was about the time that I'm getting ready to go with the subpoenas, and I still don't have my badge or credentials, and I was talking with Michael Wynn about it, and I was kind of frustrated at the time, because I'm like, well, I'm supposed to go serve subpoenas and do this work. I don't even have my credentials, which my contract, don't have a badge, I don't have a governmental email address, and Mr. Wynn asked me, I guess, well, send me over your agreement. And I had planned on coming out to Austin the following day to come do these subpoenas. So I get out to Austin to go over to...
Now let's put a day on it. What day do you get to Austin?
That was on the 28th.
All right, the 28th would be a Monday.
September 28th.
All right. And you arrive in Austin on the 28th. And what happened when you got... Who do you go to see?
I'm meeting over at Nate Paul's office, and Michael Wynn is there.
All right. And what do you find when you get there?
My contract was there on the table.
And was it signed by whom?
Myself and Mr. Paxton.
Had you ever seen a contract signed by Mr. Paxton before September the 28th?
No, sir.
And in fact, all this time that you thought you had a valid contract, did you have a contract that was only signed by you?
I sent Mr. Vassar my signed copy back on the 4th and said, please send me back an executed contract. And I never got one. You know, I didn't know.
I just want to make sure real quickly here. You got back from you sent Mr. Vassar your contract, which had only your signature on the 4th. Is that right?
That's correct.
And then, from then until the 28th in Mr. Paul's office, did you ever see a contract that had the Attorney General's signature on it?
No, sir.
And when was it that you complained to the Attorney General, if you did, that you did not have a contract signed by him? When was the last time you did that before you saw it on the 28th?
I don't recall the exact date, but I had told him about a badge, you know, credentials and email address. And so I just never received it.
On the morning of the 28th before you left, did you have a conversation to go up there? Early in the morning, did you have a conversation with Mr. Wynn?
I did.
And what did you tell Mr. Wynn?
I believe he had texted me the night before and said, you know, because I was frustrated, so I was telling him I don't have my credentials, like meaning my contract or my badge or any of that. So he texted me. I think I was already sleeping, and he said, "Send me your contract." So I wake up at like 5 a.m. and I send it to him.
The contract you sent to Mr. Wynn early that morning,
about 5 a.m.
5 a.m. had only your contract, your signature?
Yes, sir.
All right. And then how soon after that was it that you arrived in Mr. Wynn's office where they had a contract signed by the Attorney General?
We went to Nate Paul's office, not Mr. Wynn's office, and we had to be around lunchtime maybe.
And you walked in and saw what?
My contract was there on the deal signed.
Signed by the Attorney General?
Yes, sir.
And that was the first time you'd ever seen one?
Yes, sir.
Signed by him. All right. Now, finally, when things got a little hectic for you after that, did they not, after the 29th and 30th of September?
Yes, sir.
When was the next time that you saw the Attorney General?
I don't remember the exact date. I'm sorry.
On the 29th or the 30th, did you see him? Or the 1st of October or the 2nd of October or any of those dates? Did you have occasion to have contact with the Attorney General again?
I did. I just don't remember the exact date. It was after I had received the second cease and desist letter from Mr. Mateer.
And what were the circumstances of you seeing him?
I got a phone call from Michael Wynn, and he had said, "Hey, I need you to come out to Austin." It was like last minute, and it was in the evening. And I'm like, he's like, "You need to come out to Austin and come over to Nate Paul's house."
What time of day were you supposed to get there?
I don't remember what time I got there. Maybe it was in the evening. My sun was going down.
All right. And so when you drove up there to Austin, to Mr. Paul's house, did you have any idea why you were there?
I mean, I figured because at this point, I've gotten a cease and desist letter. I've gotten basically the rug pulled out from under me. Like, I'm going and working, everything is okay. I'm getting affirmation that everything is good. And then all of a sudden, I've got cease and desist letters, U.S. Marshal showing up at my office. And I'm trying to figure out, how did we go from that to this? And I'm just trying to get answers about what's going on, because I still don't know. And so that's what I figured this was all about. So yeah, I get out to the house. I drive to Nate Paul's house, tell my fiance at the time, like, "Hey, I'm going out here. I'll be back later." And then, yeah, I get out.
So what happens when you walk in? Could you basically describe the meeting?
Yeah, I go in, and Michael Wynn is there, Nate Paul is there, and Mr. Paxton's there.
Where's Mr. Paxton, and what's he doing?
Shook his hand, and he was like on the phone, and then just spent most of the time just out on the balcony on the phone.
Was there anything surprising about him being there to you? Did you know he was going to be there?
I didn't know he would be there.
Pardon me?
I didn't know he was going to be there.
And then, you know, what was the circumstance, the scene? How was everybody dressed? What was everybody doing? All that jazz.
I mean, I was dressed in a suit because I was, for business, and, they were dressed casually. I think Michael had a suit on. Mr. Paxton had running shoes and running shorts on or something, just casual.
Did they talk to you? Why were you there?
So while Mr. Paxton was out on the balcony, Michael Wynn and Nate Paul, they were just kind of commiserating about all this stuff that had happened in that last few days. And when Mr. Paxton came in, as I was going to leave, I think I was there maybe an hour, he had mentioned, that Mr. Penley didn't have any authority to tell me to stop working. He told him to stand down and just to continue to work on this report.
At that time, when you say he came in, was he outside the room but there when you arrived?
He was in the house and then went outside on the balcony or in the back and was on the phone the entire time.
All right, after Mr. Paxton told you that, how long were you there?
Oh, I left.
So what did you think? What was the meeting about?
Just a lot of talking about, how I can't believe that this happened. I can't believe what these guys are doing. The fact that Mr. Penley had reached out to Michael Wynn asking for documents, even though Mr. Paxton had told him not to work on the case and this type of stuff. But I still left there very, in my mind, I'm not, hey, I got 2 cease and desist letters. I'm not doing any more work. And I haven't been paid for anything. And so I'm just kind of listening, trying to get answers on what I should be doing.
So did you wonder on the way home why the hell you had been there?
Yeah, yes, sir. That was annoying to have to drive out a 3-hour drive for an hour meeting and then come back.
When is the next time you saw the Attorney General about this matter?
I think within the next couple of days, I got a call to come out to his office and meet with him and some of his staff.
And what did they want?
Mr. Paxton wanted me to meet Brent Webster.
Brent Webster was did you know who he was by that time?
No, sir.
Did you know what position he now had?
I knew when I got out there that he was, I guess, the first assistant.
And when and where did y'all meet? What did you do? Just walk us through it.
So we met in the conference room over at the Attorney General's office with 2 other individuals, and Mr. Paxton wanted me to just debrief what I had learned, what the first referral was about.
What did you tell him?
What I had done. I spent the first few minutes kind of just venting my frustration about how I felt like I had been treated to that point, still not having any clear answers. And, the fact that I had a whole entire life before of all of this, a docket, I had clients. I didn't ask for any of this. You guys reached out to me to come do a job, and then now you're pulling the rug out from under me, and I'm getting cease and desist letters, and now my name's being thrown through the mud in the media, and it's a totally new world to me. So, I let that out and just told them, what we kind of talked about here today, right now, that I'd issued subpoenas. I had this PowerPoint presentation where they showed me this. And
what did they say? What did he say? What did the Attorney General say?
I believe he asked me, or Brent Webster asked me, to send him any documents that I had sent the Attorney General, to email it to him.
Did the Attorney General apologize to you?
I don't think he apologized to me, no.
And then did y'all stay there, or did you go somewhere else?
No, I left there. Went back to Houston.
And then when was the next time that you saw the Attorney General?
Yeah, the next time, and I'm sorry, but I just don't recall the exact date, but it was within that week. I get a call from, that last meeting, it was like, hey, you need to, just continue to work on the report. Everything is fine. And in the back of my mind, I'm like, yeah, right, I'm not doing anything else. And then a few days go by and I get a call to come back out and meet with him, just like a very short notice, maybe even the same day, to come out to Austin again.
You drove up again?
Drove up again.
You recall what that date is?
No, sir. It had to be the first week of October sometime, though.
All right, and then where did you go when you drove up?
I went to the AG's office again.
And then who was there?
Brent Webster and Mr. Paxton.
And what happened there?
I thought we were going to meet to talk about the contract and what is going on, and but instead, you know, they were like, well, let's not meet here in the office, and they walked me over to a Starbucks outside of the office to have a meeting.
Did you ask why?
No, but it was uncomfortable. It was not professional to me at all.
So when you go to the Starbucks, who all's there?
Mr. Paxton, Brent Webster, and then a couple other gentlemen who I don't know.
And what happened at that meeting?
At that meeting, Mr. Webster did all the talking and told me, well, in fact, your contract is not any good anymore. You know, stop working, don't do anything at all. I asked him, okay, well, what about, you know, paying me?
Do you recall exactly how you put it about whether you were going to get paid? Did you put the amount in there?
I think I ballparked it, and I said, what about my $14,000 invoice? And he's like, well, you're going to have to eat that invoice. I've had to eat $40,000 invoices.
Webster said he had eaten a $40,000.
That sticks out in my mind, sir.
Yeah.
Yes, sir.
Why does that stick out in your mind?
Just because it was offensive.
What was the Attorney General doing during this whole conversation?
He was just listening in.
Did one of them tell you your contract was now terminated?
What Mr. Webster said.
How long did you at the Starbucks?
15 minutes, 20 minutes tops.
Did you feel better knowing that Mr. Webster says he had eaten a $40,000 debt before? Did that make you feel any better?
I'm sorry, what do you mean?
How did it make you feel?
I don't know if I believed him or not, but I know it was offensive to me.
And then what happens? Anything you remember? What happened then?
Yeah, they left the Starbucks and tried to get in the car and drive off. I said, excuse me, can I get a ride back to my car?
So these guys take you to, are you saying that these guys took you over to a Starbucks outside the office, terminated your contract, told you weren't going to get paid, and then drove off? And if you hadn't said, wait, I got my car, they'd have left you in the street?
That's what it looked like.
Pass it.
Mr. Cogdill.
Good afternoon, Mr. Cammack.
Hey, Mr. Cogdill.
We know each other distantly, I guess is the best way to put it.
Yes, sir.
You also know my associate, Mr. Oso.
Yes, sir.
Once upon a time, there was a lot of discussion in the court about young lawyers and five-year lawyers and whatever. At the time you got involved in the Paxton matter, Mr. Cammack, you were a five-year lawyer, right?
Yes, sir.
Mr. Oso, younger than you or older than you?
He's younger than me.
Let me begin sort of near the back and the marshals coming to your office. You learned eventually, did you not, that the purpose or the reason the marshals came to your office was because of the visit that you'd made to the I guess the widow or the widower at the clerk's office, right?
I learned that from my lawyer, Andy Drumheller.
Okay.
Yes.
And Mr. Paxton hadn't sent you to that clerk's office or anything of the sort, right? That was
sir.
That was Nate Paul. You met with Mr. Harden how many times before you testified?
I've spoken with him 3 times.
When was the first time?
I believe it was in the last 2 weeks. I'm sorry, I don't remember the specific date.
About how long was that meeting, Brandon?
That was approximately 4 to 5 hours, I believe.
And the next time you met with him?
I met with him last week when I came out here. I thought I was going to be testifying on Friday.
And about how long was that?
Hour and a half to 2 hours.
And did you meet with him again last night?
Met with him last night for maybe an hour.
So that's a total of how many hours that you met with Mr. Hardin?
Roughly 7.
Could we see article of impeachment, article number 5? Have you studied, I assume you have not, Mr. Cammack, the articles of impeachment in this case?
No, sir, not studied them.
But if I suggested to you, this is, quote, why you're here, close quote, could you agree with me?
Yes, sir. I've read this. I've seen this.
All right. Did Mr. Hardin ask you or show you this article in any of those 8 or so hours?
I don't recall seeing this.
So in the 8 hours that you met with Hardin, he never showed you the relevant article that brings you here. So let's take it apart. It says, while holding office as Attorney General, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. Will you agree with me, Mr. Cammack, that you were not a prosecuting attorney pro tem? Agree with me on that?
Yes, sir.
Okay. It goes on to say that Paxton engaged Cammack, a licensed attorney, to conduct an investigation into a baseless complaint. Mr. Hardin never asked you about that? That language?
I'm sorry, could you
Sure.
rephrase that? I'm sorry.
Yes, sir, sure. Mr. Hardin never went over this language in the article of impeachment with you, right?
No, sir.
And you will agree with me, Mr. Cammack, that you certainly never believed that you were a part of an investigation into a baseless complaint, right?
No, sir, I did not.
Okay. 8 hours and you never asked that question by Mr. Hardin, right?
We didn't talk about a baseless complaint.
Okay. Let's go for strike 3, although you just need 1. It says, during which Cammack issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. You would agree with me, Mr. Cammack, that was not your purpose. You were not there trying to benefit Nate Paul or his business entities. That's not why you agreed to get involved in this. Agreed?
Absolutely not. I didn't even know Nate Paul or his entities or anything like that.
Mr. Hardin has a reputation as not a good lawyer, a great lawyer, right?
Yes, sir.
Could you give us a reason why a lawyer as good as Mr. Hardin would have never asked you those critical questions?
In the words of a great American, Your Honor, it's calling for speculation.
Sustained.
Well, if that's a suggestion that I'm a great American, I'll take it. Let's go back. I think what may be lost in some of this, Mr. Cammack, is this is in the late summer or fall of 2020, right?
Yes, sir.
And this is when, I don't want to say COVID is raging, but COVID is ever-present, omniscient. It's taken over the world, right?
It's peak COVID. Yes, sir.
Peak COVID. So here you are, a younger lawyer. If I understand it correctly, you had just left, not too long before this, practice with your father, right?
That's correct.
He is also a criminal defense lawyer.
Yes, sir.
So you have your own practice, right?
Yes, sir.
You had tried a number of cases with your dad, I assume, a number of cases with others, right?
And myself, yes, sir.
And yourself. And you had tried, I guess, I'm assuming, anything from misdemeanor cases to felony cases,
Yes,
right?
sir.
You weren't some kid straight out of law school that couldn't find a courtroom door with a CNI dog and a search warrant. I mean, generally speaking, you knew what you were doing at the Harris County Courthouse, right?
Absolutely.
So along comes COVID, and like a lot of Americans, what you took for granted suddenly was an issue, right? Meaning your business, our business stopped. It didn't slow down. It came to a screeching halt, right?
Yes, sir.
Arrests went way down. Courthouses literally closed, right?
They did.
So you're rolling along, I assume, and you get a call from Mr. Wynn that the Attorney General might be calling you, right?
That's right.
Now, I assume you never aspired to be a prosecutor or you would apply to the DA's office, but still, when the Attorney General calls, that's a big moment, right?
It was a big moment.
Okay.
Yes, sir.
You trusted Mr. Wynn, right?
I did.
He's a Harvard-educated lawyer. You were aware of that?
He's a serious lawyer.
He's a serious lawyer. And I assume that up to this point in time, Mr. Cammack, you didn't have any real personal connection in terms of going out and having drinks or having dinner or whatever with Mr. Cammack, but you knew him professionally slash socially, and you respected him, right?
With Michael Wynn?
Yes, sir.
Just an acquaintance who was part of a couple clubs I was, and we had worked on that COVID-19 panel with some of the district court and federal judges, and he seemed like a nice person.
Okay.
So,
he had a significant practice, at least from your perspective?
serious practice, yes.
So it's good news, and if I'm remembering your direct correctly, the call from Mr. Paxton or from General Paxton came on your birthday.
Yes, it was on my birthday.
You're thinking, what a great birthday present, right?
Something at the time I was like, oh, well, what a coincidence.
And look at you now, Mr. Cammack. Didn't turn out to be that perfect, did it?
I never would have imagined in a million years getting that call to sitting in an impeachment hearing, sir.
Got it. So let's go completely sideways for a second. If there has been a suggestion, Mr. Cammack, that it is wrong or illegal to challenge or investigate the legality of a search, that is not your worldview, right?
I'm sorry, one more time.
Sure. If there has been a suggestion made in this courtroom before these 31 senators that it is somehow wrong or illegal to investigate the legality of a search or a search warrant, that is not your worldview. Agree with me?
I agree with that.
I mean, it's sort of born and bred in a criminal defense lawyer. That's part of what we do. You would agree with me?
That is what we do.
And any criminal defense lawyer, I think, that's been practicing longer than 6 weeks has probably challenged the legality of a search warrant. You would agree with me?
Yes, sir.
And has probably looked into the conduct of law enforcement agents in either the creation of a search warrant, right?
That's right.
The execution of a search warrant, right?
That's right.
Again, that's called Wednesday in our business. That's what we do.
That's a Wednesday on our business. Yep.
Now, would you also agree with me that not only do we have, I guess, the choice of challenging or investigating the legality of searches, but we have the obligation to do it on behalf of our clients, right?
Right, we're just on the other side of it.
Yes, sir.
That's right.
And if we don't do that on occasion, we can get sued by the client, right?
That's right.
We can have a grievance filed against us by the client, by the state bar or someone else for failure to investigate that sort of claim, right?
That's right.
And I guess my long-winded point there is when you were asked by Ken Paxton, and we will get to that conversation, but when you were asked by Ken Paxton or told by Ken Paxton he wanted you to investigate the possibility of an illegal search or the creation of an illegal search warrant by agents, that was like, great. That's in my wheelhouse. That's what I do, right?
Well, it was an investigation into potential violations of the Texas Penal Code, which is what I'm familiar with doing. So it would be in my wheelhouse.
Right. So it's in your wheelhouse, in your strike zone, whatever, right?
Right.
And the fact that, and oh my God, it's a federal agent, or oh my God, it's a federal magistrate. I mean, again, they deserve and are owed their deference, but there's nothing sacrosanct about an AUSA in our worldview, right?
I have complete respect for government officials, but, Mr. Paxton also believed that, hey, this is a serious accusation. It requires a serious focus. And, if someone's doing something like that, they should be held accountable for it.
And I assume, Mr. Cammack, you felt the same way.
I did feel that way.
Now, jumping ahead a little bit, but I think in one of the conversations, Mr. Cammack, you had, or one of the answers to one of Mr. Hardin's questions, that somewhere along the line you heard either Mr. Wynn, I believe, or Mr. Nate Paul say something, quote, and this is a statement attributable to Mark Penley, there's no amount of information that could be presented to him that would ever convince him that a federal official could commit a crime, right?
That's right.
And which person said that? Was it Mr. Paul that said that about Mr. Penley, or Mr. Wynn that said that about Mr. Penley, or do you know?
It was Mr. Paul said that.
Okay.
Mr. Wynn was there when he said that.
Okay. And that's just not the house that you live in.
I don't live in that house.
You don't feel that same way, right?
I don't feel that same way, no.
I'm assuming.
Excuse me, can the witness be a little closer to the mic and speak up a little bit?
All right, Judge.
I'm assuming, Mr. Cammack, that you view federal prosecutors and magistrates and judges just like defense lawyers, bankers, bakers, trash truck drivers, whatever. There are good ones out there and there are bad ones out there.
Base people off of their character. I mean,
that's right.
That's it.
And you do not automatically foreclose from your mind or from your obligations an inquiry into the legality of a search warrant simply because it was signed off by a federal magistrate, right? That's a mouthful. There's nothing improper in your worldview about investigating a search warrant or the validity of a search warrant simply because it is signed off by a federal magistrate, right?
No, I mean, as a defense lawyer, that's what we do, is challenge the validity of a search warrant. I mean, this was just on the other side of it, where that person could be held accountable for it.
Now, let's get to your first meeting with Ken Paxton. On your birthday, I think the 22nd, he calls, right?
Yes, sir.
And I'm sure you have been asked this question 287 times, but the best of your recollection, he says what to you when he calls you, Mr. Cammack?
I didn't speak with him that day. It wasn't until the 23rd that I spoke with him, and he said that he got my name from Michael Wynn. I think the words were, my name was dropped in a hat, and he got my name from Michael Wynn and wanted to see if I'd be interested in coming to talk to him about working on a criminal investigation.
And that would have been, if it's the day after your birthday, that would have been August 23rd?
Yes, sir.
And did he give you any detail about what he wanted to, what what was the job description specifically that he wanted you to do?
Not at that time. It wasn't until I went out there and met with him in person that I found that out.
Okay, and if I'm recalling it correctly, there was some request by someone to bring a resume, right?
Yes, sir.
And it had been a while since you had a resume, right?
Yes, sir.
But you figured, well, if I've got to audition for the beauty contest, I'll find a swimsuit, I'll get a resume together, right?
Just trying to remain humble and do what he asked me to do.
Okay. And you met with him, right?
Yes, sir, on the 26th.
On the 26th, Mr. Paxton, General Paxton you knew him by sight, right?
Yes, sir.
He's gracious, professional, nice enough to you.
He was nice, yes.
And on that day, on the 26th, Mr. Cammack, can you share with us the description of what he wanted you to do?
At that time, he told me that he was looking to hire a special prosecutor to investigate whether, I guess, these federal agents had tampered with or altered a search warrant. Basically violations of state law.
Okay. And again, we've talked about that's kind of in your wheelhouse.
Correct.
You spend 20, 30 minutes with General Paxton?
Probably 20, 25, something like that.
And he uses the phrase special prosecutor, right?
Correct. Yes, sir.
So we've heard that sort of go through the evolution of your story, but it is true that he was the person that first put those words into your mindset, right?
Yes, sir.
If I heard your testimony directly, then, Mr. Cammack, you go down the hall and you meet with Jeff Mateer, right?
Yes, sir.
And did he act like he knew why you were there?
He did.
And just collapse the conversation succinctly that you had with Mr. Mateer.
Yeah, so I had another copy of my resume. I handed it to him, and I said, well, it was kind of awkward for a second, just communicating with him. But he said, I said, I'm here to interview about the special prosecutor position for this investigation with respect to the search warrant. And he acknowledged that, okay, and said, oh yeah, I know a little bit about that, and just kind of act disengaged.
Gotcha. And I think that was the phrase that you used with Mr. Hardin, disengaged, right?
Yes, sir.
But I guess my point, at least right here, Mr. Cammack, is the phrase special prosecutor was discussed with Jeff Mateer, right?
That's correct.
And at no time did Jeff Mateer say, oh, no, you're not going to be a special prosecutor. We can't hire special prosecutors. That never happened, right?
No, sir.
Did Mr. Mateer, disengaged as he was, did he ever indicate to you, Mr. Cammack, that there was no need for a special prosecutor being hired?
He did not.
Did he ever indicate to you that he felt like this investigation was a baseless complaint?
His attitude was kind of like that, like he didn't feel like it was important or worth pursuing.
It didn't rise to his level of importance.
That's fair to say.
Okay. But he certainly never said or suggested to you that this was a crime or illegal for you to be interviewing for this job.
He did not. He did not.
Okay. Now, you don't get the thumbs up that day, but you leave. You're optimistic, hopeful about it, right?
That's right.
And to put us back in your worldview at the time, again, we're in the middle of COVID. Let me stop back. I over theatrically demonstrated or referred to how long you'd spent with Mr. Hardin. You and I did meet last night, right?
Yes, sir.
Spoke for 45 minutes or so.
45 minutes.
It was late, right?
It was late.
And it was after Mr. Hardin had
met with Mr. Hardin, and then me and my lawyers came and talked to you for about 45 minutes.
Gotcha. So we have discussed this before. I'm not just getting lucky with every single answer.
We have talked about this, yes, sir.
Okay. So you're hopeful. Again, we got COVID. You're thinking the Attorney General. This is great. I believe that on your drive home, you call your grandmother, right?
I think I told you that. It's like, hey, I met the Attorney General.
Right.
Yeah.
And your grandma says, I guess would act like any other grandma. So good for you. That's awesome.
That was her attitude.
So you then go through a series of exchanges about whether or not you might have a conflict, right? potential conflict with any other cases at the Attorney General's office.
Yes,
correct?
sir. Mr. Vassar at some point reached out to me about a contract.
Okay.
And told me that I needed to do a conflicts check.
Did Mr. Vassar ever suggest to you, Mr. Cammack, that you were unqualified?
No, sir.
Did Mr. Vassar ever express to you that hiring, whether we call you an outside counsel or special prosecutor, whatever, did he ever express to you that the hiring of you was unnecessary?
No, sir. He reached out to me to set up a phone call. And then on that phone call with him, I said, yeah, I'm interviewing, or he's calling me, I guess you're calling me about the special prosecutor position. And then he's acknowledged that, asked for my email address. And I think we talked a little bit briefly about where he had gone to school and that type of thing. So he's, I told him the same thing that I told Mr. Mateer as well.
But he never gave you any pushback on the idea of you getting hired for this job, right?
I never got any pushback from anyone at the Attorney General's office until I got a cease and desist letter.
Say that again.
I never got any pushback from anyone at the Attorney General's office or the Travis County District Attorney's office or anything until I got a cease and desist letter.
In fact, Mr. Cammack, it's true, is it not, that in your, effort to be compliant, appropriate, righteous, that's probably overstating it, but in your effort to do the right thing, you called the State Bar of Texas Ethics Hotline and described what you were going through, right?
I did, sir.
And without getting into what they told you, you walked away from that conversation after explaining to the ethics hotline at the State Bar of Texas what you wanted to do. You felt like you had a blessing from the State Bar of Texas to do exactly what you do, right?
Told me congratulations on the job.
So in the middle of this alleged conspiratorial dark worldview effort, you're calling the State Bar just to make sure you are literally dotting your I and crossing your T.
That's
right?
correct.
Now, I think Mr. Hardin had you talk about your expectations about your sort of bell curve or what have you of ability. In other words, when you first met with Mr. Paxton, I think you thought, I can investigate, I can issue grand jury subpoenas, I can appear in front of a grand jury, I can make recommendations to the grand jury. Heck, I might even get to go try this case. That was kind of your worldview when you went into this, right?
I didn't think there would be any limitation all the way up into potentially presenting the case for a charging instrument, whether it be an indictment, a complaint, an information, or trying the case in front of a jury panel. So once I got my contract, then I realized how limited of a scope it was.
Yes, sir. You anticipated my next area question. Once you got the contract back, it was sort of the real world of, no, I'm not going to be presenting this case to a grand jury. No, I'm not going to be making recommendations. No, I'm not going to be trying the case, but I'm going to be investigating the case, right?
I was just still happy to be working for the Attorney General.
Got it. Now, and I don't know when you want to break, Mr. President.
I was going to go to about 3:10, about 15 more minutes.
That's fine. At some point along the way, you and General Paxton had a discussion about your hourly rate. You said $300 an hour, right?
Yes, sir.
And you would agree with me that all things being equal, that's a pretty reasonable, moderate rate, right?
Yes, sir.
I guess, Mr. Cammack, the more important than the money was sort of the prestige or the opportunity or the resume, if you will, of getting to work for the AG's office on this particular matter.
I thought it was a fair rate, and it was not about the money. And I have a whole business before all of this that I still have today. So it was not about the money. It was about trying to help out.
All right. So refresh my memory of when you get a contract from, and refresh my memory. I should know, but I don't. You got a contract from whom and on what date? The first contract you received?
I received a contract. This was my mistake, but the contract came in on September 3rd in my email, and Mr. Paxton asked me, did I receive it?
Okay.
But I didn't see it. It got lost in the shuffle of all the other emails. So I responded back and said, no, I didn't get it. and then Mr. Vassar resent it to me on September the 4th of 2020.
So you have a recollection of Vassar specifically sending you this contract, right?
I do, sir.
And when you receive this contract from Mr. Vassar, you think that is an I mean, neither one of us are contract lawyers, but you think that's an offer, and by signing it and sending it back, you think that's an acceptance.
Yes, sir. I spoke with him, Mr. Vassar, about the contract.
Right.
I spoke with Mr. Paxton about the contract. He followed up to see if I got the contract.
Right.
He said he could get me the hourly rate. I told him I was coming back out there. I mean, to me, it was very clear that I was being hired for this position. And so I signed it and returned it to Mr. Vassar that day when I got home.
Gotcha. And no one suggested to you during that month of September that they had their fingers crossed and you really didn't have an agreement. In other words, you went through that month believing you had a valid contract with the state of Texas to be an outside lawyer, right?
Yes, sir.
Now, I think you told us that you, Mr. Cammack, attended a meeting with Nate Paul on September 4th, right?
Yes, sir, I did.
And that's here in Austin, right?
Yes, sir.
Let me back up. So Michael Wynn tells you, hey, the AG might be calling, the AG calls, right? And then you learn at some point that Michael Wynn not only had recommended you, but was Nate Paul's lawyer, who was the complainant, for lack of a better description, in this illegal search warrant claim, right?
Yes, sir.
Do you know when it was, Mr. Cammack, that you learned that Wynn was representing Nate Paul?
Yes, sir. It was once I got confirmation about the job, I guess, and
Okay.
I sent, Michael reached out to me and said to come meet with him and the complainant, Michael or Nate Paul, on September 4th.
Now, Mr. Harden asked you if you did any research about Nate Paul, or you Googled Nate Paul, or words to that effect, right?
He asked me that, yes, sir.
And when is the first time you have a recollection of doing that? Before you met with Paul or after you met with Paul?
Before I met with him, I just Googled him.
And you knew, obviously, at some point that he had a search warrant run on his home and his properties and his business and all of that, right?
Yes, sir.
You didn't come across news articles about that in your search, however long that was or wasn't, right?
No, sir.
But what you came across were articles where, for lack of a better description, he's the new golden child of commercial real estate in Austin. He's the new king or whatever, right?
It was just headlines about his career as a real estate developer.
From your perception, Mr. Cammack, you thought you were sitting in front of or meeting with a valid gentleman or person of substantial economic means, I guess.
I thought, okay, serious guy, businessman, serious lawyer, serious case. I took it very seriously.
Okay. So nothing about this, I guess I'm stumbling into, nothing about this was off-putting to you. You didn't think that there was, in fact, you thought this case just keeps getting better and better for me, right?
I was just trying to focus on the facts of what I was being presented with. I didn't know any of these people.
Okay. So you meet with him in Austin. I believe you said you met with him for an hour and a half, 2 hours, right?
Yes, sir.
And I say him. Nate Paul is there. Michael Wynn is there, right?
Yes, sir.
Ken Paxton is not at this first meeting, if I understand it, correct?
No, sir. He was not there.
And they are explaining to you, that is Mr. Wynn and Mr. Paul are explaining to you their theory about why the search warrants may be invalid and why they might have been altered, right?
Yes, sir.
And I wasn't there, but as I understand it, Mr. Paul showed you, made a pretty convincing presentation utilizing a computer, diving into the metadata, which at least convinced you that this probably happened or this might have happened, right?
I was convinced.
You were convinced?
Something there.
Okay.
I didn't make a judgment either way, but it was a persuasive presentation.
How computer literate are you, Mr. Cammack? And that's a vague question. You know much about metadata?
No, I've never really worked with metadata in that way.
Okay, but it at least appeared to you at that time that Mr. Paul was literate in that area, made this explanation, made this explanation, and you accepted it, right?
Yes, sir. I was told that this presentation was also given to Mr. Penley and Mr. Maxwell as well. So it was just me, my set of eyes looking at it, and I thought it was persuasive.
And you leave there, I think, and go meet with Ken Paxton at his office here in Austin the same day.
Yes, sir, that's correct.
Do you recall how you described your worldview of the explanation that, I don't know why I can't talk. I'm paid to talk. You told Ken Paxton, I think, Mr. Cammack, words to the effect of, I think there may be something there, General.
I told him I was convinced, it was convincing what I was shown, and he agreed with that.
Okay. Now, let's go there. When you say it's convincing, exactly what words did you say?
I said it was convincing, it was persuasive, and he agreed with that. He said, yeah, I agree.
Paxton agreed with you.
Yes,
right?
sir.
Now, at no time, you would agree with me, I think, that did Paxton ever suggest to you that this investigation was a baseless investigation, right?
No, he never indicated that it was a baseless.
You believed, recognizing that you don't know what's in his head, but you believe that he believed the same thing that you believe, right?
Yes, sir.
At some point during this meeting with Ken Paxton, after you had met with Nate Paul, I think it is then that General Paxton says to you, get me a wedding copy of the search warrant, right?
He said that after we got back from the press conference and I was getting ready to go.
That the same day?
Same day.
Okay, so...
He did say that.
And they probably understood it after Mr. Harden explained it, but just so that I'll be on the same page with it, a wedding copy is a copy that is actually signed with ink by a judge, right?
It would just be the original document.
And your understanding of why a wedding copy was important is it could, if not definitively, then go a long way in establishing whether that warrant had been improperly altered or not, right?
Yes, sir, that was my understanding.
And the words of General Paxton to you, I think, were along the lines of, if you can find me a wedding copy of this search warrant, that's all I need, game's over, right?
It was, if the wet ink copy is the same as the PDF document that was provided to Nate Paul and his lawyers, if they're the same, then it's over.
It's over, meaning he would be satisfied.
Would be satisfied with that. And if they were different, then obviously this thing's going to take a little longer.
Okay.
Figure out.
Now, did General Paxton ever pressure you to find a given or a specific result?
With respect to my ultimate conclusions about what I thought happened?
Yes, sir.
No, he never pressured me one way or the other.
He didn't say, you got to do this, dude. I need one. I mean, if you get this done for me, you got a big job. I mean, there was never any suggestion of you engaging in any sort of impropriety or a request for any sort of impropriety on the part of General Paxton. Agree with me?
I agree with that.
Did he use verbiage like, look, I just want to know the truth. Just tell me find the truth in this thing. You remember that?
I do.
And when was it, Mr. Cammack, that General Paxton first told you, I just want to know the truth or find the truth?
That would have been in our first meeting on August 26th when I first went out for the job interview.
So to be clear, before you were ever hired, that was his directive to you. I just want to know the truth. Find me the truth.
It was, I just want to know the truth, and if something happened, that would be an injustice.
Okay. Now, There has been a lot of discussion, Mr. Cammack, about evidence and what's not evidence and that sort of thing. At the time that you first met with Mr. Paul and Mr. Wynn, do you believe they gave you at least some type of evidence for you to begin an investigation in good faith based upon?
They gave me, they told me the story about what happened, and I took some handwritten notes, and then when I left there, I was given like this timeline of events to kind of, I guess, help me digest everything.
Okay. And so you set about doing what a lawyer should do, that is investigating, right?
That's right.
And you could have done a number of things in this investigation. I assume one of the things you could have done is knocked on doors and started interviewing people, right?
Yes, sir.
But you didn't do that, if I understand it correctly. Instead of knocking on doors, if I'm understanding what you did, you issued subpoenas or chose to have grand jury subpoenas issued, right?
Yes, sir.
Would you agree with me, Mr. Cammack, that the very intent and purpose of having the grand jury subpoenas issued was for you to be able to obtain that information without causing any alarm or concern on the part of the people of whom you were seeking the information?
That is correct.
Right. So for a week and a half, we have heard, oh my God, the grand jury subpoenas would intimidate these people and frighten these people and scare these people. It was exactly 180 degrees opposite from that. Your intention was to do the exactly opposite of that, right?
Can I explain that?
Yes, sir.
But yes, sir, to answer your question, when I spoke with Mr. Paxton about the idea of grand jury subpoenas, he said it was a smart idea because some of these individuals were people in positions of power, and this would be the most discreet way to get that information.
So if I'm understanding that conversation, then not only did you believe that was the most discreet way to obtain the information without alarming or frightening somebody, so did General Paxton, right?
Yes, sir.
Can we break now? Is that okay?
Members, we will stand at ease until 3:30, so a 25-minute break.
Wow. I'm trying to think about where to start. So when, sorry guys, you literally, this is like, it's like a bad movie. So when he doesn't get he keeps asking for the contract or the credentials. He gets sent one contract by Vassar. He signs it, but he never gets the signed contract until he ends up going to Nate Paul. He ends up meeting with Nate Paul and Michael Wynn, Nate Paul's attorney, and gets a copy of the contract that Paxton has signed.
Yeah.
I mean, that is just, it's, wow. Unbelievable.
I think we keep saying unbelievable. But is it enough for the senators, 21 senators, to convict?
I don't know. Todd?
I find it remarkable. The testimony was explosive at the end, especially during the direct. The way the story unfolded in the last few days of his relationship with the Attorney General there at the end of September, where he got the grand jury subpoenas, served some of them by email, 25 to 30 by email. According to his testimony, those were to the entities like Microsoft or some of these other larger corporations, and then the few that he decided to do in person were to the banks, according to him, and that it went from there that the next day, or maybe the couple days later, the 29th, which was kind of a very important day. They harped on September 29th quite a bit, where he was going to serve those subpoenas with Mr. Nguyen in person, and Mr. Nguyen insists on going with him. That was the first thing that we all kind of lost our collective breaths together. We go, wait a minute, what? And that just seems to make no sense. Again, this cross-pollination relationship between Nate Paul's personal attorney and this individual that's been hired as a quote-unquote special prosecutor by the Texas Attorney General's office, and they're out going to play sheriff, rogue, justice guy, serving subpoenas in person on banks from a private lawyer that's never done this before. I mean, the idea of it all is so comical, it's almost unbelievable that he's even, and that's where the most explosive part to me starts. They start to serve these subpoenas. Of course, our guy Brandon thinks, well, this didn't feel appropriate, didn't feel right.
Says, I felt a little pressure to say okay with regards to Michael Nguyen accompanying him to deliver subpoenas. He thought, yeah, that seems kind of weird.
Seems kind of
strange. You know, when you have the little thing in your brain that says, you know, the little birdie, the little angel the little angel on your shoulder that says, maybe it's not a good idea. The spidey sense. Maybe it was time to listen to the voice.
I made a note at that point when he said, I wasn't sure if this was appropriate, and I started to feel pressure from Mr. Nguyen on him riding with me or being a part of this service, that it's at that point it seemed like he finally realized I may be in over my head here. I'm out over my skis a little bit, and I don't really know how to deal with this. I'm dealing with maybe forces larger than me, motivations larger than me, plans that were put in place before I got involved, and I don't really know how to react or respond to it. I still don't understand why he didn't go seek some.
What if he'd called you? What would you have said?
I would have told him to probably stop what he's doing. We need to get to the bottom of what's going on here. I probably would have advised him that it's probably in his best interest to be very, very careful, tread very lightly with regards, because again, you'd start placing all the people in the pieces of the puzzle, and I'd say, this is not how things happen. This is not how it works. I know you've only been doing this for 5 years, but this is not normal course of business.
And he has never been a prosecutor.
No, and that's the way it doesn't pass that smell test.
I mean, and maybe if he had been a prosecutor, maybe if he'd spent a little time in a prosecutor's office, maybe he would have known that this was so outside the ordinary. I mean, maybe not, but I look, there's nothing about this, and I know a lot of lawyers, and I know lawyers that have not been in a prosecutor's office, and I think they would all agree this was not the norm. This is not the way you do things.
Well, he decided it's not the norm. But I think that what really caught me as well as that is when those law enforcement officers showed up at his house. And he's what's going on? You know? And then he calls Paxton. What's going on? And then Paxton tells him to go get an attorney.
I mean, the Attorney General of the state of Texas, according to Brandon Cammack, says don't talk to him without an attorney.
Well, and I guess that struck me as well. When the marshals show up at his office, why was Cammack's first reaction to call the AG? Why did he think that they were there to talk to him about his capacity with what he was doing for the Attorney General, as opposed to some other aspect of his life, whether it was one of his other cases or whether it was something going on in his personal life? Why was because did he know deep down what he was doing was probably in violation of the law, or there was some issues going on with what he was doing? His first reaction was he kept saying, I blew up Paxton. I kept calling him, kept texting him. I needed answers from him. What am I supposed to do? Well, what made him have the sense inside him to go, this has to deal with what I'm doing with. He'd only been in a relationship with Paxton for a month at this point.
Right.
But he had already started feeling uncomfortable. He knew something was not right.
If you have any common sense at all, you
well, I mean, that's a question whether he had any common sense at all.
Well, I still just see this attorney looking at this huge opportunity, and then also wondering, why shouldn't I trust the Attorney General. And he had had some type of a dealings with Wynn.
Right.
So, and it appears as if when he realized, well, when they took him to Starbucks and let him out and he was almost having to walk back, and realized, I'm not going to get paid. You know, it's.
I mean, the cease and desist letters, the bouncing back and forth between cease and desist, no, keep working, no, cease and desist, and then we're not going to pay you. I mean, we're not going to. The Attorney General says to him, "You're not going to get."
That was Brent Webster.
Well, twice, and
Yeah,
I think he asked Paxton. I think he said to Paxton directly, "Am I going to get paid?" And he just never got an answer. And then Webster, right in front of Paxton, says, "You're going to eat the 14,000. I've eaten 40.
Because I've eaten 40,000.
I've eaten 40." And he just takes it. I mean, that is a just unbelievable testimony. That the Attorney General is sitting there listening to this. This is the guy that he was his handpicked dude. That's the guy he wanted to go get, that he reached out to, brought in, talked to him 15 to 20 times by phone or text in a 25-day period, wanted progress, wanted to talk about what was going on, had him brought it. Every time he called, our guy jumped in the car, drove to Austin. Went to a meeting. He even said I had to do it. I would go for an hour. One time he went and Paxton was out on the porch. How about when he shows up over at Nate Paul's house and all three of them are over there? Okay. Sounds like I'm meeting with like the mafioso. He shows up and the whole family's there. It's like the head of the Sopranos is waiting for you.
And then was told that his contract wasn't even legal.
I don't know if they said legal. They said that, hold on, let me go. I got to find that part of my notes. Webster said, he said, your contract is not any good anymore.
Well, what's the difference? Well, did he say anymore?
Anymore.
He said anymore.
So what's the difference?
Stop working. Okay, well then pay me for what I've done to this point.
What's the difference?
But again, and if the contract was good to begin with, why don't you pay? Why don't you pay? It doesn't make any sense.
If it was
I
good,
still heard
there's so many unanswered questions.
Well, okay. I'm almost going through my notes kind of chronological right now because there's so much. I hate to miss anything. So, in addition to sending out all these subpoenas and going on these visits to the banks, and by the way, the visits to the banks are recorded. He recorded these things. So there's a husband of a court deputy, and there's an inference from Michael Wynn to Brandon Cammack that this court deputy has died under nefarious circumstances. And I'm thinking to myself, is Vince Foster with him? Again, at what point, Brandon, do you say to yourself,
Well, he did.
I mean, who did they think had her? Did they think that the all these law enforcement officials got together and said we're going to kill the court deputy?
Well,
I mean, it's just
he did. It just took him too long. Too many things happened.
Yeah,
and then especially when they told him he wouldn't be paid.
Yeah, I just, it's just stunning. So he says on, October 1st, 2020, he gets this first of the cease and desist letters, and he starts calling Paxton, and he blows his phone up, and that's when he tells him to get the lawyer. When the U.S. Marshals show up, what y'all think about them? One of the last times, I guess it's the last time he's with them, and he goes to this. I mean, they try to leave him at the Starbucks.
If he had not said, "Hey, wait a minute," of course they were through with him. See, that emphasis, we're done with you.
So
you need
explain to me
on.
this too. I don't understand. So at the beginning of the relationship, and really throughout the duration or the great majority of the relationship, it was all Paxton, and it was all Nate Paul, and it was all Nate Paul's lawyer dealing with Brandon the entire time. It was just those three having all the communication,
except for Vassar sending the contract over,
right?
And the meeting that he has with Mateer early on, when he first comes to the office to meet the first time,
right,
in late August. He meets with Paxton, and then he meets with Mateer for like 15, 20 minutes. And that's pretty much it.
And then now at the very end, the back end, when Webster gets involved, and now he seems to be running the show. He's like, we're telling you, you're eating the 14 grand, your cease and desist is now in play. And that, he's running the show at the meeting at the Starbucks. And you also heard Brandon say, it was Paxton there, it was Webster, and then a couple guys I didn't know. So now we got some new faces. So it's almost like Paxton went back to official AG role and kind of what I'm ready to wipe my hands of this secret life. No more Signal app, no more burner phone. We're going to pretend that didn't happen. You eat that money, the contract, all this stuff. Just go ahead and scoot out of my life, and we're gonna move on from you. Goodbye.
But hadn't by then he had fired the rest of his team? See, Webster came in.
I don't know that he fired all of them. That's going to happen. Well, they had gone. They go to the FBI. I think it's the 30th. Because they go to Mateer and Penley and Banger and the others go. They go to the FBI. I think it's the 30th of September, and then over the course of that next 30 to 60 days, they're going to either be fired, resign. There's going to be a combination of things that's going to occur to various ones of them. But I would like to know who those other two people are. Are they, okay, so right now we have 6 attorneys from the Attorney General. Okay, first of all, Brent Webster replaces Mateer. He's the one that comes in and takes over for Mateer. But right now we have 6 attorneys who are on temporary leave from the AG's office representing, they're on the defense team, involved in representing Ken Paxton.
Right.
One of them, we've seen quite a bit of. His name is Chris Hilton. He's the kind of larger, bald man with the beard. Now, he hasn't spoken. You haven't really heard. There might have been one time when he said something out loud, but for the most part, we haven't actually heard him. But, I mean, and again, I just would love to know who those other people are at that Starbucks meeting. Who are these people that accompany along? And are some of those people now who have taken temporary leave to help defend Ken Paxton? We don't know the answer to that, but it'd be nice to know.
But they're obviously people who are now on his team. They're doing the things that he wants to get done, and he shows up at Starbucks with them. But not to pay the guy. But if you remember, Missy testified that the money wasn't there. If he went through the process he was talking about going through, there was no money. He couldn't pay it.
It's interesting. So one of the things that came out in the testimony, this was during when Hardin was talking to him, is that Wynn never clues Cammack in that, hey, you're about to send subpoenas off to opposing counsels. You're about to send Ray Chester, who's the opposing counsel in the Mitty case, all these opposing counsels. And he seemed kind of genuinely like, ooh, I wish they'd have told me that.
I wouldn't have done it, yeah.
Well, but now that's when I get to why he didn't do any kind of research. Now I do get, I can understand the wide-eyed, I'm going to work, but when do you start doing your own research? When do you start doing what you're supposed to be doing as
critical thinking?
Yes. Now that raises questions.
He's just extremely inexperienced and unsophisticated attorney, and he started off with, I believe, the right intentions. He was absolutely flattered that he was being selected for this position, and I believe he recognized after a couple weeks involved in this, as soon as the subpoenas started to get issued, the day that they went in the car ride together to serve those subpoenas, and the other alarm that starts to go off is, how come every time I ask for any credentials, they won't give them to me? If I'm working as a special prosecutor, how come nobody will acknowledge that that's what I am? Why can't I get a badge? Why can't I get some piece of paper that when I go to serve these things, it shows that that's who I am? And the symbolism to me at the very end of the car pulling away from the Starbucks and refusing to even give him a ride is about as strong as it gets.
They gave him a ride
there, but they wouldn't give him a ride back. I believe he said they left him there in the street.
Well, they started to.
They started to.
And then he said, wait a minute. I don't have a car. I don't have a way back.
And they get you find your own ride back.
They have.
I mean, it's just wild stuff. Do you think that, Todd, Cogdell's getting anywhere?
I don't really see where he's going. I mean, he did start off by trying to play there's a card out there that we as defense lawyers play a lot, and that's trying to track the language of the indictment and, really stick to the verbiage of, the state hasn't proven intent. They haven't proved recklessly, intentionally, knowingly, or recklessly, and there's been no evidence that's been presented to show bodily injury or, whatever the term is in there in the indictment that hasn't been proven. So really, really trying to go with a strict interpretation of what we call the four corners of the indictment, that, no matter what you may feel as a juror about the person or whatever kind of emotion might be dredged up about you may not like him, you may think he's a bad person, you may think he's not a good father or a good husband, but that doesn't mean that the state of Texas has proven their case beyond a reasonable doubt according to the language in the indictment. What I just saw him doing there with the articles of impeachment was trying to go through those three different things that he said. He was going at 3 strikes and we'll try for strike 3 here. He was tracking the language of that particular article that they're using this witness for to say they haven't met their burden at all. You may have gone through a whole day's worth of testimony, but you never got to any of this stuff that's in the article of impeachment. So I thought that was a decent strategy for at least argument purposes. But the rest of his time has been spent on simply repeating the same question and answers that they've already gone over. Just to reiterate and basically say, now, didn't you say, X or Y? Yeah, that's what I told the prosecutor. That's exactly what I said. And then, where are we going with that? So that part I'm not real crazy about.
So I'm pulling up the articles of impeachment. So obviously there are articles that are detailed, like the one you're referring to is Article 5 that talks about the hiring of Brandon Cammack. That's that one. But there are. I'm getting down into sort of the catch-all one.
Well, again, so the seasoned defense lawyer is only going to ask questions that's going to benefit him on cross-examination. So he found that one, Article 5, that he can track the language on and ask the questions of the witness that benefits his strategy, and he'll stay away from the one that doesn't.
Right. So Article 19. Article 19 is unfitness for office, and it says Paxton engaged in private and public misconduct described in the articles that indicate his unfitness for office. The resolution says these are summations of them. Article 20 is abuse of public trust. Paxton subverted the lawful operation of Texas government by using, misusing, or failing to use his official powers and obstructed the fair and impartial administration of justice, bringing the Attorney General's office into scandal and disrepute, which harmed the public's confidence in the state's government. So that gets away from, let's
it's much more vague,
right?
So,
there's several articles that are more
catch-all
art. In other words, okay, if we're outside the 4 quarters of the indictment,
that's right.
Here's our conspiracy one.
We just don't like him anymore. We just don't like what he's done. We don't like what he stands for. We don't like the way he conducts his business. We don't like this clandestine, secretive society that he's created with seemingly every aspect of the office and his personal life and all these different things that he's doing with secret burner phones and secret accounts and, secret relationships and outside counsel. Why is his own office not investigating this? There was no reason to assign a special prosecutor.
Because they don't want to do it.
Well, they work for him. There are hundreds, if not thousands, of lawyers that work for the Attorney General's office. He is the Attorney General. He is the boss. When he says, here's what we're doing, go, right? This is who we're investigating. This is what we're doing. It's not up to his employees to say, no, boss, we're not doing that. Yeah, okay, you don't want to do it, you're fired. Goodbye.
I think that's pretty much what happened.
Well, I mean,
with
but you don't go out and hire a special prosecutor unless there's a conflict within the office.
Well, right, and there is.
And you can't tell me that every single prosecutor in his office refused to do what he said. The whole office said, no, we're not going to go investigate this.
He seems to have kept a lot of his requests to his deputies, the people that were right up there on the 8th floor, the Penleys,
right,
and David Maxwell and those people. And, Penley says, well, we were trying to get documents from Michael Wynn to back up his claims. And then, of course, that's being framed a different way,
right,
as, the defense is trying to say, well, that Penley was still trying to get documents after he'd been told to cease and desist. I mean, I don't know.
He didn't get the documents. But
no.
I also think that the AG office, it does have numerous attorneys, but at this point, Paxton is only interested in getting the work that he wants done, and he's not interested in telling every attorney, okay, and every attorney to know what I'm trying to do. So he just went out and tapped on someone that he wanted to do, but it appears as if Wynn and Paxton are partners in this whatever you want. We can't say these bad actions. That they're in partnership.
It's certainly. So I mean, well, yeah. I mean, they're at meetings together. I mean, it's. I can't even. I mean, Todd, can you even think of a parallel? It's just.
It just.
Who would take the risk?
I'm trying to come up with the right term to try to explain how awkward and unprecedented the relationship is, and bringing in this inexperienced, young, out of his element, out of his league individual that has no connection at all to any of this to carry the water, to do the dirty work, and then just dump him and not pay him. I mean, that just really, really stinks. And then to have the gall during cross,
pay the man for his
to have the gall during cross saying, well, it really wasn't the money didn't really matter to you, did it? It was the prestige of working for the AG. What do you mean the money? When does $14,000 mean nothing to anybody? $14,000 is $14,000. Let me tell you what, he spent time for those 25 or 30 or 35 days that he was working on it that he was not getting other business.
Well, he spent money on a hotel.
Yeah,
he made multiple trips to Austin.
Not working with other clients, not generating other business. I mean, this guy's been a lawyer for 5 years. He just opened his own firm after leaving his dad. It's not like he's got an established practice. Don't sneeze at $14,000 like he's some multimillionaire.
And just keep in mind, this attorney general should be representing all aspects of the citizens of Texas. If he'll do this to someone who he hired to do his work, just think about what he'd do to me. I mean, and the senators must weigh this. Do we keep this kind of action in office? And as you said, they were not trying to discredit what he said and what he did. They were trying to knock holes and come up with, okay, but is this impeachable? Is what he did to this guy, is it impeachable? Yeah. But if you just imagine that if Paxton, if your attorney general, and then he won't even listen to his top attorneys, that this is potentially criminal, do you keep this attorney general in office? Well, it boils down to it. And it's going to take looking at polls or the potential of being primaried. They're going to have to look within.
Right.
How can you keep a person of this caliber with this kind of character in office?
Well, now, I'm not going to answer that question.
Well, I didn't either.
That's for them to figure
out.
I
asked the question.
You asked the question.
That's right. That's for
and
them
I'm
to
not
figure
a
out.
senator.
That's right.
I'm not a senator.
Well, and whether, no matter where you fall on what you think should or should not happen to Ken Paxton, you cannot pretend, and I will not pretend, that this conduct is normal.
Well,
you cannot.
So you keep using that word normal, which is fine.
I mean, I'm basing that on years and years, and Todd's been around a long time. We've been around in the criminal justice system a long time, and I think when you've been around in the criminal justice system, you can speak to what is normal.
Yeah,
and this is not normal.
And I get that, but see, is it acceptable?
Well, it's also not acceptable.
See, that's
also
what
not, it's not normal. It's not acceptable.
Yeah.
Now, does it right? But it's not for me to say one way or the other what should happen here. But it is not normal, and it is not acceptable. And I don't think we have to pretend that it is normal or acceptable, because we expect better, and we should expect better of our public officials. And that's
we should expect better of our citizens. I mean, just of being a decent human being, of not paying somebody the fair wage that you contracted. I mean, you had a man, you found a man that had no connection to you and asked him to perform a service, signed a contract, signed your name to it. You are the head law enforcement official of the entire state of Texas. signed your name to a contract, and 5 days later effectively said, screw off, pal, I'm not paying you a dime for everything you just did. How in the world is that right?
And didn't Webster say I lost 40,000?
Webster said, basically told him that he said, well, you're just going to have to eat that.
But why?
That invoice.
Why?
He said, I've eaten 40K.
But why though? What's the justification? What if this guy did everything he was asked to do, and he was doing his job exactly as the defense lawyer is asking him? He didn't do anything wrong. Why does he not get to get paid for his service?
Well, and for the people out here in the chat who are pro Paxton, I'd like, what's the explanation? Why is Brandon Cammack not paid?
That's right.
If everything is
everything
on the
else,
up
just
and up,
why should he not get paid for his service?
If it's on the up and up, why is he not paid? Because if it's on the up and up, if everything is done the way it's supposed to be, then Brandon Cammack gets paid.
It's called theft of service, and the person that was responsible for paying him should be prosecuted as a felon, because that's $14,000 that he provided a service that was not paid for. And to me, the person that signed that contract,
that would be
who
Ken
is your
Paxton.
Attorney General of Texas, committed another felony by not paying him.
So should he? Is there what's the statute of limitations on that?
I don't know.
Well, that was from 3 years ago. I mean, probably three years.
Probably 3 years. So
which is coming up here in a couple days. Yeah.
Well, he probably did decide I'd better eat it, because why would you go up against a man so powerful? He isn't just the Attorney General. He's a very he was, and he probably still is among his rank and file but he's powerful.
He is powerful, and it's pretty clear in watching Brandon Cammack that he never, in his wildest dreams, thought,
here's where I'd be.
Here's where I'd be.
He said,
and this is not how you really want to get famous as an attorney.
Yeah.
It's not.
He said it.
I mean, I.
So is anybody in your chat giving justifications to why Brandon shouldn't have been paid?
Somebody's claiming that the controller refused to pay him, but I mean, again, he's still the AG.
They denied his payment. They said, you don't get paid. The first assistant said to his face, eat it.
Yeah, why is he not getting paid? I mean, I think that's,
They didn't tell him to go to the controller. They said, eat it.
They sure did. And I don't remember, well, I'm not going to say I've heard everything. I just don't remember anybody saying that the comptrollers refused to pay him.
No.
Well, yeah, I mean, there has been a lot of testimony. But the bottom line is, Ken Paxton, why didn't he? I mean, again, make sure the guy gets paid, And
well, I heard too that it was not done properly, that he could not be paid.
That's what Missy Carey said. Missy Carey said that you had to, if you were going to do this, then you had to have a waiver, an express waiver to say why you were going around.
I'm sure
the procedure.
Of course, it wasn't done properly. I mean, the Attorney General doesn't execute his own contracts. He doesn't email the contract back and forth with the special prosecutor. That's done all internally.
Are you saying that contracts are not normally delivered by the
sitting Attorney General
no,
to
no.
this?
But no, the contract is. Remember, he comes to the meeting with, and I forget what day it was. It would have been late September. He comes to the meeting, and he gets the contract that has been signed by Paxton in a meeting with Nate Paul and Michael Wynn.
And I know.
Now tell me that's the normal way things operate.
I thought Paxton was there. That was the day he was. No, that was a different day. Yeah, when he goes and shows up at the house, there's the signed contract at the house.
Now, Paxton's not there.
Not there. Or at Nate Paul's office, maybe.
It was at Nate Paul's office.
And look at my notes.
But it was the same day that he sent it to Wynn and without his signature.
Right.
And then he shows up at the office later and has Paxton's signature on it. And then a few days later, he's called back to Austin, and he meets all three of them are there.
It's just
way too tangled a web.
Yeah.
But you know what? And as I say, there have been certain days I missed that testimony. But
okay,
who's?
Patrick's back. Let's go back and listen.
You may resume, Mr. Cogdell.
Mr. Cammack, by my notes, I'm about halfway done, but let me see if I can speed this up and get you.
Mr. Cognell, would you raise your mic up? There you go.
Yes, sir.
We had you talk a little bit, Mr. Cammack, about the grand jury subpoenas and the reason for that. At some point, I think I heard you discuss with my colleague, Mr. Hardin, that Paxton made a statement to the effect that he was being critical of Mr. Penley and Mr. Maxwell because they won't do any work. Do I recall that correctly?
I don't remember the exact question that I was asked by Mr. Hardin.
Do you remember back during this time, that is back in September of 2020, that happening, that is Mr. Paxton being critical of Mr. Penley and Mr. Maxwell, believing that or stating that they didn't do any work?
Wasn't critical in the sense that like he gave me any detail about what they were or weren't doing. He just said that he couldn't get the people at his office to do what he was asking them to do.
Fair enough. Now, there are different ways of conducting an investigation. You'd agree with me?
Yes, sir.
There are all kinds of different tools that law enforcement can use, TCIC, NCIC, every initial in the book sort of stuff, right?
Yes, sir.
And even lay people can do computer searches, Google searches, Intellius, Truthfinder, LexisNexis, all that sort of stuff, right?
Yes, sir.
Are you literate on LexisNexis, or were you at the time?
Yes, but more proficient in Westlaw.
Okay. And Pacer, do you do much work on Pacer?
No, sir, but I'm familiar with it.
And Pacer is public access to computer electronic records, something like that?
I believe so.
Okay. May I approach, Your Honor?
Yes, you may. And the witness, if you can speak up, Mr. Cammack.
Yes, Judge.
Make sure all of our senators can hear you.
Yes, sir.
Acoustics, not your fault. Acoustics aren't the best. And some of our hearing collectively is not the best either. So. Hold on, get back to your microphone. There you go.
Yes, sir. I'm showing you what's marked as AG Exhibit 1047. And I don't know that you've ever seen this, but I'm going to see if I can walk you through it. I would offer AG 1047, which is a docket sheet on the Contigo matter.
Any objection, Mr. Hardin? Sure.
If I may, please.
Take your time.
No objection. No objection.
No objection. Admit to evidence. AG Exhibit 1047.
All right, Eric, if you could kind of blow up the top. And again, I'm just using you as my ventriloquist right now because I don't think you've ever seen this, or tell me if you have. Have you ever seen this before?
No, sir.
Eric, blow up the top of it, which says, obviously, the style of the case, which is Contigo Information Management. Are you familiar with that name, Contigo Information Management?
Yes, sir.
And that is one of the entities, is it not, Mr. Cammack, that Mr. Nate Paul was complaining that an illegal search may have potentially occurred at that place right there, Contigo, right?
Yes, sir.
Now, if you will go to the second page, Eric, of 1047. Let me go back to the first page, my bad. And on the first page, it shows, does it not, that Judge Mark Lane is the judge in this case, right? Upper left-hand corner, Mr. Cammack?
Yes, sir.
That's obviously public information. and that Mr. Gupta with the U.S. Attorney's Office is representing the government, right?
Yes, sir.
So the whole world can see that based on anybody that has a Pacer account has access to that sort of information, right? Now, if you could go to the second page, Eric, and what that shows, give us the top half of that page. And what we see, do we not, Mr. Cammack, is there's a motion for leave to disclose sealed search warrant that was filed on September 5th, right?
Yes, sir.
And an order granting that motion for leave to disclose a sealed search warrant, right?
Yes, sir.
So that would allow, and that was granted on the 5th, and then it is closed again on the 17th, where someone files an order, someone files a motion to extend the sealing, right?
Yes, sir.
But for those, whatever that is, 12 days, that search warrant would have been the warrant, not the probable cause affidavit. And they probably understand by now, but I know you do. There's a difference between the search warrant and the search warrant affidavit, right?
That's right.
But the search warrant would have been visible via Pacer for those 12 days back in September. Again, anybody with a Pacer account could have logged in and looked at that at least during those 12 days. Agree with me?
It was not sealed during those 12 days.
Fair enough. Now, when you were working on this matter, did you ever see, Mr. Cammack, any evidence that Mr. Penley or Mr. Maxwell had done anything in terms of investigating the same complaints that you were investigating? Meaning, did you see any reports, any memoranda, any conclusion, anything?
No, sir.
It is possible, is it not? Let's say that I want to investigate whether or not a given prosecutor might have at least been accused in a pleading of doing something improper. You or I can get on Pacer and enter that person's name and pull up every case that lawyer's ever been assigned to, right?
Yes, sir.
And they can do the same to us as well, right?
That's correct.
But if we wanted to investigate whether or not a given prosecutor was doing something, we could look at their history, or at least their history that's visible on Pacer, right?
That's right.
Same with the judge, correct?
It should be public record.
Now, let me be Captain Obvious because it's a cape I wear a lot. Every single search warrant that is a bad search warrant was signed by a judge somewhere, wasn't it?
Theoretically speaking, it.
Okay.
Yes.
Well, I guess my point is, if someone is arguing, well, a judge signed it, therefore it must be good. Well, if it's a search warrant that was executed, chances are a judge signed it. That doesn't necessarily make it a good search warrant. It's just one more search warrant that one more judge signed. Agree with me?
I agree with that.
I think we heard you testify that Mr. Wynn, during, I guess, the latter part of September, stated that Penley had reached out to him out of the clear blue and asked for documents. You recall that?
Yes, sir. That's what I was told.
Do you know when Mr. Cammack ballpark that was?
It would have been, I believe, sometime in the fourth week of September 2020.
Okay, so if you were hired on September 4th, you had been working on this case for several weeks, or this investigation for several weeks by the time you heard that. Agree with me?
Sir, approximately 3 weeks.
Okay. Now, let's get into the time. Mr. Harden had you walk through sort of the frequency of contact that you had with Mr. Paxton during this, and it was about a month. That's probably the easiest way to describe it, is about 30 days, right?
Yes, sir.
And Mr. Harden had you describe your contacts with
Agent Paxton, and I think you said, I don't know, 15 to 20 times, something like that, right?
Yes, I did say that.
And during that month or so period, you saw him a grand total of how many times face to face? 2 or 3?
Well, I can tell you the days. So the 26th was
Okay.
one time. September 4th was the second time.
Right.
Then there was the time at the end of September at Nate Paul's house.
That's 3.
And then there was another time when I drove out to meet with him and Brent Webster.
That's 4.
And then there was another time when we met at the Starbucks.
That's 5, right?
It's 5 times.
So let's use as a demarcation, artificial or not, I'm going to call it when the stuff hit the fan, and that is September 30th or October 1st, okay?
Oh, yes, sir.
So before the stuff hit the fan, and we're going to get to there, you had seen him a grand total of 3 times. That is Mr. Paxton, right?
2 times.
2 times, okay. Now, you said, I think in reference to a question by Mr. Harden, that you had talked to him 7 to 10 times on the phone, something like that?
Yes, sir.
And there were some occasional texts as well, right?
Yes, sir.
Would you agree with me, generally speaking, Mr. Cammack, that those phone calls are generally short, to the point calls?
Yes, sir.
Do any of them stand out in your memory for one reason or another? That's not meant to be a trick question. That's just an open-ended question.
I'm just thinking about what stands out in my mind about the conversations.
Okay. Let me keep going, and if it comes to you, we'll come back to it.
Okay.
Fair? Would you agree with me, Mr. Cammack, that Mr. Paxton has, General Paxton, whatever we want to call him, has a, let's say, unique style of communication? I'm sure it's not exclusive to him, but what I mean by that is when he wants you, he reaches out to you and you're generally accessible, right?
Yes, sir.
But the reverse isn't always true. When you need him, it ain't always, he doesn't pick up the phone as quickly as you pick up the phone.
I would agree with that.
Okay. And you had 3 or 4 of these occasions where you were saying, look, Mr. Paxton, or look, General Paxton, I need an email address and I need some identification, or I need a badge or something, right?
Yes, sir.
And the response that you get is more or less, yeah, I'm working on it, yeah, right?
Yeah, I mean, every time that was kind of the
Fair
response
enough.
that I got.
And you would also agree with me that just about every time you're in the presence of General Paxton, he's either on the phone some of the time or on the phone all of the time. Is that fair?
The first 2 times that I met with him, it was not on the phone.
And those were the interview, right?
Interview, and then the second time that I went there.
Yes, sir.
And then after that, he was on the phone quite a bit.
In your mind, I think, not unlike perhaps others, he's kind of notorious for being on the phone when you need the man's attention. That's just how he rolls. Agree with me?
I didn't know him before all this.
I'm just talking about your experience with him.
Just figure he was busy.
And he is, as far as you know, right? Now, let's get to, speaking of busy, let's get to that point in time, Mr. Cammack, when you were asking for a signed contract and you told Michael Wynn you hadn't gotten a signed contract, and I think that was the night before, and then you roll into Mr. Paul's office the next morning, leaving at 5 or thereabouts, and lo and behold, there is a signed contract on the desk or at Nate Paul's office, right?
Yes, sir.
Do you know whether or not, Mr. Cammack, that on that date that Mr. Paxton was out of town? You know one way or the other if he was?
No, sir.
Okay. Would you agree with me that based upon your observations of the man, he traveled frequently? Agreed?
There was at least one other time, that, yes, sir, that he said he was traveling.
Okay, so let's jump to the second, and again, I'm going to be quick running through these, but we've talked generally speaking about the first referral that you received from the Travis County DA's office, right? And that is the complaint about the search warrant.
Yes, sir.
Not too long after you're involved, you get this second complaint, right?
Yes, sir.
And that complaint is referred to you directly. It is mailed to your office, right? Somebody find that for me, a copy of it, the second complaint.
I believe it was emailed to me from Mr. Clemmer.
Okay, whether it was emailed or mailed, my mistake.
Yes, sir.
It was sent to you directly. Agree with me?
Yes, sir.
And if someone were to come in here and state that Travis County DA's office had no idea who you were or what you were doing and you were just some sort of ghost out there in space, you would disagree with that, would you not?
That would be a falsehood.
And in fact, Mr. Clemmer knew exactly who you were and where to find you, right?
Yes, sir.
And can you estimate for us, Mr. Cammack, how many touches, for lack of a better description, how many touches you had with employees of the Travis County DA's office? And when I say touches, I mean interfaces, emails, phone calls, personal visits. How many touches are we talking about?
Well, and it's no disrespect to the folks over there. I just don't remember everyone's name.
Of course not. I'm not giving you that pop quiz. I'm just asking to estimate it.
Yeah, so I spoke with one individual who referred me to Don Clemmer, and then I think there was another woman named Amy Meredith, maybe.
Okay.
And then I got referred to a woman named Bailey.
So that now we're up to 4, right?
I think we're at 4, and then from there were multiple
repeat visits.
Well, just back and forth on an email exchange about the subpoenas, and then 5 or 6 times there, like with Mrs. Molnar, and then I got that other referral from Mr. Clemmer directly.
So if we are counting each subpoena as a touch, we've got 35, 40 subpoenas?
Well, I sent them on the application, just multiple per, just sent them out. There were several emails to their office.
I'm interrupting you. I'm sorry. I apologize. But there were several tranches of subpoenas sent to the Travis County DA's office.
Yes, sir. I agree with that.
And there were several people you communicated with, right?
Yes, sir.
Some were staff and some were lawyers, right?
Yes, sir.
And at least in your mind, Mr. Cammack, they were well aware of who you were and what you were doing, right?
Yes, sir.
And you certainly never tried to hide that fact from anybody. When you were working with the Travis County DA's office, you told them who you were, you told them your job description, you told them what you need. It's not like you were hiding, right?
I was not hiding.
The second complaint is different, Mr. Cammack, in kind, is it not, from the first complaint? Meaning, the first complaint is, may I approach, Your Honor? And just to satisfy, of the second complaint, correct?
Yes, sir. That's the second referral.
So again,
I'm sorry, Mr. Cammack, I really need for you to speak louder when you're answering, because I know.
Yes, Judge, that's the second referral.
and again, like the point I made before you saw the document, although I don't think there was a dispute about it, that was sent to you directly with your name on it, with your address on it. Clearly, they know who you are, right?
Yes, sir.
Okay. Now, the first complaint, again, focused on the potential illegality of the search warrants. The second complaint focused on a alleged fraud concerning people trying to steal my words, not the complaint word, Nate Paul's property too cheaply, right?
Yes, sir.
And I believe, correct me if I'm wrong, but you utilized the resources of the Travis County DA's office to issue search warrants, or I'm sorry, grand jury subpoenas for the first complaint, correct?
Yes, sir.
And you did the same thing with the second complaint, meaning part of the thing that you did to investigate it was send out grand jury subpoenas to try to obtain information, correct?
Yes, sir.
Now, I think I heard you say, Mr. Cammack, correct me if I'm wrong, that you were not keeping General Paxton apprised of the names of the individuals that you had issued the grand jury subpoenas before, right?
I never spoke with him about like who specifically I was issuing subpoenas for, but that's not to say that I don't remember if I had forwarded an email list or something like that.
Fair enough. It's possible that you sent him on one or more occasions a list of folks that, or some sort of detail on names, right?
That's possible.
Not certain one way or the other if it happened, but it's certainly possible.
As I'm sitting here right now, I don't recall that.
Fair enough. But you didn't in any conversation, as far as you can recall, Mr. Cammack, get so granular with General Paxton about the names of the people that were being subpoenaed that you said, well, Joe Smith on this day, Bob Hunt on that day, Travis Smith on the other. That didn't happen, right?
No, sir.
And I assume it is a safe bet to say that if you sent General Paxton an email containing a list with names on it, you don't know one way or the other whether or not he opened that email and read through it and assimilated or understood what was in it or not. Agree with me?
I'm sorry. Could you just rephrase that one for me?
That's a $500 question. I don't know why I ask it that way. You don't know if he ever opened up any email you sent to him and read it or not, right?
That's right. I don't know.
Okay. Now, in the Thank you. In the investigation of the second complaint, did you think your marching orders from General Paxton had changed? Meaning, if I recall your testimony correctly, Mr. Cammack, in the first referral, he told you to go get the truth or find out the truth or whatever, right? I assume you were operating under the same belief system that General Paxton wanted you to do the same thing in the second complaint, correct?
That was my belief and my understanding.
And at any point, Mr. Cammack, that you were dealing with Ken Paxton, did he ever ask you to misrepresent anything?
No.
Did he ever ask you to, for lack of a better description, lie, cheat, or steal?
To lie, cheat, or steal?
Yes, sir.
No, sir.
And I'm including that in a broad sense, not in the literal sense. But also in the broad sense, not the literal sense, Mr. Cammack, never ask you to hide, secrete, destroy, never ask you to hide any record, conceal anything you did, dispose of anything that you obtained. There was never any suggestion of that, I don't think. Was there?
No, sir.
Now, there was the time when the stuff hit the fan, right?
Yes, sir.
And that was October 1st?
I believe it was October 1st, whatever day that I got a cease and desist letter from Mr. Penley.
Okay. And again, whether it's the 1st or the 2nd, 30th, whatever, you get the cease and desist letter. And what was your reaction when you got that? What was your thought?
I mean, I was shocked. I was confused and felt like a rug been pulled out from under me. And
I heard shocked and confused, and then I didn't hear the last thing that you said.
I just felt like the rug had been pulled out from under me.
Okay.
It just seemed like it came out of nowhere.
And it really did come out of nowhere, if I'm understanding your story, right?
It did come out of nowhere. I had never spoken with Mr. Penley over the course of those 3.5, 4 weeks.
And after Mr. Penley sent you that letter, Mr. Mateer sent you another letter, right?
That's correct.
And this is and he's basically saying, this is unauthorized, you're performing illegal activity, you're whatever. This is the very same Jeff Mateer whose office you sat in interviewing for the job that you took, right?
That's correct.
If I'm recalling it correctly, Mr. Cammack, when you got the first letter from the Penley letter, you responded very professionally, very appropriately, very succinctly. He sends you this cease and desist letter, and what do you reply back?
I think I told him that I would just stand down and something along those lines.
Unlike some other people that you might have heard of, you didn't get volcanic on him. You didn't pick up the phone and slur a bunch of invectives or worse at him, right?
No, that would have been unprofessional.
And to be fair to you, Mr. Cammack, all you were trying to do was do a job, do it well, do it professionally, right?
Yes, sir.
Then it gets even worse because the press starts blowing up, right?
Yes, sir.
And speaking for you, you are a 5-year lawyer, and you have authors, writers, people in the press that you've never spoken to, that you've never communicated with, that you've never heard of, just saying horrible things about you, right?
There were a lot of articles written, and I read a couple of them and then chose just to put that out of my scope of view, just move on with my life.
That was probably a wise decision, but it went into really needless detail about disagreements that you had with your family, and it just blowing everything out of proportion. And it was a nightmare for you, simply put, was it not?
It had nothing to do with anything involved in this. It was just a bunch of trash. I'm sorry.
That's all right. And it was, if you understand the timeline, or I guess if I understand the timeline, I'm asking you if you understand it the same way, Mr. Cammack, that by this point, the so-called whistleblowers had gone to the FBI, and that's when all this volcanic eruption occurred, right?
I'm sorry, could you?
Sure. When the negative press started coming out, it was after the time, at least insofar as what the articles were claiming, that several individuals that used to be with the Attorney General's office had gone and made a complaint with the FBI, or made the so-called whistleblower complaint. Is that consistent with your memory?
I remember reading, I think, about that.
And after this eruption, that is when you drive to Nate Paul's house, right?
Yes, sir.
And I mean, it's just a surreal time, fairly put, for you and for everybody else, right?
Yes, sir.
You go to his house. You had never been to his house before. You're hoping to resolve whatever issues are outstanding. Oh, by the way, you would like to get paid for your work, right?
Right.
And everybody's kind of standing around shell-shocked. When I say everybody, I mean you, Mr. Wynn, your friend or whatever, Mr.
Mr. Paul and Mr. Paxton, right?
That's who was at that meeting.
And I mean, again, without engaging in a hyperbole, it's kind of like everybody's sitting around with PTSD, just like, what the hell was that, right?
Right.
You were asked to continue the good fight, keep working, and in your own mind you say, no, I'm done with that.
No,
right?
That's right, I was done.
Okay. And then you have another occasion that you detailed for Mr. Hardin where thank you, Mr. Webster and Mr. Paxton asked you to come to Austin. You come to Austin, and it's just as weird as as the time before. You don't go into the AG's office. You go over to Starbucks. Brent Webster says, 15 grand ain't nothing. I had to eat 40 grand. And you're thinking, that's not going to put, post toasties in my bowl here. I don't really care. My word's not yours, right?
That happened.
Okay. And to this day, you've never been paid anything, right?
$0.
Okay. And the reward that you have gotten is not really a good reward, right?
I haven't received any benefit from any of this.
Let me apologize for that situation.
Thank you.
That should have never happened.
Thanks.
Should have never happened. All that having been said, Mr. Cammack, it is still true, is it not, that what Ken Paxton asked you to do, find the truth.
That's what he told me when we first met. He just wanted to find out the truth about this first referral.
And that's what you were trying to do.
Yes, sir, that's correct.
I'll pass the witness.
Mr. Hardin, or redirect?
No, Your Honor.
Or both of you
You can be excused. Good
finished
luck,
with the
Mr.
witness?
Thank you.
Maybe. Thank you, sir.